Court officer? Court officer?
ಹೇಳಿ ಸರ್.
Sitting late, huh?
ಯಾಕೆ ಸರ್? ಏನಿಲ್ಲ, ನಮ್ಗೇನ್ ಆತರ ಇನ್ಫಾರ್ಮೇಶನ್ ಏನಿಲ್ಲ.
ಹೌದಾ? ಯಾಕೆ ಕೋರ್ಟಲ್ಲಿ ಯಾರು ಜನವೇ ಕಾಣ್ತಾ ಇಲ್ವಲ್ಲ?
ಮಳೆ ಬರ್ತಿದ್ಯಲ್ಲ, ಬರ್ತಾರೆ ಅನ್ಸುತ್ತೆ.
Okay. Okay, thank you, madam.
ಥ್ಯಾಂಕ್ ಯು.
Vote of sir. Vote of sir.
ಸರ್ ಹೇಳಿ ಸರ್ ಹೇಳಿ
ನಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಒಂದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮೂವ್ ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ ಮೇಡಮ್.
ಸರ್ ಪೇಜ್ ವೈಸ್ ಕಾಲ್ ಔಟ್ ಆಗುತ್ತೆ ಅವಾಗ ಮೆನ್ಷನ್ ಮಾಡಿ.
ಓಕೆ.
ಟಿಪಿಸಿ ಸಿಕ್ತು. ನಂದೇ ಕೊಟ್ಟಿದ್ದೀನಿ. Is it?
96 to 102. No, 102, my lord. 102 and
ಯಾರ್ದು? ವಿಜಯ್ ಕುಮಾರ್ ಅವ್ರದ? ವಿಜಯ್ ಕುಮಾರ್ ಅವರು, ಓ ಮಹೇಶ್ ಅವರು. ಬೆಳಿಗ್ಗೆ ಎದ್ದ ತಕ್ಷಣ ಅವ್ರ ಪ್ರೆಸೆನ್ಸ್ ಅನ್ನ ದೇ ಮೇಕ್ ಇಟ್ ನೋಟಿಸಬಲ್ ಟು ಅಸ್. ಎಸ್. Have you served the copy on the other side? Have you got to say anything in that? ಏನಿಲ್ವಲ್ಲ, ಬರೀ ರೂಲ್ಸ್ ಕೊಡೋದಿತ್ತು. You want to argue? No, no, will not permit you. Now we have to attend to the. ಅಲ್ಲಿ ಏನಿರುತ್ತೋ ಅದ್ರ ಮೇಲೆ ಒಂದು ಮಾರ್ಕ್ ಮಾಡಿಕೊಡಿ ಅಷ್ಟೇ. See, your matter is not listed today. You can't argue even when mentioning is not over. Yes.
Adjournments, page wise, page 1, still number 1 and 2.
There are some other compliances. There are in other cases, there are other compliances. Adhu check ಮಾಡಿ ಆಮೇಲೆ ನೋಡಿ, non filing of acknowledgement for having paid deposit. The office objections raised on memo for return of documents. ಇದೆಲ್ಲ ಇದೆ ಅಲ್ಲ. Here for the claimant, you have filed the memo for return of documents. But who has filed this memo for return of documents? There are other claimants also. No, you are in one case. In other case, ನೀವೇ ಇದ್ದೀರಾ? What is correct? Who has filed this memo for return of TCR? Probably you must have filed. ಅಲ್ಲೇನೋ ಒಂದು. So it was ordered to be considered along with the main matter. As requested by both sides, list on date. 22.
Madam, serial number, my lord, serial number 4, my lord.
Serial
There
number
is little difficulty for me to attend the court today. My lord, may I have it day after tomorrow, my lord?
2015. M.R. Vijay Kumar and Shivanegowda. As requested by the appellant.
Only for today there is some difficulty, my lord. May I have it on next Monday, my lord?
20. You said day after tomorrow. 22.
Day after tomorrow, my lord, have another this thing. Have it on 23rd, my lord. I have no objection.
You only said ಮೊದಲು day after tomorrow ಅಂತ ಆಯ್ತು. 23rd is which date?
ಅಲ್ಲ, day after tomorrow ಬೇರೆ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಫಾಲ್ಟರ್ಡ್ ಇದೆ, ಅದಕ್ಕೆ ಬರ್ದೇ ಹೋಗ್ಬೋದು, ಹೊರಗಡೆ ಹೋಗ್ತಾ ಇದ್ದೀನಿ ಅದಕ್ಕೆ.
23, all right. Yes.
Page 3, still number 5.
Please,
to 7.
My lord, serial number 7, my lord. I appear for the appellant in this matter. May I request for 2 weeks' time, my lord, in this matter?
Total moved. This is it.
Illa, we have not moved the court, madam.
Then we can't grant adjournment in their absence. Let them come.
Okay.
How that is connected? Common award or common award? Council correspondence 1 to 4 submits that MFA number so and so is also connected to these matters. List all the matters together. 2015 ಇದೆ. ಅವಾಗ ನಾಳೆ ನಡೆದ ಡೇ ಟುಮಾರೋ, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಮತ್ತೆ ಈಗ 2015 ಪೆಂಡಿಂಗ್ ಇರುವಾಗ
serial number 6, my lord.
that any other matter is connected. ಇದು ಕನೆಕ್ಟೆಡ್ ಅಂತ ಹೇಳೋದು ಬರೀ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಳ್ಳೋದಕ್ಕೆ ಒಂದು.
My lord, serial number 6, my lord.
6.
Yesterday your lordship has recalled the order of dismissal. The same matter, my lord, it was posted to 28/6. It can be posted along with any date.
In that case, we have ordered to list that on 28/6.
Yes, my lord. From yesterday, connected matter.
ಅದನ್ನು ಪ್ರಿಪೇರ್ ಮಾಡಿ ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ.
Please, any date. No. I don't have any objection.
22/6.
Much obliged.
22. Page 4, still number 8. Page 5, still number 9 and 10. Page 6, still number 11 and 12. Page 7, still number 13 to 17. As a date given matter or the withdrawal application.
ಕರೆಕ್ಟ್ ಅವರು ಏನೋ ಒಂದು ವಿತ್ಡ್ರಾವಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ ಅದನ್ನ ಇಟ್ ಶಲ್ ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಅಲಾಂಗ್ ವಿತ್ ಅಂತ ಆಗಿರ್ಬೇಕಾಯ್ತು ಇನ್ನೊಂದು ಆಸ್ ರಿಕ್ವೆಸ್ಟೆಡ್ ಬೈ ರೆಸ್ಪಾನ್ಸ್ ಕೌನ್ಸಿಲ್ ಲಿಸ್ಟ್ ಫ್ರಮ್
28-6.
ಏನಾಗುತ್ತೆ ಏನೋ ಡೆತ್ ಕೇಸು ಬಹಳ ಗ್ರೀವಸ್ ಇಂಜುರಿ ಇರೋ ಕೇಸ್ ಇದೆ ಪಾಪ ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ಆದ್ರೂ ಅಮೌಂಟ್ ಸಿಕ್ಕಿ
Page 8, seal number 17 to 21, 22. Page 9, seal number 23 to 26.
ಆಮೇಲೆ ಕರೆ
24 and your lordship.
24
Your lordship, we have submitted the memo for this thing. Serial number 25, your lordship. I'm sorry, your lordship.
we will consider that when the case comes. Now we are calling these matters only for adjournment. You want adjournment?
No, your lordship.
Then wait till the matter is called.
38, seal number 1. Kalpana B, Janatan Reddy, Sharabu.
Last time we had already calculated and last time we had calculated this compensation payable on the head of loss of last 3 lakhs ಅಂತ ಏನೋ ಅಮೌಂಟ್ ಬರ್ಕೊಂಡಿದೀವಿ ಅದೇನಾ ಅವ್ರ ಪ್ರಕಾರ ಎಷ್ಟು ಬೇಕು how many bills has taken ಮತ್ತೆ ಯಾಕೆ ಸುಮ್ಮನೆ ಅಡ್ಜರ್ಮೆಂಟ್ ಕೇಳ್ತೀರಾ ಎಲ್ಲ ಆಗಿ ಡಿಕ್ಟೇಷನ್ ಮಾಡೋ ಟೈಮ್ಗೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಯು ಹ್ಯಾವ್ ಟೇಕನ್ ಟೈಮ್ 3 lakhs ಅಂತ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ವಿ or whether they had claimed higher compensation. No, madam, will not grant time. This is from which place? ಮತ್ತೆ ಬೆಂಗಳೂರು ಇದ್ರೆ ಪಾರ್ಟಿನೇ ಇಲ್ಲೇ ಇರ್ತಾರೆ ತಗೊಳ್ಳೋದು ಯಾರ ಹತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಮತ್ತೆ ನೀವ್ಯಾರ ಅಡ್ವೊಕೇಟ್ ಕರೆಕ್ಟ್ ಎಲ್ಲಿದ್ದಾರೆ ಅವರು ಅವ್ರ ಹತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ ಬೇರೆ ಯಾರ ಹತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರು ಎಲ್ಲಿದ್ದಾರೆ this is too much. No, will not grant adjournment. At the most will pass it out. Last time dictation kodo time ge has stopped it.
Number 2 adjourned. Number 3, Omahesh. Ravi. Number 3.
Ready, my lord. I am ready.
Vellanki Ravi. Okay, Varlina will respond. One is your appeal and the other one is their appeal.
Yes. My appeal, my lord, on question of my lord, the negligence.
Oh, last time we had argued in this that bus.
Yes.
Two buses were involved. Yes. Hey.
Yes, ma'am. Lord, the date of accident is 18/3/2008 at 8:15 p.m. Lord, deceased Krishna Kumar, aged about 41 years, my lord, was driving the car, my lord.
My lord, I am for the BMTC. We don't have any liability, my lord. A formal party.
Yes. Yes.
He was driving the car, my lord, KA03 MD 6178.
Yes.
The bus, my lord, is bearing registration number KA01F 2061. In this respect, my lord, I would like to invite your lordship attention to the reasoning of the tribunal before I take your lordship to the other document. In page 17, para 15 of the judgment.
Yes.
14, from 14, my lord. 15 my lord. However, it is an admitted fact that the present accident is a head-on collision. Exhibit P4 in the spot sketch reflects that there was sufficient space for the deceased towards his left side to avoid BMTC bus. In spite of that, admitted accident has taken place. So it appears that the deceased was proceeding with high speed. Therefore, it appears the deceased has contributed some negligence in occurrence of the accident. In the circumstance of the case, it is thought just and proper to levy contributory negligence on the part of the deceased at 20%. But this I have challenged my lord, in my appeal.
Yes,
So admittedly, it was a head-on collision, my lord, and there was ample space for the deceased driver of the car to avoid, but in spite of that, my lord, he has gone and dashed against the BMTC bus, which was coming from the opposite direction.
so he himself was driving.
Yes, he
You
himself.
are the insurer of his car only.
No, my lord, I am the insurer of my lord,
Bus.
1 minute. BMTC, but
BMTC bus. Okay.
BMTC was insured with my lord.
United India.
And he was driving the car.
Hmm.
He went and dashed against the BMTC bus, though he had ample space to his left side. Therefore, my lord, higher degree of contributory negligence should have been considered, if not sole negligence.
Yes, what is the observation about your negligence?
Lord, PW2 is the employee, my lord, who speaks about this thing. Lord, RW1, my lord, is the driver of the BMTC who speaks, my lord, as to the manner of the accident and says that the driver of the car himself was negligent. Here, my lord, the driver of BMTC has been examined. And RW2, my lord, ACP was examined.
Yes,
His statement, my lord, that when he reached the place, my lord, that the public were saying that it was due to the negligence of the deceased.
that is PW.
PW2, my lord. Title page 2 of the deposition. Last paragraph, my lord, it is correct to suggest that in the complaint it is stated that the people at the spot were talking that the driver of the car himself has overtaken. The said portion is portion of exhibit P1 is exhibited as exhibit P1A.
PW2, no? Who?
RW2, my lord. Assistant Commissioner of Police, Mohammed Hussain. RW2, my lord, RW2.
Oh, Maheshwar.
Title page 2 of the deposition, last paragraph. my lord. It is correct to suggest that the complaint, in the complaint, it is stated that the people at the spot who are talking that the driver of the car himself has overtaken. The said portion at exhibit P1 is exhibited as exhibit P1A.
P1 is complaint.
P1 is complaint.
P1 is FIR
FIR.
with complaint.
Yes.
Who is the complainant here? Informant HP Siddharaju.
Complainant, my lord, is Siddharaju.
You name Martita. Police. He is also a police
He
constable.
is also police. Then, my lord, the complaint, you not kindly see the last few lines. That is by Siddharaju.
Yes. Yes.
Yes, ಚಕ್ಕಮಾಗಿರ್ತದೆ ಆಯ್ತು ಸದ್ರಿ ಕಾರನ್ನು ಚಾಲಿಸುತ್ತಿದ್ದ ವ್ಯಕ್ತಿ ಕಾರಿನ ಸ್ಟೇರಿಂಗ್ ಮೃತಪಟ್ಟಿದ್ದನು ಮತ್ತು ಅಲ್ಲಿದ್ದ ಸಾರ್ವಜನಿಕರು ಅವರಿಂದನೇ ಓವರ್ಟೇಕ್ ಮಾಡಿಕೊಂಡು ಬಂದು ಎಂದು ಹೇಳುತ್ತಿದ್ದರು.
So this Siddharaju was not examined.
Siddharaju, my lord,
His statement is hearsay.
when he went to the spot, my lord, he said that the people were speaking that the car driver himself was trying to overtake and he was responsible for the accident.
This RW2 was not a.
RW2, my lord, is not the, but he speaks about the, my lord, the police.
He has filed the charge sheet.
Yes.
RW2 himself has filed the charge sheet.
But he speaks, my lord, both ways. He comes and says that it is not true to suggest in order to help the family of the deceased they have taken. But the P4 may kindly be looked into, my lord. That also.
He was cross-examined by the claimant's counsel also.
Yeah.
RW2 was your witness.
RW2 is, my lord, is my witness, my lord.
But he says another thing, re-examination.
So normally what happens, my lord, driver is not examined, that's what, my lord. But here the driver has been examined, BMTC. I'll read the evidence of RW1 also, my lord, for your lordship.
Cross-examination you.
May I read a RW1 evidence, my lord, the driver of the bus.
I have recorded further statements of the witnesses.
From para 2, my lord, I'll read.
Para 2 of?
Para 2 of RW1, my lord, the driver of the BMTC. I submit that on 18/3/2006 at about 8:30 p.m. I was driving BMTC bus bearing registration number so and so as per the instruction of the first respondent and carrying passengers in a bus. And I was stopped of Trinity Circle and waiting for the red signal. And after given green signal, I was moved and said due to that time, deceased was driving his car and came from the wrong side and overtake another bus and cross the road because he was very in a hurry to cross the signal, even though the red signal was to him, and he has lost control and dashed to the roadside divider and then turned and turtled his car and met with an accident, met with a self-accident and not due to my fault, and my bus dashed to his car. But the deceased was driving his car in a very rash and negligent manner and lost the control and in a hurry to cross the signal and lost the balance and dashed to the road divider and turtled his car and met with an accident. This is the, my lord, evidence of the, my lord. And he says that he has been acquitted in the, my lord, in the criminal court after the trial. That is on the last few lines, my lord, has been. I have contested the criminal case with before the 5th Metropolitan Magistrate Traffic Court in CC number so and so and acquitted under section 255. Now, my lord, I would like to, my lord, invite your lordship attention to the sketch, my lord. Trinity Circle at the end of, my lord, the MG Road.
Exhibit?
P4. Right, my lord, it goes to the Alsur. Right, my lord, to the old airport road. And there is a signal. He, in order to, my lord, avoid, he jumped the red signal and overtook another vehicle and came and dashed against the, my lord, the divider. sketch may kindly be looked into, my lord.
This bus was going from which side to which side?
My lord, he was coming from east to west.
We were asking the sketch in the sketch. So
My lord, at the Trinity Circle, if your lordship, my lord, is have traveled that side, my lord, Trinity Circle, there is a church. There is a traffic signal, my lord.
your bus was proceeding towards Richmond Road, right?
Yes, my lord, that is.
He was proceeding from Richmond Road side to Trinity Circle.
My lord, what I am.
As per this sketch, just we are asking you, as per this sketch,
Yes,
the from the border of the road, there was 11 meters. The accident took place at a distance of 11 meters, and their car was at 10 meters.
at the
That's the other
Trinity,
border of the road.
my lord, at the Trinity Circle, from west to east, my lord, it goes to Alsur. Right turn, my lord, Airport Road, and there, my lord, then it goes to the Richmond Road also. There is a split up, my lord, this thing, T cross. It goes to the Richmond Road.
Yes,
And traffic comes from my lord, old Airport Road to join the MG Road. There is a traffic signal.
yes,
Therefore, my lord, the contributing negligence to an extent of only 20%, my lord, is on the lower side, considering the facts and circumstances of the case, if not solely negligent, my lord, higher degree of negligence, my lord, should have been attributed to the, my lord, the deceased driver of the car.
yes.
That is regarding, my lord, the negligence. Driver of BMTC bus has been examined, and RW2, my lord, ACP has been examined, who is not an eyewitness. And officer of the, my lord, the insurance company has been examined as RW3 to substantiate the on issue of negligence and quantum. Now, my lord, coming to the quantum. He was stated to be, my lord, manager in engineering concern, drawing 35,000 per month. Tribunal, my lord, in the absence of, my lord, the proper material, has taken the income as 21,000 per month. And contribution at 14,000 after deducting, my lord, 1/3.
Yes.
23,52,000. Blood in the loss of dependency, then again 30%, my lord, the future prospect, 7,05,600. That is, my lord, questioned by the, my lord, by the appellant.
Why 21,000 is on the higher side?
Yes, my lord, the future prospect, my lord.
What was his age?
Blood, he was aged 41 years.
Is there any dispute about that?
PW2 was examined, my lord. He doesn't speak about, my lord, the future prospect as such, and there is no document to prove the terms of contract of employment.
What was his occupation? He was working as?
Lord, he was, my lord, the manager in a Gina Engineering Company Limited.
He's a manager at Gina Engineering Company.
For having claim, my lord, when there is he was employed, then, my lord, terms of employment will reflect, my lord, when he will get promotion, what will be the increment in his pay. Only in the absence of, my lord, proof, the Lok Adalat charge, my lord, is taken into consideration.
Not Lok Adalat charge, that is the Pranay Sethi's case, there is guideline, no? Regarding
Lord,
future prospect.
Well, my respectful submission is when the Malord, the future prospect is not proved, he was employed under a contract of employment, there will be a specific Malord provisions when he will be promoted and what will be the increment. Pranay Sethi case, Malord says, in the absence of evidence, Malord, that would be the. But here, Malord, you will have to kindly see. He was aged 41 and PW2 was examined. I'll read Malord evidence of PW2.
PW2 is the employer. PW2 is employer.
PW2 is the an officer of the employer, Malord, of the.
Yes.
Yes. PWD para 3, Malad, I submit that the deceased K. Krishna Kumar joined in our company as legal advisor in the March of 2005, pursuant to the appointment letter issued by our company. Submit that when K. Krishna Kumar joined our company, that he was paid to him by the company rupees 20,000. I submit that subsequently deceased K. Krishna Kumar was promoted as a manager legal and his lot term salary was 35,000. I submit that if the deceased Krishna Kumar continued in the services of our company, he could have been promoted as senior legal consultant and he would have been drawing a salary of 75,000 to 1 lakh as on today. I submit so on so. Then, Malord, cross-examination may kindly be looked into, Malord. I am working as senior consultant legal Gina Engineering Company Private Limited, Indira Nagar, Bangalore. I have authorized my managing director of the company to give evidence in the present case on its behalf. Today, I have filed my affidavit in lieu of examination chief and the said affidavit is prepared as per my instructions. The contents of the affidavit are true and correct and so on. So, then, my lord, at typed page 5, my lord, bottom paragraph. The deceased employed in our company on 18/3/2005. The company is income tax assessee. Payments of the company based are made through the checks. The mode of payment of the salary is checks. The salary of the deceased used to be credited to his SP account in a SBM Ambedkar VD branch. There is details of payment of salary to the deceased. There is no impediment for me to produce the salary certificate maintained by your office. This is, my lord, but they are not produced, my lord, any documents.
Yes.
No passbook has been, my lord, produced.
Yes.
Yes. So under these circumstances, my lord, the tribunal has rightly held 20,000, my lord, 21,000 per month. But future prospect, my lord, 7,05,600 at the rate of 30%, my lord, was uncalled for in the absence of, my lord, evidence.
When he was enrolled, his enrollment certificate also they have produced.
He has not produced anything, my lord, only
They have produced research as well.
PW2, my lord, he says that there is.
Certificate exhibit P14, enrollment certificate exhibit P15.
Yeah.
When he was enrolled,
Enrollment certificate issued by the system controller, so on so. All those certificates, my lord, do not reflect or prove the income, terms of employment, proposed, my lord, future
yes, 1992.
promotion and pay.
16 ವರ್ಷ practice ಆಗಿದೆ. Yes. Yes.
Yes, my lord. Therefore, my lord, the 7,05,600 was uncalled for. And again, my lord, 1,25,000 to the loss of estate, my lord, is by any thing, my lord, is on the higher side.
One second. When I was working in Ventura data systems, he puts the job.
1 lakh is, my lord, awarded for love and affection, 50,000 for love and affection for the other claimant. 8% interest, my lord, has been allowed instead of 6%. These are the grounds, my lord, on which appeal has been filed.
Broad amount of concept. Controller, component, yeah. Yes. Yes, anything else?
That's all, my lord, from my side.
The bundle.
ಅದೇನಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
ಅಲ್ಲ, ಅವ್ರು ವಿಜಯ್ ಕುಮಾರ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಕ್ಲೇಮೆಂಟ್ಸ್ ಅಡ್ವೊಕೇಟ್.
ಇಲ್ಲ, ವಿಜಯ್ ಕುಮಾರ್ ಏನಿಲ್ಲ, ನಮ್ಮ ಕಂಪ್ನಿಲಿ ಇನ್ಶೂರೆನ್ಸ್ ಆಗಿದೆ, ಅದೇನಿಲ್ಲ.
ಕ್ಲೇಮೆಂಟ್ಸ್ ಕೌನ್ಸಿಲ್
ನಾವೇ pay ಮಾಡ್ಬೇಕು.
ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ಏನೋ ಬಂದಿದ್ರು. ಪಾಸ್ವರ್ಡ್ ಮಾಡೋದು.
My lord, I appear for BMTC.
You said
Our vehicle is insured with United India.
no, claimants council. Serial number Vellanki. Last time it appears had come. Vellanki Ravi. Or they are on the point of this negligence as well as quantum. We'll pass it over. Bartare nodon. Parlilla andre. Pass.
Number 4 adjourned, so number 5, Remanded ready, open the path.
Is it fast forward, my lord?
Ask over. We'll see if he comes.
Please.
Permit to aviation ಇದೆ. ತಮಿಳುನಾಡಲ್ಲಿ permit ಇತ್ತು, ಕರ್ನಾಟಕದಲ್ಲಿ vehicle.
You are for the
I have for the
owner of the
insurance company.
United India. You are
1917 ನಲ್ಲಿ ನಮ್ಮ insurance company.
5.
Okay, so 6 or 5.
5 is the insurance appeal.
ಹೌದು.
6 is claimants appeal. 6 Vasant appeal. You are for the claimants. 2279. This.
ಏನ್ ಇನ್ಶೂರೆನ್ಸ್ ಆಗಬೇಕು? permit ತಮಿಳುನಾಡಲ್ಲಿ ಕರ್ನಾಟಕದಲ್ಲಿ accident ಆಗಿದೆ.
You are charged sheeted for a violation of permit condition also. 96. Charge sheet is exhibit. P7. He was not charge sheeted for this violation of
vehicle ತಮಿಳುನಾಡು permit ತಗೊಂಡಿದ್ದಾರೆ.
right permit ತಗೊಳ್ಳೋದು ಆಪರೇಟ್ ಮಾಡೋದಕ್ಕೆ ಯಾವ ಏರಿಯಾದಲ್ಲಿ 279 ಆಗ್ಲಿ ಪರ್ಮಿಟ್ ಎಲ್ಲೆಲ್ಲಿ ಆಪರೇಟ್ ಮಾಡೋದಕ್ಕಿತ್ತು ಪರ್ಮಿಟ್ ಮತ್ತೆ ಹಾಗಿದ್ರೆ ಇಂಟರ್ಸ್ಟೇಟ್ ಪರ್ಮಿಟ್ ಇರ್ಲಿಲ್ಲ ಅಂತಾನ ವಾಟ್ ಇಸ್ ದ ಎವಿಡೆನ್ಸ್ ಯು ಲೆಟ್ ನೀವು RTO ಅಲ್ಲಿ RTO ಯಾಕೆ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ and he was not charge sheeted for violating the permit conditions or any provisions of MV Act. Permit copy is that document you have produced? Authorization letter, permit extract, exhibit R2. R2. Route permit for which all routes except those are prohibited. All routes ಅಂತಂದ್ರೆ ಯಾವ್ದು ಅದು concrete mixture nature of goods to be careful. Correct. ಅಲ್ಲಲ್ಲ ಅದರಲ್ಲಿ ನೀವೀಗ now you are saying that he was operating ಆ ಕೇಸಲ್ಲಿ ಅವರು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರು ಕನ್ಸರ್ನ್ RTO ಯಾರೋ commissioner or somebody was examined that case commissioner of this transport ಇಲ್ಲಿ ಆ ಕೇಸ್ ಇಲ್ಲ ಮತ್ತೆ ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರು ಆ ಅಫೆನ್ಸ್ ಇದ್ರಲ್ಲ ಆ ಚಾರ್ಜ್ all routes except those prohibited ಅಂದ್ರೆ ಏನು you have to explain that heavy goods vehicle prohibited routes ಅಂದ್ರೆ ಯಾವ್ದು ಅಂತ ಏನಾದ್ರು ಹಾಕಿದೀರಾ ಇಲ್ಲಿ ಅದಕ್ಕೆ ಅವಕಾಶ ಮಾಡಿದ್ರು not west. This what the tribunal said for that regarding liability. Even owner liability ಹಾಕ್ಬೇಕಂದ್ರೆ there should be condition. ನಿಮ್ಮ statement of objection ಅಲ್ಲಿ whether you have taken up this ground. No. Statement of objection only. Ground. First respondent. You were the first respondent. Yes, the lorry was also subject to conditions, obligations, limitations, no obligation on the part of the ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಹೇಳಿದೀರಾ ನೀವು there was violation of permit condition ಅಂತ vehicle pertained to Tamil Nadu and was holding permit to ply within Tamil Nadu and as the vehicle since has plied in Karnataka the alleged place of accident in Karnataka the permit clause of the policy has been breached. But you have to establish that the permit was only to operate in Tamil Nadu. Led for that. ಈಗ ಅಲ್ಲಿ ಅದರಲ್ಲಿ all routes ಅಂತ ಇದೆ except prohibited. What is the meaning of that prohibited? Yes. Then
regarding negligence aspects of the vehicle road cross ಮಾಡಬೇಕಾದ್ರೆ ಕಂಪ್ಲೀಟ್ ಆಲ್ಮೋಸ್ಟ್ ಕ್ರಾಸ್ ಆದಾಗಿರೋ ತಂದ್ಕೊಟ್ಟಿಲ್ಲ
ಏನದು ಸ್ಕೆಚ್ ಇದೆಯಾ
ಎಕ್ಸಿಬಿಟ್
P2 spot sketch. Road median. Service road, this is motorcycle number. Lorry. Your vehicle was crossing the road. Oh, you do mean cross road. No, lorry was coming from the other side. Red mix lorry. ದೊಡ್ಡನಕೇರಿ ರಸ್ತೆ ಕಡೆಯಿಂದ ಗೋಶಾಲಾ ರಸ್ತೆ ಅಂತ ಇದೆ. So it had already almost reached the end of this, and he only came and did. Yes. Oh. 20% is already. No, what was the proof of income? Whom had you examined? Employer. Huh? Oh. Employers. So why the tribunal considered 31,000? According to it was 32,000. Andre professional ಇದನ್ನೆಲ್ಲ ಕಳೆದಿರಬೇಕು ಅದರಲ್ಲಿ. ಅಂದ್ರೆ not regular income. It's all variable. So then why did you file appeal? Why have you filed appeal? 20. Sketch ನೋಡಿದ್ರೆ ನಿಮ್ಗೆ negligence ಇದೆ. On perusal of already cross the road. ಎಲ್ಲ ಮಾಡ್ತಾರೆ ಗೊತ್ತು. See, the tribunal says that on perusal of exhibit P2 sketch, it goes to show that mixer lorry had already crossed the road, and at that time the deceased was coming on the main road, came there and dashed against the mixer lorry, caught beneath the back wheel. So it was in the back wheel. Right. And you don't find any error. In fact, RW1 in the cross examination admits nowhere it is mentioned that permit is given to ply vehicle within state of Tamil Nadu. He further volunteers that IO submitted the report, and in that report the same is mentioned. Vehicle plies to other state, they have to take permission from the concerned authority, and also admits that they have not verified the same from the concerned authority as to whether they have taken permission or not. So RW1's evidence is no help to you ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅವರು. PW2 and 3 eyewitnesses ಅಂತ ಮಾಡಿದವರು, they are not complained, neither complained nor charge sheet witness. Regarding the issue number 2, no? Deceased was age 24. Age basis will not depend. No, age is fixed based on which document ಅಂತ ನೋಡ್ತಾ ಇದ್ದೀನಿ. Age is fixed based on which document? Marks card of regarding exhibits P10 13/6/86 19/2000 26 years. That's correct. So there is no dispute about the multiplier also. Now we are only on the there is the discussion with regard to income. In para 41, na? For that, as the deceased was aged 26 years, at the time of accident, 50% come out of his income has to be taken as loss of future prospects. No, income ಬಗ್ಗೆ discussion already. Para 35. ನಾನು ಹಾಕ್ಕೊಳ್ಳೋದು ಇವತ್ತು. ನಾನು ಹಾಕ್ಬಿಡಿ ಒಂದು. ಹಾಕ್ಬಿಡಿ ಹಾಕಿ ಸರ್. Para 35. Appointment confirmation. Yes, this petition also produced the above services. Company has paid incentives. So on an average, it was 31,000 and so on. If we take the 8 months salary into consideration, totally it works out to 2,49,416. Divided by 8 months, 31,177. Income tax assessee ಇರಬೇಕಲ್ಲ ಮತ್ತೆ ಇವರು 3,72,000 ಅಂದ್ರೆ ಇನ್ನು ಇದು ಅವರೇಜ್ ತಗೊಂಡಾಗ you are not produced the income tax returns or bank statements. Then that is reasonable, whatever is taken.
Yes, quite reasonable.
Our incentives ತಗೊಂಡಿದ್ದಾರೆ incentives. And what was the deduction? 10% has to be given deduction towards the tax. So 12,000 towards tax. So 3,59,000 correct is that. The most number 173. Allari, a variation, it is not a regular, that is not the regular salary. Incentives. So where is about future? 26 years. Up to 40%. You say that it has to, he was established, self-employed, established, permanent job, actual salary. What the employer said, permanent job regarding nature of job? So income taken is 3,59,800. After deduction of tax, 3,59,800. Your deduction, no? How many? He was unmarried. 3,59,800 divided by 2 money. 1,79,900. How do you 1,79,900. Either the 40%.
71,960.
71,960. ಎಷ್ಟಾಗುತ್ತೆ 1,79,900 ಪ್ಲಸ್ 71,960. 1,79,900 plus 71,960. 2,51,860 into this is annual income, Allah. This was annual income. Multiplier applicable 17 into 17. 42 lakhs 620. Then 20% ಆಮೇಲೆ ಡಿಡಕ್ಟ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಎಲ್ಲಾದ್ರಲ್ಲೂ. How many dependents? Mother and father ಇಬ್ರೇನಾ? So 40. ಎಲ್ಲಿದೆ? ಅದ್ ಯಾವ್ದೋ ತೋರ್ಸಿದ್ರು ಆದ್ರೆ ಅದ್ರಲ್ಲಿ ಏನು ರೇಷಿಯೋ ಅಂತ ಏನು ರೇಷಿಯೋ ನೋ ರೇಷಿಯೋ ವಾಸ್ ಲೇಡ್ ಡೌನ್ ಇನ್ ದಟ್. ಯಾವ್ದು ಹೇಳಿ ತೋರ್ಸ್ಬೇಕಂದ್ರೆ ಯಾರೋ ಹಿಂದೊಂದು ತೋರ್ಸಿದ್ರು ದಟ್ ನೋ ರೇಷಿಯೋ ವಾಸ್ ಲೇಡ್ ಡೌನ್. ಶಿವನ್ನೇಗೌಡ್ರು ಯಾವ್ದೋ ಒಂದು ಕೇಸಲ್ಲಿ ತೋರಿಸಿದ್ರು ನೋ ರೇಷಿಯೋ ವಾಸ್ ಲೇಡ್ ಡೌನ್ ಇನ್ ದಟ್. Pranay Sethi's case was on reference, so we have to go according to that. So 88,000 ಇದ್ರಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಕಣ ಇದನ್ನು? ಟೋಟಲ್ 1 lakh ಕೊಟ್ಟಿದ್ದಾರೆ. ನೀವು ಅದಕ್ಕೆ ಚಾರ್ಟ್ ಮಾಡಿಲ್ವಾ ಇಲ್ಲಿ ನಿಮ್ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ? ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಕಾಣಲಿಲ್ಲ. Loss of dependency 63 lakhs 24,000 ಮಾಡಿದ್ರು. ಇಲ್ಲಿ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಕಡಿಮೆ ಆಯ್ತು ಅದಕ್ಕೆ. ಕಾಂಪನ್ಸೇಷನ್ ಟು ದ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಅದು ಜಾಸ್ತಿ ಆಯ್ತಲ್ವಾ 1 lakh 88,000 ಆಗುತ್ತೆ. 88,000 plus 33,000. Accident took place in which year? 2012. ಎಷ್ಟು ರಿವಿಷನ್ ಆಗುತ್ತೆ ಇವಾಗ? ಒನ್ಸ್ ಇನ್ 3 years ರಿವಿಷನ್ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. 10% ಒನ್ಸ್ ಇನ್ 3 years. 2017 ಆನ್ವರ್ಡ್ಸ್. 17 ಜಾಸ್ತಿ ಕೊಡ್ಬೇಕು ರಿವಿಷನ್ ಜಾಸ್ತಿ ಕೊಡ್ಬೇಕಾಗತ್ತೆ. ಈ ಜಸ್ಟ್ 10% ಇದ್ದದ್ದು ಅದ್ರ ಮತ್ತೆ ಎವ್ರಿ 3 years ಮಾಡ್ಬೇಕು, ಮಾಡ್ತಾ ಹೋಗ್ಬೇಕಲ್ಲ. ಅಟ್ಲೀಸ್ಟ್ 2 ಆದ್ರೂ ಕೊಡ್ತಾರೆ. 2017 to 2020, 2020 to 2023 ಒಂದ್ ಸ್ವಲ್ಪ ಚೇಂಜ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. 88,000 ಅಲ್ಲ, 88,000 ಮೇಲೆ ಮತ್ತೆ ಪ್ಲಸ್ ವಿ ಹ್ಯಾವ್ ಟು ಗಿವ್ 10%. 88,000 88,000 ಪ್ಲಸ್ 8,800
96,800.
ಅಲ್ಲಿಗೆ ಬಂತಲ್ಲ 1 lakhಗೆ. ಅಲ್ಲ 10% ಆ ಬೇಸಿಕ್ ಅಮೌಂಟ್ ಮೇಲೆ ಕೊಡ್ಬೇಕಾ ಏನ್ ಮತ್ತೆ ಅಕ್ರೂ ಆಗಿದ್ರ ಮೇಲೆ ಕೊಡ್ಬೇಕಾ? ವಿತ್ ಎಸ್ಕಲೇಷನ್ ಆಫ್ 10% ಅಂತ ಹೇಳಿದೆ. ದಟ್ ಎಸ್ಕಲೇಷನ್ ಓನ್ಲಿ ಆನ್ 40,000 ಆರ್ ಅಗೇನ್ ವೆನ್ ಇಟ್ ಬಿಕಮ್ಸ್ 44,000 ಆನ್ 44,000. ವಿ ಡೋಂಟ್ ಥಿಂಕ್ ಇಲ್ಲ ಇದು ಹಾಕ್ಬೇಡ. 40,000 ಮೇಲೆ ಅಂದ್ರೆ 20% ಕೊಟ್ಟು ಬಿಟ್ರೆ ಕರೆಕ್ಟ್ ಆಗುತ್ತೆ. 40,000 20% ಎಷ್ಟಾಗುತ್ತೆ ನೋಡಿ? 8,000 ಅಂದ್ರೆ 48,000 ಆಗುತ್ತೆ ಅಲ್ವಾ? 48 into 2 ಅಲ್ಲಿಗೂ ಮತ್ತೆ ಹಾಗೆ ಬಂತಲ್ಲ, ಹಾಗಾದ್ರೆ ಅದು ಕರೆಕ್ಟೇ. 96,000. ಸೊ 33,000 ಅಲ್ಲ 30,000 20% 6,000 ಆಗುತ್ತೆ. 36,000 ಹಿಂಗ್ ಮಾಡಿ 42,81,620 ಇಲ್ಲಿದೆ ಇದೆ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ. ಅಲ್ಲ ಇದ್ರಲ್ಲಿ 20% ತೆಗಿಬೇಕಲ್ಲ ಮತ್ತೆ. ಹೀಸ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ವಾಸ್ ಟೇಕನ್ 20%. 25 ಅದು ನಿಮ್ಮೂರಿಗೆ ಹೋಗಿ ಹೊಡೆದಿದ್ದಾರೆ ಅಲ್ಲಿ. 44 lakhs ಇಲ್ವಲ್ಲ, ಜಾಸ್ತಿ ಆಗ್ಬೇಕು. 42,81,620, 96,000 plus 36,000. 44 ಸಾರಿ 44 lakhs ಆಗೋದಿಲ್ಲ ರೀ. 42,81,620 ಡಿಡಕ್ಟ್ 40% ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಎಷ್ಟು? 44 lakhs 620. ನೀವೇನು 20% ಅಂತ ಹೇಳಬೇಕು. ದಟ್ ಫೈಂಡಿಂಗ್ ಇಸ್ ಅಟ್ ಪೇಜ್ ನಂಬರ್ Internal page 12. No doubt, technical condition. Taking into consideration sketch, etc. 75%, yes, I apportion negligence 25% to the motorcyclist and 75%. Unfortunately, ಏನು ಮಾಡಕ್ಕಾಗೋದಿಲ್ಲ ಹಾಗಲ್ಲ ನೋಡಿ ಶಾಸಕ whom did they examine ಮತ್ತೆ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಅವ್ರು ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರು ಅಲ್ಲ ಆಯ್ತು ಇದು ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ವಾಸ್ ಫೈಲ್ಡ್ ಓನ್ಲಿ ಅಗೇನ್ಸ್ಟ್ ದಿಸ್ ಟ್ರೈಲ್ their own document ಬಟ್ ಆಕ್ಸಿಡೆಂಟ್ ಹೇಗಾಗುತ್ತೆ ಅಂತ ಹೇಳಕ್ ಆಗಲ್ಲ ಇವರು ಬಂದ್ರು ಅಂತ ಅವ್ರು ಆ ಕಡೆ ಹೋಗಿ ಇವ್ರು ಈ ಕಡೆ ಹೋಗಿ ಕರೆಕ್ಟ್ ಸ್ಕೆಚ್ ಆಕ್ಸಿಡೆಂಟ್ ಆದ್ಮೇಲೆ
ಅದರಲ್ಲಿ which is the main road?
ಸ್ಕೆಚ್ ಬರೋದು ಆಕ್ಸಿಡೆಂಟ್ ಆದ್ಮೇಲೆ
ಅಲ್ಲ when your lorry is crossing the main road ಅಲ್ಲ under motor vehicle act it is the duty of drivers to see on either side of the road and then proceed.
he was on the left side idare
Left side is that.
see he was on the main road as brother said when your lorry crosses ಇದನ್ ಅಲ್ಲ ರೀ ಅಲ್ಲಿ ಏನ್ ರೋಡ್ ಸಿಗ್ನಲ್ ಇತ್ತಲ್ಲ ಏನಾದ್ರು ಆದ್ರೆ ರೋಡ್ ಲೈಟ್ ಇತ್ತು ಅದ್ರ ಇವರು ಅದನ್ನ ಎಕ್ಸಿಟ್ ಅಲ್ಲ ಟ್ರಾಫಿಕ್ ಸಿಗ್ನಲ್ ಅದಕ್ಕೆ ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದೀರಿ ನೀವು ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಎಲ್ಲಾದ್ರೂ ಬರುತ್ತಾ ದರ್ ವಾಸ್ ಟ್ರಾಫಿಕ್ ಸಿಗ್ನಲ್ಸ್ ಅಂತ ಅಂದ್ರೆ ಇವ್ರಿಗೆ ಸಿಗ್ನಲ್ ಇದ್ದು ಇವ್ರು ಹೋಗ್ತಿರುವಾಗ ಇಫ್ ದಿಸ್ ಕ್ಲೇಮ್ ಡಿಸೀಸ್ ಕಮ್ಸ್ ಅಂಡ್ ಹಿಟ್ಸ್ ದೆನ್ ಇಟ್ ಇಸ್ ಹಿಸ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಇವ್ರು ಇಲ್ಲಿ ಇಫ್ ಎಟ್ ಆಲ್ ಟ್ರಾಫಿಕ್ ಲೈಟ್ಸ್ ಆರ್ ದೇರ್ ಇಲ್ಲಿ ಟ್ರಾಫಿಕ್ ಲೈಟ್ಸ್ ಇಲ್ದೇನೆ ಇವ್ರು ಬಂದಿದ್ರೆ ಇವ್ರ ತಪ್ಪು ಬಟ್ ಹೂ ಹ್ಯಾಸ್ ವಾಟ್ ಇಸ್ ದ ಎವಿಡೆನ್ಸ್ ಫಾರ್ ದಟ್ ಸ್ಕೆಚ್ ಹೇಗೆ ಅಂತಂದ್ರೆ ಇಟ್ ಈಸ್ ಆಫ್ಟರ್ ದ ಅಕರೆನ್ಸ್ ಆಫ್ ದ ಆಕ್ಸಿಡೆಂಟ್ ಯಾವ ವೆಹಿಕಲ್ ಎಲ್ಲಿತ್ತು ಅಂತ ತೋರಿಸ್ತಾರೆ ಅಷ್ಟೇ ಆದ್ರೆ ಆಕ್ಸಿಡೆಂಟ್ ಹೇಗಾಯ್ತು ಅಂತ ತೋರಿಸೋದಕ್ಕೆ
Who was at fault vehicle?
ಹೌದಾ ಆಕ್ಸಿಡೆಂಟ್ ಟುಕ್ ಪ್ಲೇಸ್ ಅನ್ನೋದಕ್ಕೆ ಚಾರ್ಜ್ ಶೀಟ್ ಇಸ್ ಅಟ್ ಎಕ್ಸಿಬಿಟ್ ಎಷ್ಟು ಚಾರ್ಜ್ ಶೀಟ್
Signal.
ನೋಡಂತದ್ದು ಬಜರ್ ಅಲ್ಲಿ ಏನಾದ್ರೂ ಇದೆಯಾ ಬಜರ್ ಇಸ್ ಎಕ್ಸಿಬಿಟ್ P3 ಅಪಘಾತವು ಮಹದೇವಪುರ ರಿಂಗ್ ರಸ್ತೆಯ ದೊಡ್ಡ ನೆಕ್ಕುಂದಿ ಜಂಕ್ಷನ್ ನಲ್ಲಿ ಭಗಿನಿ ಹೋಟೆಲ್ ಕಡೆ ಜಂಕ್ಷನ್ ಅಂತ ಬರೀತಾರೆ ಈ ರಿಂಗ್ ರಸ್ತೆ ಪೂರ್ವ ಪಶ್ಚಿಮ ಸರ್ವಿಸ್ ಸಿಗ್ನಲ್ ಇರೋ ಜಂಕ್ಷನ್ ಆಗಿರುತ್ತದೆ ಅಂತ ಇದೆ ಈ ರಸ್ತೆ ಉತ್ತರ ದಕ್ಷಿಣ ವಿಮುಖ ಸಂಚಾರ ವ್ಯವಸ್ಥೆ ಇರುತ್ತದೆ ಸಣ್ಣ ವಾಹನವನ್ನು ದೊಡ್ಡನ ಕುಂಡಿ ಕಡೆಯಿಂದ ಭಗಿನಿ ಹೋಟೆಲ್ ಕಡೆಗೆ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬಂದು ಕುಂಡೀಪುರ ಕಡೆಯಿಂದ ಮಾತಾಡಿ ಕಡೆ ಹೋಗುತ್ತದೆ ಮೋಟರ್ ಸೈಕಲ್ ಡಿಸ್ಪ್ಲೇ ಗೊತ್ತಾಯಿತು ಅಲ್ಲಿ ಏನ್ ಎವಿಡೆನ್ಸ್ ಇದೆ ದರ್ ವಾಸ್ ಸಿಗ್ನಲ್ ಲೈಟ್ ಆಪರೇಟಿಂಗ್ ಹೂ ಜಂಪ್ಡ್ ದ ಸಿಗ್ನಲ್ ಅನ್ನೋದಕ್ಕೆ ಏನಾದ್ರು ಇದೆಯಾ ಒನ್ ನೇಮ್ ನೈಟ್ ಅಲ್ಲ you have to establish whether who jumped the signal if there was a signal
ಬರೀ ಬ್ಲಿಂಕ್ ಆಗ್ತಿರ್ತಾವ ಅಷ್ಟೇ ಬ್ಲಿಂಕ್ ಆಗ್ತಾ ಇರ್ತದೆ ಯಾವ್ದಿರೋದೇ ಇಲ್ಲ ಬ್ಲಿಂಕ್ ಆಗ್ತಾ ಇರ್ತದೆ
ಹಾಗಂದ್ರೆ ಇಬ್ರು ನೋಡ್ಕೋಬೇಕು but this man was coming on the main road this man was crossing the road ಕರೆಕ್ಟ್ ಇದೆ 25%. ಯಾಕಂದ್ರೆ ರಾತ್ರಿ 1 ಗಂಟೆಗೆ ಎದಕ್ ಹೋಗ್ತಿದ್ರು ನಿಮ್ಮವ್ರು ರಾತ್ರಿ 1 ಗಂಟೆಗೆ and hardly was 26 years ಅಲ್ಲ CM ರಿಪೋರ್ಟ್ ಏನ್ ಹೇಳುತ್ತೆ
Investigation report ತರ ಒಂಥರ ಇರ್ತದೆ. ಅದಕ್ಕೆ record ಅದಾವೆ, produce ಮಾಡಿಲ್ಲ.
ಏನು ಇದನ್ನ ಆಲ್ಕೋಹಾಲ್ ಅಂತಾನೆ
Consumer alcohol ಅಂತ ಏನು ಬಂದಿಲ್ಲ, PM report ಅಲ್ಲಿ.
ಅಲ್ಲ ನಿಮ್ಮದ್ರಲ್ಲಿ ಬಂದಿದೆ ಆಲ್ಕೋಹಾಲ್ ಅಂತ.
ಅದರಲ್ಲಿ ಅವರು ಮಾಡಿದ್ರು ಅಂತ ಇನ್ವೆಸ್ಟಿಗೇಟರ್, ಬಟ್ ಅವರು ಒಂದು ಇನ್ವೆಸ್ಟಿಗೇಟರ್ ಅಂದ್ರೆ ನಾವೇನೋ ಅವ್ರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ತೇವೆ ಪೊಲೀಸ್ ರೆಕಾರ್ಡ್ಸ್ ರಿವ್ಯೂ ಮಾಡೋದಕ್ಕೆ.
ಮೊದಲೆಲ್ಲ ಪಿ ಎಂ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಅದನ್ನ ಬರೆಯೋರು, ಇತ್ತೀಚೆಗೆ ಬರೆಯೋದು ವೆಲ್ ನಾರ್ಮಲ್ ಅಂತ ಇದೆ ಇದ್ರಲ್ಲಿ ಅಬ್ಡೋಮನ್ ಅಲ್ಲಿ ರೈಸ್ ಅಂಡ್ ಚಿಕನ್ ಮೀಲ್ ಅಂತ ಇದೆ ಅದರಲ್ಲಿ.
ಸ್ಮೆಲ್ ನಾರ್ಮಲ್ ಅಂತ
ಇದ್ರಲ್ಲಿ ಬರೀತೀವಿ ಮೊದಲು ಇಲ್ಲಿ ಬರೀತಿದ್ರಲ್ಲ ಇಲ್ಲೇನೆ ಸ್ಮೆಲ್ಸ್ ಆಲ್ಕೋಹಾಲ್ ಅಂತ ಬರೀತಿದ್ರು. 25 ನೋ ಗ್ರೌಂಡ್ಸ್ 25 ಏನಾದ್ರೆ ನಿಮ್ದೇ ಕಡಿಮೆ. ಈಗ 44,13,620 ಇದು ಆದ್ರೆ 80% ಎಷ್ಟು ಬರುತ್ತೆ ನೋಡಿ. 80/100 ಅಲ್ಲ ಸಾರಿ 75 upon 3/4 ಅದರದ್ದು. 33 lakhs
10,215.
3/4 ಇಷ್ಟು ಬರುತ್ತೆ. 75%. Challenging the award in MVC number 1596 of 2012. Yes, on the file of the principal MACP SCCH number 1, the insurer has preferred MFA number 3979 of 2015 and the claimants have preferred MFA number 2278 of 2015. The appellants in MFA number 2278 of 2015 were the claimants, and the response in the said case were respondent number 1 and 2 before the tribunal. For the purpose of convenience, the parties will be referred to henceforth according to their ranks before the tribunal. Claimant number 1 and 2 are the father and mother of deceased Manjunath. On 19/2/2012 at 1 a.m. when Manjunath was riding his motorcycle number K01 EU 9931 near junction. Sheet is exhibit ಎಷ್ಟು ಹೇಳಿದ್ರಲ್ಲ sheet exhibit near ಅಂದ್ರೆ at ದೊಡ್ಡೇನ ಕುಂದಿ traffic junction near Bhagini Hotel within the limits of Kyarpuram traffic police station. Please take your seat. The lorry bearing number TN02 T9592 which was crossing the road hit him and caused the accident. He died at the spot. Due to the injury suffered in the accident, Manjunath died at the spot. Regarding the accident, one Netravati is a mother who was filed the complaint. She is not here. Netravati. ನಾರಾಯಣ ಅಲ್ಲೇ 20 ವರ್ಷ ಅಂತ ಸಿಸ್ಟರ್ ಆಯ್ತು. ಅಣ್ಣನವರ ಮೊಬೈಲ್ ನಿಂದ ಫೋನ್ ಮಾಡಿ ನಿಮ್ಮ ಅಣ್ಣನವರಿಗೆ ಅಪಘಾತವಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರು. ಎಲ್ಲ ಸಿಸ್ಟರ್ ಅಂತ ಬರ್ಕೊಂಡಿದ್ದಾರೆ ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ, ಬಟ್ ಶಿ ಇಸ್ ನಾಟ್ ಪಾರ್ಟಿ ಇನ್ ದ ಪಿಟಿಷನ್. Netravati filed a complaint before traffic police, Kyarpuram traffic police, alleging that the accident occurred due to the actionable negligence on the part of the driver of lorry number lorry number TN02 T9592. On the basis of the said complaint, care from traffic police registered FIR as per exhibit P1 in crime number 30 of 2012 against the driver of the lorry. Here, driver is not made party in the claim petition. On investigation, the police filed charge sheet as per exhibit P7 against the driver of the lorry for the offence is punishable under section 279 and 304A IPC. Next paragraph. I'm sorry, I'll let it go. At the relevant time, respondent number 1 and 2 were the insurer and registered owner of the said lorry. The claimants filed MVC number 1596 of 2012 before the tribunal, claiming compensation of rupees 50 lakhs from the respondents on the ground that the accident and consequent death of Manjunath occurred solely due to the negligence of the driver of the lorry. They further contended that they were solely depending upon the income of the deceased, and due to his death, they have suffered the damages. Respondent number 2 did not contest the petition. Respondent number 1 alone contested the petition, denying the occurrence of the accident due to the actionable negligence on the part of the driver of the lorry. Respondent 1 contended that the deceased himself was solely responsible for the accident. Respondent 1 further disputed the age, occupation, income of the deceased, and its liability to pay the compensation. It was alleged that the lorry was operating in violation of the permit condition. Thereby, there was a breach of policy condition and it was not liable to pay the compensation. Next one. To substantiate their claim, claimants got examined PW 1 to 4 and got marked exhibit P1 to P20. Respondent number 1 examined its official as RW1 and got marked exhibit R1 to R4. ನಿಮ್ಮ investigation report in ಹಾಕಿಲ್ಲ ನೀವು. The tribunal, on hearing the parties, relying on exhibit P1 to P7, P1 to P7, and the evidence of PW, ಅವರೆಲ್ಲ ಐ ವಿಟ್ನೆಸ್ ಅಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. P1 to P7 held that the driver of the lorry contributed, the accident occurred due to the contributory negligence of the driver of the lorry as well as the deceased. The tribunal apportioned the negligence at the ratio of 75% and 25% between the driver of the lorry and the deceased Manjunath. Further, the tribunal, relying on the evidence of PW employer, PW2 alva employer, PW2 and exhibits P8 to P8 and 9. 8 and 9. And the 9 are the pay slips. 8 is the appointment letter.
20
P8, 9 and 20. Oh, what 18 pay slips ಹಾಕಿದಾರ?
18 on the service confirmation letter.
he was working in 2 companies ಅಂತ
Exhibits P8, 9.
8, 9, 18 and 20. 18 to 20. ಹಾಗಾದ್ರೆ 17 ಬರುತ್ತೆ. 17 to 20. 17 to 20 held that the deceased regarding income paragraph ಎಷ್ಟರಲ್ಲಿ ಇದೆ? 35. Deceased had was ಏನಂತ ವರ್ಕ್ ಮಾಡ್ತಿದ್ರು ಅಂತ? Deceased was working as ಇದರಲ್ಲಿ ಅದೇ ಟೆರಿಟರಿ ಬಿಸ್ನೆಸ್ ಮ್ಯಾನೇಜರ್. ಅದು ಲೀಗಲ್ ಕನ್ಸಲ್ಟೆಂಟ್ ಇನ್ನೊಂದು ಕೇಸ್. ಟೆರಿಟರಿ ಬಿಸ್ನೆಸ್ ಮ್ಯಾನೇಜರ್ with AstraZeneca
Pharma India Limited.
AstraZeneca Pharma India. ಅದರಲ್ಲಿ ತಂದಿಲ್ಲ ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ರೀಸನಿಂಗ್ ಅಲ್ಲಿ. Since the tribunal further held that since he had variable income, taking the average of 8 months income, considered his 8 months income, considered his income at rupees 31,000 per month. After deducting 10% from his income, the tribunal considered his annual income at 3,59,800. Tribunal considered the age of the deceased as 26 years. Added ಎಷ್ಟು 50% ಮಾಡಿದ್ದಾರೆ. 50% to the income of the deceased by way of future prospects. 26 years. 50% ಬಗ್ಗೆ ಏನಿದೆ? ಇಲ್ಲಿದೆ ಪ್ಯಾರ 41 ಅಲ್ಲಿ AstraZeneca 50%. ಡಿಡಕ್ಷನ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? Deducted deducted 50% of his income for his personal expenses, applied 17 multiplier, and awarded compensation of 63,24,000 on the head of loss of dependency. Either 20%, 25% deduct ಮಾಡಿದ್ದಾರೆ. The tribunal in all assessed the total loss of income at rupees 63 lakhs, total damages at rupees 64,34,000 as per the table below, page 24 ಅಲ್ಲಿ paper book ಅಲ್ಲಿ ಹಾಕೊಳ್ಳಿ. Out of the aforesaid damages, the tribunal deducted 25% towards the contribution of the deceased in the occurrence of the accident, and assessed the compensation payable to the claimants at rupees 48,25,500. Next one. The insurer challenges the award on the ground of negligence as well as the quantum of compensation. Similarly, insurer and the claimants both challenge the award on the ground of negligence as well as quantum. Next one. Shri Janardhan Reddy, lawyer counsel, appearing for the insurer, reiterating the grounds of charges, submits that claimant's own documents show that it was the deceased was only responsible for the accident. He further submits that there was the future prospects considered by the tribunal is on the higher side. further submits that there was breach of policy condition as the vehicle had operated in deviation of the permit. Therefore, the tribunal should have exonerated the insurer of its liability. For contrast, she so and so lower counsel for the claimant submits that the tribunal was in error in holding that the deceased contributed for the negligence for the accident. He further submits that ಅವ್ರು justify ಮಾಡ್ತಾರೆ ಉಳಿದಿದ್ದನ್ನು. He is not on the ಅವ್ರ quantum ಯಾವುದೋ ಒಂದು ಅವ್ರಿಗೆ ಕೇಳಿದ್ರಲ್ಲ ಅವ್ರ ಇನ್ಕಮ್ ಅಷ್ಟು the assessment of the income of the deceased by the tribunal was erroneous. The tribunal should have taken the income as per the salary slips produced by the claimants. Thus, he seeks enhancement of the compensation. So far as the liability of the insurer, he submits that the charge sheet was not filed regarding the violation of any terms of the policy conditions or motor vehicles act. And such violation of permit was not proved. Therefore, the insurer is liable to pay the compensation. Next paragraph. Regarding occurrence of the accident. On hearing both sides and on perusal of the records, the points that arise for determination of consideration are: number one, whether the finding of the tribunal that the accident occurred due to the contributory negligence of the driver of the lorry and the deceased at the rate of 75% and 25% suffers any illegality. Number two, whether the compensation awarded is just and fair one. Next one, regarding negligence. So, both sides do not dispute the occurrence of the accident. The PW1, the first claimant was not the eyewitness to the incident. PW3 and 4, though were examined as eyewitnesses, as rightly observed by the tribunal, they were neither the complainants nor charge sheet is exhibit P5. Charge sheet is exhibit P7. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲೂ ಸೈಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ, ಕರೆಕ್ಟಾ? ನೇತ್ರಾವತಿ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ, ಸಿಸ್ಟರ್ ಇರ್ಬೇಕು ನಾನು ರೇಷನ್ ಕಾರ್ಡ್ ಅದ್ರಲ್ಲಿ ನೇತ್ರಾವತಿ ಅನ್ನೋ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟರು ಅಂತ ಇದೆಯಲ್ಲ, ನೇತ್ರಾವತಿ ಅನ್ನೋ ಹೆಸರು ತೋರಿಸಿದ್ದಾರೆ. ಕುಟುಂಬದ ಸದಸ್ಯರ ವಿವರಗಳು ಅಂತ ನಾರಾಯಣ್ ರೆಡ್ಡಿ ಜಯಮ್ಮ ಅಲ್ವಾ ಇವರಿಬ್ರು? ಮತ್ತೆ ಅವ್ರ ರೇಷನ್ ಕಾರ್ಡ್ ಅಲ್ಲಿ ಆ ನೇತ್ರಾವತಿ ಅಂತ ಬೇರೆ ಯಾರು ಅಂತ ಸರ್, ಅಂದ್ರೆ ಆದಿನಾರಾಯಣ ರೆಡ್ಡಿ ಅಂಡ್ ಶಿವರತ್ನಮ್ಮ. ಪ್ರಾಬಬ್ಲಿ ಟೂ ವೈವ್ಸ್ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಈಗ ಫಸ್ಟ್ ಕ್ಲೇಮೆಂಟ್ ಈಕೆ ಮಕ್ಕಳು ರೇಷನ್ ಕಾರ್ಡ್ ಅಲ್ಲಿ 2 persons, one ಶಿವರತ್ನಮ್ಮ is also shown as wife. ಆಮೇಲೆ ಬೇರೆ ಮಕ್ಕಳು ನೇತ್ರಾವತಿ, ಮೋಹನ್ ಎಕ್ಸಿಟ್ರಾ ಅಂತ ಕೊಡ್ತಿದ್ದಾರೆ. ನೋಡಕ್ಕೆ ಜನ ಸಿಕ್ತು. ರವಿಕುಮಾರ್ ಅಂಡ್ ರಾಮರಾಜ್ ಅಲ್ಲ, ರವಿಕುಮಾರ್ ಅಂಡ್ ರಾಮರಾಜ್. ರವಿಕುಮಾರ್ ತೋರಿಸಿದಾರಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲ. ರವಿಕುಮಾರ್ ಸನ್ ಆಫ್ ಗೋವಿಂದ್ ರೆಡ್ಡಿ, ಇನ್ನೊಬ್ರು ರಾಮರಾಜ್. ಇದು ಚಾರ್ಜ್ ಶೀಟ್ ಅರ್ಧ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಕಾಣ್ತದೆ. ಪೂರ್ತಿ ಹಾಕಿಲ್ಲ ನಾನು, ಬರೀ 7 ಜನರಿಗೆ ಮುಗೀತು ಅಥವಾ ಇಷ್ಟ. ಒಳ್ಳೆ ಈ ರವಿಕುಮಾರಿನ ಇನ್ನೊಬ್ರು ಯಾರೋ ಗೊತ್ತಿಲ್ಲ. ರವಿಕುಮಾರ್ ಅನ್ನೋರು ಒಬ್ಬರನ್ನ ತೋರಿಸಿದ್ದಾರೆ. ವಾಟ್ ಇಸ್ ಹಿಸ್ ಫಾದರ್ಸ್ ನೇಮ್? ರವಿಕುಮಾರ್ ಫಾದರ್ಸ್ ಅಲ್ಲ, ಡಿಪೋಷನ್ ಅಲ್ಲಿ ರವಿಕುಮಾರ್ ಅಂಡ್ ರಾಮರಾಜ್. ರಾಮರಾಜ್ ಇಸ್ ನಾಟ್ ದ ಚಾರ್ಜ್ ಶೀಟ್ ವಿಟ್ನೆಸ್. PW ಎಷ್ಟು? P ಅಲ್ಲ, ರವಿಕುಮಾರ್ ಗೋವಿಂದ ರೆಡ್ಡಿ. ಇಲ್ಲಿರೋ ರವಿಕುಮಾರ್ ತಂದೆ ಹೆಸರು ಗೋವಿಂದ ರೆಡ್ಡಿ. ಕರೆಕ್ಟ್.
PWs 2 and 4, though were examined as eyewitnesses, as rightly observed by the
They
tribunal,
were,
they were neither complainants.
they were not the complainants. They were not the complainants. PW4 was not even the charge sheet witness. However, the charge sheet exhibit P7, on investigation, charge sheet exhibit P7 was filed against the driver of the lorry. The coordinate bench of judgment Veerappa, the coordinate bench of this court in Veerappa versus Illa 2004 Karnataka has held that charge sheet is not the conclusive proof of the negligence in the proceedings under section 166 of the Motor Vehicles Act, and the court has to examine the same with reference to the other evidence adduced by the parties. In this case, exhibit P2, the sketch of scene of the accident produced by Veerappa and Andar versus Siddhappa and Andar, ILR 2009 Karnataka 3560. Exhibit P2, the sketch of scene of accident produced by the claimants themselves show that the accident took place in a junction. It further shows that the lorry was crossing the road in the junction, and deceased was coming on the main road. At the fag end of the when the lorry driver had reached almost the border of the road, while crossing the road, the accident has taken place. Considering the same, the tribunal has rightly held that both deceased and the driver of the lorry have contributed for the occurrence of the accident. The tribunal, since the lorry was crossing the road, the driver of the lorry should have been more vigilant and watchful in the vehicles crossing the road. Therefore, the tribunal has rightly apportioned contributory negligence to him at 75%. The said finding does not suffer any illegality. Next, regarding quantum methods. Regarding quantum, exhibit P10, the SSLC marks card of the deceased showed his date of birth as page number. Page number 13/6/1986. The accident took place on 19/2/2012. Therefore, the tribunal rightly considered his age as 26 years as on the date of the accident. The claimants, to substantiate their contention that the deceased was working with AstraZeneca company as territory manager, AstraZeneca Pharma India Limited. Examined PW2 and produced his salary slips. Exhibit P10, P9, sorry, P9 and P20. They also produced exhibit P8, the appointment confirmation letter, exhibit P11, his PAN card, exhibit P17, the appointment letter, exhibit P18, the service confirmation letter, and P19, the application for employment. Those documents coupled with the evidence of PW2. What is his designation, PW2? The manager of the employer company. Manager of AstraZeneca Pharma Limited, Pharma India Limited. Showed that he was working as territorial business manager in the said company since 7/4/2021, 2011 till his death, and drawing salary of rupees on the last drawn salary, na? 32,436, and his last drawn salary was 32,000, and he was drawing on the 32,436. The salary slips showed that the income was variable and that included incentives also. Therefore, the tribunal rightly took the average of 8 months salary as his consistent salary at rupees 31,000 per month. 31,000 per month. The deceased was, the tribunal added 50% to the said income by way of future prospects. The records show that the deceased was employed in private sector in the organization. There was nothing to show that it was a permanent job. Therefore, in view of the judgment of the Supreme Court in Pranay Sethi's case, National Insurance Company Limited versus Pranay Sethi, citation according, the tribunal should have taken the future prospects at 40%. 40%. Since the deceased was bachelor, 50% of his income has to be deducted for his personal expenses. Therefore, annual income of the deceased at rupees 31,000 per month after deducting 10% tax comes to rupees 3,59,800. On deducting 50% for his personal expenses, his annual income comes to 1,79,900. 40% of the same comes to rupees 79,960, which is payable on the head of future prospects. Therefore, his annual income comes to 1,79,900 plus 71,960, 2,51,860. The applicable multiplier was 17. Therefore, damages on the head of loss of dependency comes to 2,51,860 into 17, 42,81,620. As per the judgment of the Supreme Court in Pranay Sethi's case, referred to Supra, each of the claimant are entitled to compensation at the rate of 40,000 on the head of a consortium, with escalation at 10% for every 3 years. 3 years. Similarly, on the conventional heads of funeral expenses and loss of estate, they are entitled to compensation of 15,000 plus 15,000 with escalation at 10% for every 3 years. Therefore, compensation payable on the head of consortium comes to 48,000 into 2, 96,000. On conventional heads of funeral expenses and loss of estate, 30,000. 36,000. 33,000 plus. No, 15,000 ಹಾಗಲ್ವಾ 30,000 plus 6,000, 30,000 plus 6,000, 36,000. Therefore, the total damages on account of the death of the deceased is as follows: loss of dependency 42,81,620, consortium 96,000, conventional heads ಅದರ ಕೆಳಗಡೆ ಮತ್ತೆ ಬರ್ಕೊಳ್ಳಿ ನಿಮ್ಗೆ loss of estate and funeral expenses 36,000, total 44,13,620. After deducting 25% towards the negligence of the deceased himself, 75% of rupees 44,13,620 comes to rupees 33,10,215. Okay. A liability ಮೇಲೆ ಒಂದು ಪಾಯಿಂಟ್ ಮಾಡಲಿಲ್ಲ 3 ಪಾಯಿಂಟ್ಸ್ ರಿಗಾರ್ಡಿಂಗ್ ಲಯಬಿಲಿಟಿ ಅಂತ ಬರ್ಕೊಳ್ಳೋಣ. ರಿಗಾರ್ಡಿಂಗ್ the insurer contended that the vehicle operated in Bangalore in Karnataka state, whereas the permit was issued only to operate in Tamil Nadu. To substantiate the said contention, the insurer relied on the evidence of RW1 and exhibit R2. But exhibit R2 says that in exhibit R2, the condition with regard to route permit is as follows. Ali route area for which permit is valid anta hakondi, inverted comma alli hakondi. Route area for which permit is valid dash hakondo all routes except those prohibited. The claimant did not, the insurer did not examine the Regional Transport Authority who issued exhibit R2 to show whether Karnataka route was the prohibited route. Therefore, there was nothing to show that Karnataka, Bangalore where the accident took place was within the prohibited route. Considering the non-examination of such material witness, the tribunal rightly held that the contention of the insurer with regard to breach of permit condition was not proved and fastened the liability to the insurer. That finding does not warrant any interference. Next. In the light of the above discussion, both the appeals, ಅವ್ರ ಪಾಟ್ಲಿ ಎಲ್ಲೋ ಹೋಗೋದಿಲ್ಲ, ನಿಮ್ದೊಂದೇ ಪಾಟ್ಲಿ, ಅವ್ರದ್ದು ಪಾಟ್ಲಿನೇ ಅಲ್ಲ, ಯಾಕಂದ್ರೆ 96,000 36,000 ಅಲ್ಲ, ಅವ್ರಿಗೆ ಅಲ್ಲಿ 1 lakh ಕೊಟ್ಟಿದ್ರು, ಅದಕ್ಕೆ 96 ಅಲ್ಲ. ಅದರ ದೇರ್ ಅಪೀಲ್ ಎಲ್ಲಿದೆ ಅದು ದಿಸ್ ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅಪೀಲ್ ಅಲ್ಲ ಹೋಗ್ಬೇಕಾಗತ್ತೆ, ಯಾಕಂದ್ರೆ ಫಿನರಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಬರೀ 10,000 ಕೊಟ್ಟಿದ್ದಾರೆ, 10,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಬರೀ. In the letter about discussions, both the appeals deserve to be allowed in part, hence the following order. The appeals are partly allowed. The impugned award is modified as follows. The claimants are entitled to compensation of rupees 33,10,215 payable by respondent number 2, respondent number 1, the insurer. Respondent number 1 shall deposit the said amount before the tribunal on adjusting the amount deposited, if any, already deposited if any, within 4 weeks from the date of the receipt of the copy of this award. The order of the tribunal with regard to apportionment of the compensation and ಇದು 2012 the release ಮಾಡೋದಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡೋಣಲ್ಲ ಅದೇ ವಯಸ್ಸಾದವ್ರಿಗೆ. The order of the tribunal with apportionment is maintained on the deposit of the amount. The tribunal shall release the amount to the claimants according to the said ratio. Transmit the TCRs and amount in deposit if any to the tribunal forthwith. ಒಂದು ನಿಮಿಷ ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲೇ ಬರೀಬೇಕಾಗುತ್ತೆ. ಕೃಷ್ಣಸ್ವಾಮಿ ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರ್ತಾರೆ. ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರ ಹೆಸರು ಅವಾರ್ಡ್ ಅಲ್ಲೂ ತೋರಿಸ್ತೀನಿ. Since Shri Janardhan Reddy 5.1 and Janardhan Reddy has filed Wakalat not filed has filed the connected appeal. Registry shall not show the name of A.N. Krishnaswamy for respond number 1 and only show the name of Janardhan Reddy for respond.
Number 6, actions, number 7, Maranathan.
My lords, we have taken time in the morning, my lords. I appeal for the appellants.
Yes, wait. Response counsel is also present. He has moved the matter. Yes. Here. Just come. ಇದರಲ್ಲಿ ಏನ್ ಸಬ್ಸ್ಟಾನ್ಶಿಯಲ್ ಕ್ವಶನ್ ಅದೇ employment. Whether learned trial judge was justified to compute the compensation basing its calculation on monthly wage of 21,080 and not rupees 8,000 as determined by the central government notification dated. So this is the only substantial question.
Please, my lord.
We have to hear you only on this point. Why do you want time?
My lord, just 2 weeks, my lord. We'll just place some authorities, or it may be at next week.
2 weeks will not grant.
Next week, my lord.
And it's a case of death. Parents idare anta consider.
Parents have been implicated, my lords.
Right.
My lords, just for today, my lords.
2 ವಾರ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಅದಕ್ಕೆ
My lords, any my lords, next week.
ಕೆಲಸ ಮಾಡ್ತೀವಿ ಅವ್ರಿಗೆ ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ then we'll grant 2 weeks adjournment.
My lords, any date next week or my lords, one because we have to place some authorities. Already they're getting interest amounts, so I request for one accommodation. Today there's an
Hand in hand work interest value bank account ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಆಗ್ತಾ ಇದ್ರೆ.
I understand. My lords, one accommodation today I request for.
2016 matter, original proceedings, case of a death of a lineman. 2014 and welfare legislation.
My lords, one accommodation, my lords, I request for today. Kindly permit my request, my lords.
Share ಮಾಡೋಣ ಒಂದು ಇವಾಗ ಯಾವತ್ತು ಡೇಟ್ ಹೇಳಿ ಒಂದು next week ಅಲ್ಲಿ. Will not grant any further adjournment.
Please, my lords.
You are there on record since 2016.
Please, my lord.
Do you want time to collect the citations and submit?
I apologize, my lord.
No, you not trial court ಅಲ್ಲಿ ಇವ್ರು ಇರ್ಲಿಲ್ವಾ? Lawyer counsel for the appellant seeks adjournment. Lawyer counsel for the respondent opposes the adjournment. There are 2 minors also. The original proceedings. This is a case involving death of a lineman. There are 2 minors. Lineman due to electrocution. There are 2 minors in the case. However, to grant one opportunity, adjournment is granted as a last chance. list on 28-6.
Please, madam. Grateful.
Number 8, Adil Committee, C. Babu.
My lordship, I represent the appellant in 8.4 and 8.5, my lord. In this, I just seek short adjournment because there is a proposal of settlement in the award. It's only a death of a son, brother and father of our appellant. In that, it has to be sharing has to be done within the family, and the quantum what it's been awarded for the appellant is very meager amount. But however, the other respondents have come forward for some kind of settlement.
Correct, but insurance has also preferred appeal.
Please, my lord. Please, my lord.
This, some compliance of office objections raised on the memo dated 4/3/2019 for return of TCR. 2019 in the pending ಇದೆ. The PF and acknowledgement correct address issue notice to R4 for the second time. Non-filing of acknowledgement copy and the counsel for respondent. Yes, Mahesh, O Mahesh or Idral Avag. He is there. Mr. O Mahesh.
O Mahesh.
Copy serve ಮಾಡಿದಾರ.
Yes, my lord.
Copies are served in 8.4 on you.
Which one, my lord?
8.4, MFA 2102 of 2016. Office objection is that copies are not served. You represent the insurer in that case. You have two appeals at 8.1 and 8.2 are your appeals.
Serial number, my lord?
Serial number 8.
8.
In 8.4, there is office objection that copies are not served. Whether they have served the copies on you.
No, my lord.
Ravi.
My lord, we have served the copy. If need by today itself, I'll see that within 1 or 2 days it will be served.
What about R4? Who is R4? Kodi adana off file. 8.4.
Service has to be, my lord. R4 for the second time they have to take steps.
ನೋಡ್ತೀವಿ ಇವಾಗ ಮೆಮೊ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತಿದ್ದಾರೆ ರಿಟರ್ನ್ ಆಫ್ TCR ಮತ್ತೆ ಒಬ್ಬರದ ಕಾಪಿ ನೋಟಿಸ್ ಹೋಗೋದಕ್ಕೆ ನಿಂತ್ರೆ who is R4 in that?
R4 1 Soumya.
All other appeals will also be delayed. R4 is respondent number 2. Claimant number 2 now. I go to trial court.
So Soumya is that, my lord. Soumya is the one of the petitioner, earlier petitioner, who is also a sister of appellant, my lord. I'll see that it will be served on our rolls.
Well, you see that somebody appears for her, otherwise.
In fact, she is the one who has proposed for a settlement along with the mother now.
She is appearing in other cases. ನೋಡೋಣ ತಗೊಳ್ಳಿ ಅವರಿಗೆ ನೋಟಿಸ್ ಕೊಡೋದಕ್ಕೆ ತಗೊಳ್ಳೋಕೆ ಡೈರೆಕ್ಷನ್ ಕೊಡಿ. Do you represent her in the other connected cases? First appeal 8.1 ಅಲ್ಲ 8 ಅಲ್ಲಿ. You represent her?
In MFA 2103 of 2016, I had to be served with a copy.
ಒಂದು ನಿಮಿಷ ಕೊಡ್ತಾರಂತ ಹೇಳಿ. ಪೇಪರೇ ಹರಿದು ಹೋಗಿದೆ. ಯಾರ್ ತಾಯಿ? No, in that MFA, Soumya is the second appellant in that case, 2057. Mahadev Swami.
Mahadev Swami is appearing. One Mr. Mahadev Swami is appearing.
ಅಂತ ಹೇಳಿ ಇದರಲ್ಲಿ 8.4 ಅಲ್ಲಿ.
Please, my lord. Please, my lord. In fact, I will serve on her only, as well as I will send it across to my learned friend's office also.
Non-filing. ನೀವು ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀರಾ ಇನ್ಶೂರರ್? That is the office objection. 8.2 ನಲ್ಲಿ since the matter is listed for final hearing and the old one at this stage TCS cannot be sent back. The memo is disposed of accordingly. ಆಮೇಲೆ 8.4 ನಲ್ಲಿ respond the 4 in this case is appellant number 2 in MFA number 2057 of 2016. Mahadev Swami ಅವ್ರು ನೀವೇನಾ? ಆ ನೋಟಿಸ್ ತಗೊಳ್ಳಿ ಸೌಮ್ಯ ಅನ್ನೋರ್ಗೆ ಇದರಲ್ಲಿ 8.4 ಅಲ್ಲಿ. He undertakes to appear for her in this case also. He is permitted to file the wakalat in the registry within 1 week. Within 1 week. Appellant's counsel shall serve the copies on him or
Please,
copies
Please, madam.
on him and the counsel for respond number 2, respond number 1 copies ಅವ್ರಿಗೂ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ. Who is this C Babu? R2 ಗತಿ ಆಗ್ತದೆ. ಈಗ ಇದು 8.5 ನಲ್ಲಿ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ? 8.5 etc. to issue notice to R4. Who is the R4 in that case? 2103. ಅದ್ರಲ್ಲೇನು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಇದೆ ನೋಡಿ. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ಅದ್ರಲ್ಲೇನು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬಂದ್ಮೇಲೆ ಇವನ್ನೆಲ್ಲ ಓನರಲ್ಲ ಒಬ್ರು ಲೇಡಿ ಅವ್ರಿಗೆ ದೇರ್ ಇಸ್ ರೈವಲ್ ಕ್ಲೈಮ್ಸ್ ಇಟ್ ಸೀಮ್ಸ್ ನಿಮ್ಮಲ್ಲೇ ನಿಮ್ಗೆ ಹಂಗಂದ್ರೆ ಅದು 8.2 ಒಟ್ಟಿಗೆ ತಗೊಂಡ್ಬಿಡಿ. 8.4 and 8.5 ಎರಡಕ್ಕೂ she is respond number 4 in both the cases. ಅದಕ್ಕೆ respond number 4 in these cases. In these cases is appellant number 2 in MFA number 2057 of 2016. T. Mahadeva Swami P. Lawyer counsel who represents her in the said appeal undertakes to file wakalat for her in these cases also. He is permitted to file the wakalat in the registry within 1 week. The office of sections in that regard should comply. Lawyer counsel for the appellant shall serve the copies on the other side within 1 week. List on 1 ವಾರ ಆದ ತಕ್ಷಣ ಇರ್ತೀವಿ.
Great. Great.
As requested list on.
Please, madam.
ಹೋಯ್ತು ನೋಡಿ 5 ಕೇಸಸ್. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ರೆಡಿ ಆಗಿ ಎಲ್ಲಾನು ಮುಗಿಸಿ ಅವ್ರ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ಇವ್ರಿಗೆ.
ಆಯ್ತು.
ಮಹೇಶ್ ಅವರು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ.
ಆಯ್ತು.
ಇಲ್ಲ ಅದಕ್ಕೆ ಅವತ್ತಿಗೆ ಪೋಸ್ಟ್ ಆಗುತ್ತೆ ಅಲ್ಲ. all the matters get listed on the same day to 30th. 28 not 30th 28/6.
Please.
ಏನು settlement ಅಂತ ಹೇಳ್ತಾರೆ.
Number 9, Sandeep PL, P. Shankar Reddy.
The appellant in this matter, my lord.
For additional documents.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ my lord, once round of litigation was over, my lord, it was remanded back to the tribunal. Later, my lord, the tribunal has considered only the petitioner evidence, my lord. They have not given a chance for us to adduce evidence. And
Who had prevented
ordered some of my lord.
Who had prevented you?
No, it was filed for, it was posted for judgment because I had not got an opportunity, my lord.
Right, why did you not get opportunity?
The tribunal said, my lord, the High Court has only said that to look into only the petitioner's documents, my lord. That has been recorded in the tribunal judgment, my lord.
In the judgment?
Yes, my lord. Page 13, my lord, para 10.
Internal page or?
Internal page 7, my lord, of the judgment. Para 10, my lord.
As per the direction of the High Court. Yes,
as per the direction of the Honorable, he has adduced further evidence and got marked the salary details of the deceased person, Exhibit P18. Further, he has got examined one Suresh M. PW2 who has stated in his affidavit that deceased Kantaraja was working under him.
No. See, read on page number 8. On the other hand, even after grant of sufficient opportunity, respondent has not adduced any evidence on their behalf.
My lord,
Tribunal had not prevented you. You did not adduce the evidence.
my lord, what has happened, my lord? We had got a document, my lord, to show that he was not working under GKVK, my lord. I have produced those documents.
Correct. Who prevented you before the trial court? PW2 was
I had also.
See, you are blaming the tribunal.
No, I am not blaming. I am not blaming the tribunal.
You said
I'm sorry, my lord. I am not
interpreted the High Court's order in
on the 11th paragraph, my lord. I am sorry, my lord. I am not blaming them, my lord. My mistake. I had not gone through it. My lord, additional document page 21.
He was examined on 23/12/2015 PW2. We'll see thereafter how much time was given to you. 23/12/2015. 23. Advocate for responding present. PW closed in full. PW cross examined in full. No further evidence. Respondents evidence ಅಂತ ಆಮೇಲೆ 9-1 ಗೆ ಹಾಕಿದ್ರು 9-1 ಅದಾದ್ಮೇಲೆ ಅದೇ ಟ್ರಾನ್ಸ್ಫರ್ ಆಯ್ತು ಬೇರೆ ಕೋರ್ಟಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಟು CH-9 23 ಅಲ್ಲಿ 4 advocate for respondent absent. Advocate for respondent absent. Respondent's evidence taken as nil on 4/1/2016. ಮತ್ತೆ 5/1/2016 advocate ಅದೇನು handwriting ಅರ್ಥ ಆಗೋದಿಲ್ಲ advocate respondent not present. See, from 4/1/2016 till 8/1/2016, there were three adjournments. He had not appeared before the court at all.
Lord, there was some misunderstanding, my lord, in my colleagues. I will just see, my lord, only one document, my lord sees.
Let you argue now. If additional evidence is required, we'll.
Yes, my lord. My lord, the case of the petitioner is this, my lord, that on 16/7/2012 at 6 p.m. before Big Bazaar to west of Quad Road, he was riding a motorcycle, my lord, and the bus has dashed him. My lord, I am only on the contempt, my lord. The petitioner says, my lord, he was working with GKVK.
Petitioner, there are so many persons.
Petitioner's LR son, my lord, first petitioner. That is
A case of death.
case of death, my lord.
Yes.
My lord, he was working at under the para 11, my lord. May I read para 11, my lord?
Yes.
On considering the oral or documentary evidence, it is pertinent to me to note that this court, per the directions of this honorable court, this court has to give findings for the limited purpose of compensation liable to be paid by the respondent to the petition. On perusal of Exhibit P18, which is the salary details issued by the Soil Science Department GKVK, it is observed that the salary drawn by the deceased person when he attended his work was 6,000 per month. Further, the evidence of PW2, which has not been contradicted by the respondent, no rebuttal evidence is placed before this court. As such, it can be safely said that the deceased person was being paid ₹5,000 by PW2, under whom he was doing a part-time job. As such, the total monthly income of the deceased person comes to ₹11,000.
So 6,000 from GKVK and 5,000 from PW2. Who was PW2? No, what kind of employment? ಏನಂತ ಕೆಲಸ ಏನು ನೇಚರ್ ಆಫ್ ವರ್ಕ್ ಆಯ್ತು ಮುಂದೆ ಓದಿ ರೆಸ್ಟ್ ಆಫ್ ಇಟ್ ಅಬೌಟ್ ಡಿಡಕ್ಷನ್ ಎಟ್ಸೆಟ್ರಾ ರೆಸ್ಟ್ ಆಫ್ ಇಟ್ ವಾಸ್ ಅಬೌಟ್ ಡಿಡಕ್ಷನ್ yes what is the error in this
GKVK, my lord, GKVK has given an document. My additional documents, my lord, may I request the lords to turn to number 21.
21 GKVK is
received a sum of so and so from the project leader so and so Bangalore, being the salary towards work on contract basis as laboratory assistant in the Department of Soil Science and Agricultural Chemistry for month of Jan 2012. So 18/1/2012 to 31/1/2012 for 14 days. Contract period is from 18/2/2012 to 14/7/2012, my lord. The accident has happened on 16/7/2012.
16/7
2012, my lord. After
so his contract period was 18/1/2012 to
18/2/2012 to 14/7/2012. That is 179 days. My lord, the accident has happened on 16/12, my lord. On the date of accident, he was not working with GKVK.
Even otherwise, in 2000, yeah, notional income was 7,000.
7,000, but they've taken 11,000 rupees, my lord. Issue number 1. At paras-
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಎಲ್ಲ ಸೇರಿಸ್ಬೇಕಾಗುತ್ತಲ್ಲ ಅದಕ್ಕೆ.
ಅಲ್ಲ ಇಲ್ಲಿ 13 ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಪ್ಯಾರಾ 13 ಅಲ್ಲಿ
There is the previous order, what was previous?
previous order, my lord, previous order is at 7775, my lord.
They are produced along with this.
No, I have not produced that document, my lord.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇರ್ಬೋದು, ನೋಡ್ತೀವಿ. ಡಿಗ್ರಿ BSc ಅಗ್ರಿನಾ? No, what was his qualification?
Qualification is BA degree and computer training and lab assistant. GKVK and even then you to go to.
ಕಂಪ್ಯೂಟರ್ ಸಾಯಿಲ್ ಟೆಸ್ಟ್ ಮಾಡ್ತಾರ, ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಸಾಯಿಲ್ ಟೆಸ್ಟ್ ಮಾಡ್ತಾರ.
Lab assistant, soil science department and was also working as supervisor.
Whom did you examine to prove his employment? With GKVK?
GKVK ಮಾಡಿದ, it was the private employment.
So I have not examined the GKVK.
Certificate not valid.
This is 7775 and 2717 ಅಂತ ಆಗಿದೆ.
Yes.
ಒಂದ್ ನಿಮಿಷ, ಅಲ್ಲೇನಿತ್ತು ನೋಡೋಣ, ಅರ್ಲಿಯರ್ ಜಡ್ಜ್ಮೆಂಟ್.
GKVK document ಹಾಕಿರ್ಲಿಲ್ಲ ಅಂತ it was reversed back.
Deceased had done Bachelor of Arts from University of Bangalore, lab assistant in GKVK attached to University of Sciences. Salary of 6,000 per month. Election was working as supervising the earth moving machine. A private business company and drawing this 5,000 per month. He was not a mechanical diploma holder also. ಒಂದು ಅವರು BA ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತೀರಿ, ಸಾಯಿಲ್ ಟೆಸ್ಟಿಂಗ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಿದ್ರು ಅಂತ ಹೇಳ್ತೀರ. ನೋಡೋಣ, ಎವಿಡೆನ್ಸ್ ನೋಡ್ತಿದ್ವಿ. See, you have to satisfy the court, not the other side. We'll examine that. No, we'll examine that. Just we are making this observation. Produced. He submits that though the claimants have produced salary certificate issued by GKVK well before the pronouncement of the impugned judgment, work of lab assistant at GKVK attached to University of Agricultural Sciences, Tribunal has committed error in not taking the same into consideration, assessing rupees 5,000 per month instead of 11,000. Lab assistant GKVK, it's a private business concern. ಇದೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಯ್ತು. Admittedly, claimants have not produced the salary certificate stated to have been issued by GKVK at the time of trial, and it was not marked as exhibit, and further no person from GKVK was examined to show that deceased was working as lab assistant in GKVK and drawing salary of 6,000 per month. Even though the claimants have not examined the author of exhibit P11, the tribunal, considering the age of the deceased, his employment, etc., considered he assessed his income at 5,000 per month. In appeal, an attempt is being made. He produced salary certificates stated to have been issued by GKVK. Since KSRTC does not agree for marking of the certificate by consent, it cannot be relied upon, and income mentioned in the said salary certificate cannot be taken into consideration. At the same time, deduction of 1/3 of the income of the deceased and multiplier of 17 applied by the tribunal are also under challenge. Therefore, it is just and proper to remand the matter to the tribunal with a direction to reconsider the issue relating quantum of afresh, after giving opportunity to both parties to lead additional evidence without disturbing the finding of the tribunal on negligence and liability. Right? It was remanded only on the point of quantum. This court had This court had observed two things. One is that you have not produced the salary certificate. You have not examined the employer, that is GKVK. ಈಗ ರಿಮೈಂಡ್ ಆದ್ಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರಿ? But author of the document was not examined. Now you are saying that they had not disputed it. We'll see. PW2 examine ಮಾಡಿದ್ರು. No, that document was marked through whom?
PW2 is not that person, my lord. PW2 is a JCB owner.
Corrected. That exhibit, that salary certificate was marked through whom?
By the petitioners only.
Witness recalled. I am today producing the salary certificates of deceased, which is marked at exhibit P18. No representation, cross examination deferred. ಆಮೇಲೆ ಮಾಡಿದಾರಲ್ಲ cross examination. ಇಲ್ಲಿ ಅವನು 5 ವರ್ಷದಿಂದ ಜಿಕೆವಿಕೆಯಲ್ಲಿ ಕೆಲಸಕ್ಕೆ ಹೋಗುತ್ತಿದ್ದ ಎಂದು ತೋರಿಸಲು ದಾಖಲಾತಿಗಳನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಅವನು ಟೆಂಪರರಿಯಾಗಿ ಕೆಲಸಕ್ಕೆ ಸೇರಿದ್ದು ನಂತರ ಕಾಯಂ ಮಾಡುತ್ತಾ ಇದ್ದರು. ನಿಮ್ಮ ಮಗ ಜಿಕೆವಿಕೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿರಲಿಲ್ಲ ಎಂದು ಸೂಚಿಸಿದಾಗ ಸಾಕ್ಷಿಯು ಸರಿಯಲ್ಲ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದಾರಲ್ಲ. ಯು ಸೇಡ್ ಇಟ್ ವಾಸ್ ನಾಟ್ ಡಿನೈಡ್. ಸೊ ನೋಷನಲಿ ತಗೋಬೇಕಾಗತ್ತೆ ಇನ್ಕಮ್. ಎಷ್ಟು ಜನ ಹಿಂಗ್ ಇಂಜಿನಿಯರಿಂಗ್ ಡಿಗ್ರಿ ಮಾಡಿದವ್ರು ಪೋಸ್ಟ್ ಗ್ರಾಜುಯೇಷನ್ ಮಾಡಿದವ್ರು ಗ್ರೂಪ್ ಡಿಗ್ ಹಾಕೊಂಡ್ ಬರ್ತಾರೆ. ಕರೆಕ್ಟ್. ಇವನ್ ಅದ್ರ ಜಿಕೆವಿಕೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅನ್ನೋದ್ರಲ್ಲಿ there is no merit ಅಲ್ವಾ, because you are not examined despite this court observing that you have not examined that employer. So your grievance is only to that extent. GKVK
Yes, my
income
lord.
consider ಮಾಡಿರೋದು.
Only.
ಅದು ಬಿಟ್ಟರೆ 5,000 ಇರುತ್ತೆ. ಅದ್ರ will not consider 5,000 because it was in 2012. 7,000
Yes,
ಮಾಡಿ ಇದು ಕೊಡ್ಬೇಕಾಗುತ್ತೆ. What is that? 7,000 and future prospects. ಅದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ future prospects ಟ್ರಿಬ್ಯುನಲ್.
5,000.
Future prospects private employment ಅಂತ ತಗೊಂಡ್ರೆ 30%. Below 40 years. His age was ಎಷ್ಟು?
29 years.
29 years. 40%, 7,000, 40%. Married or unmarried?
1,800.
Married or unmarried?
Unmarried.
Unmarried. 7,000, 40%, 2,800. So 9,800 ಆಗುತ್ತೆ. 9,800 divided by 2. 4,900 into 12 into multiplier 31 years. 29 years. Hello? There is no dispute with regard to age.
No.
What is the multiplier applicable? 29, 17.
17.
Into 17 ಮಾಡಿ. 4,900 into 12 into 17.
9,99,600.
9,99,600. How much is awarded by the tribunal on the head of loss of dependency? 16,83,000 ಮಾಡಿದ್ದಾರೆ. ಬೇರೆ ಕಡೆ ಮೇಕಪ್ ಆಗುತ್ತೆ. ದೇ ಆರ್ ಪೇರೆಂಟ್ಸ್ ಮತ್ತೆ ಸಿಸ್ಟರ್, ಇಬ್ರು ಸಿಸ್ಟರ್ಸ್. ಶ್ಯಾಮಲಾ CN ಅವ್ರೇನು ಅವ್ರ ದೇವರ ಎಕ್ಸಾಮಿಂಗ್ ಮ್ಯಾರಿಡ್ ಆರ್ ಅನ್ಮ್ಯಾರಿಡ್? ಅವ್ರಿಗೆ ಎಲ್ಲರಿಗೂ ಹಾಗಿದ್ರೆ 40,000 ಈಚ್ ಕೊಡ್ಬೇಕಾಗತ್ತೆ ವಿತ್ ಎಸ್ಕಲೇಷನ್. 44,000 ಇಂಟು ಎಷ್ಟವರು 5 ಅಲ್ವಾ? 5 ಎಷ್ಟಾಗುತ್ತೆ ನೋಡಿ. 44 into 5 2,20,000. Then 33,000. $1,52,600. ಟೋಟಲ್ ಅಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 17 lakhs. ರೆಡ್ಯೂಸ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ. ರೆಡ್ಯೂಸ್ ಆಗುತ್ತೆ. See, now we are awarding more on the head of consortium. ಅದು ಅಲ್ಲಿಗೆ ಬಂತು.
Moreover, I have also not examined RW2, my lord.
We are not finding any ground to grant you opportunity because we are holding that GKVK person was not examined, therefore that income was not put. But still we have to take notional income for that year.
7,000.
And also lab technician and lab assistant and also computer training.
ಆಯ್ತು, ತೋರಿಸಿ ಎಲ್ಲರೂ ಯಾವ್ದಾದ್ರು ಕೋರ್ಟಲ್ಲಿ ಈ ತರ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಇದ್ದವ್ರಿಗೆ ಹೆಚ್ಚಿಗೆ ತಗೊಂಡಿದ್ರೆ ವಿಲ್ ಕನ್ಸಿಡರ್ ದಟ್. ಆಯ್ತು, ನಿಮ್ಮ ಸಬ್ಮಿಷನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ತೀವಿ. ಬಟ್ ಯು ಶೋ ಅಸ್ ಇಫ್ ಎನಿ ಅದರ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟೇಕನ್. What is the business for remand? It's not a right matter of course or matter of right.
I'll ask,
Who prevented you to from doing that?
actually,
This is not a shuttlecock here. ನೋಡಿ ಏನ್ ಲಾ ಇರುತ್ತೆ ಏನ್ ಜಸ್ಟಿಸ್ ಇರುತ್ತೆ ಅದ್ರ ಪ್ರಕಾರ ಮಾಡ್ಬೇಕು. ಒಂದು ಮೋಟರ್ ಆಕ್ಸಿಡೆಂಟ್ ಕೇಸ್ ಬಂದ್ರೆ ಒಂದ್ 4 ಎಂಪ್ಲಾಯರ್ಸ್ ಬರ್ತಾರೆ ಅವರು. And you don't choose to examine them. And we understand ಹೌದು ಡಿಗ್ರಿ ಆಗಿರುತ್ತೆ ಆದ್ರೆ ನೀವೇ ನೋಡ್ಕೊಳ್ಳಿ ಈಗ ಅಷ್ಟು ಡಿಗ್ರಿ ಆದವ್ರಿಗೆ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಪ್ರಾಬ್ಲಮ್ ಹೇಗಿರುತ್ತೆ ಬಟ್ ಸ್ಟಿಲ್ we are taking that notional income and we are awarding on the head of this consortium this future prospects ಕೊಡ್ತಾ ಇದೀವಿ consortium ಎಲ್ಲ ಟ್ರಯಲ್ ಕೊಟ್ಟಿರೋಕ್ಕಿಂತ ಜಾಸ್ತಿ ಕೊಡ್ತಾ ಇದೀವಿ ಈಗ. Whether compensation awarded to the claimants under the included award is just is the question involved in this case. Respondent response 1 to 5 KSRTC response where claimants 1 to 5 in MEC number 5846 of 2012 and the appellant was a respondent in the same case. On the file of 21st additional small cash court and MACT Bangalore. For the purpose of convenience, the parties will be referred to according to their ranks before the trial tribunal. Please take your seat. Claimants 1 and 2 are the mother and father, and claimants 3 to 5 are the sisters, younger sisters of deceased. What is his name? Kantra CL. On 16/7/2012. At 6 p.m. when Kantrash was proceeding on his motorcycle number K43 K654 in front of Big Bazaar, west of Card Road, Bangalore. The bus bearing registration number K33 F136 hit him. The KSRTC bus hit him and caused the accident. Alle tirogirada. He died on the spot or after? Died on due to the injuries suffered in the accident. He died on the spot. Regarding the incident, on the complaint of one Shivakumar L, Malleshwaram Traffic Police registered FIR as per Exhibit P1 against the driver of the bus for the offences punishable under section 279 and 4A IPC. On conducting the investigation, the driver of the bus was charge sheeted. Sheet copy hakilva illi, but that is not disputed. Sheet copy hakila. The claimants filed MEC number 5846 of 2012, claiming that deceased was working as a lab assistant in science department GKVK and under another private employer and earning rupees 11,000 per month. They further contended that they were solely dependent on his income, and due to his death, they have suffered damages. They had claimed 20,35,000 claim. The at the relevant time, respond also owner of others. Therefore, they claimed compensation of this 20,35,000 from the respondent. The respondent contested the petition, denying the actionable negligence on the part of its driver of its bus, age, occupation, and income of the deceased, and its liability to pay the compensation. Before the tribunal, PW2 ಮೊದಲು examine ಮಾಡಿರ್ಲಿಲ್ವಾ first round ಅಲ್ಲಿ? PW2 first round whether it was examined or not?
No.
The tribunal on recording the evidence of the parties. ನಿಮ್ಮ ಡ್ರೈವರ್ ಅನ್ನು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರು ಅವರು ಫಸ್ಟ್ ಟೈಮ್ ವೆದರ್ had examined the driver at the first instance?
Yes, ma'am. Yes, my lord, I had examined that.
No, number of witnesses none ಅಂತ ಇದೆ.
First time, my lord.
ಅಲ್ಲ ಈಗಲೂ ಕೂಡ none ಅಂತಾನೆ ಇದೆ.
ಈಗ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ಈಗ ಮಾಡಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಫಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದ್ದು ಅದು ಇಟ್ ವಾಸ್ ರಿಮ್ಯಾಂಡೆಡ್ ಅಲ್ವಾ?
Yes, my lord, it was remanded. I don't have the judge. Okay.
They have not examined them. The tribunal on recording the evidence of the parties at the first instance on 31/5/2013 passed the award granting compensation of ₹7,35,000 in favor of the claimants. The claimants and the respondent both challenged that award before this court in MFA number 7775 of 2013, connected with MFA number 2717 of 2014, into bracket ME. This court, by order dated 25/2/2015, allowed those appeals and remanded the matter to the tribunal to reconsider the issue regarding the quantum of compensation after affording opportunity to both the parties to lead evidence. After the matter was remanded, the claimant examined PW2. ಏನೇನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಅವ್ನು ಮೊದಲೇ PW1 ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ. So no documents were already produced. PW2 was examined only to prove them. ಅದೇ ಸುರೇಶ್ ಅಂತ ಕರೆಕ್ಟ್ ಅವ್ರೇನು ಅವರು ಎವಿಡೆನ್ಸ್ ಬರೀ ಓರಲ್ ಎವಿಡೆನ್ಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಮೊದಲೇ ಮಾರ್ಕ್ ಆಗಿತ್ತು. The tribunal again the respondent did not read any evidence from the tribunal. The tribunal on hearing the parties by the impugned award held that impugned award granted compensation of ₹17,48,000 on different heads as per the table below. Page number 16 and internal page 10 ಅಲ್ಲಿ ಹಾಕೊಂಡಿದೆ. The tribunal held that the tribunal and relying on exhibit P18 the salary details held that the deceased was earning ₹6,000 per month from his employment in GKVK and ₹5,000 from his employment under PW2 as a supervisor of JCB. Thus, tribunal assessed his total income at ₹11,000 per month. Added 50% to the same by way of 50% of future prospects. 50% to the same by way of future prospects. Deducted half of the same for his personal expenses. applied a 17 multiplier and awarded compensation of 16,83,000 on the head of loss of dependency. The tribunal in all awarded compensation of 17,48,000 on different heads as per the table below. Next. The respondent had challenged the said award on the ground that that at the time of the accident, the deceased was not working in GKVK. Therefore, the tribunal committed error in considering the income of 6,000 by way of salary of the deceased under the employment of GKVK. ಅದೊಂದೇ ಪಾಯಿಂಟ್ ಅಲ್ವಾ ರೇಸ್ ಮಾಡ್ತಿರೋದು ಈಗ 50%. He further submits that he was not given, the respondent was not given proper opportunity to adduce his evidence. Therefore, the respondent KSRTC has filed IA 3 of 2017 under Order 41 Rule 27 for production of documents and for leave to ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಅದಕ್ಕೊಂದು ಇಂಡೆಕ್ಸ್ ಲಿಸ್ಟ್ ಏನು ಇಲ್ವೇನ್ರಿ?
ಅಲ್ಲ, ಇಲ್ಲಿ ವಿಜಿಲೆನ್ಸ್ ಆಫೀಸರ್ permit to produce enclosed reports of vigilance officer and relevant documents.
Correct. Order 41 Rule 27
List of documents are.
Additional evidence and seek remand of the matter for that purpose. Next. Remand for that purpose. For contrast, he saw and so other person. He further challenges the quantum of compensation. Okay. Per contract, she saw and so other counsel for the claimants submits that despite giving a sufficient opportunity, the respondent did not adduce evidence. He further submits that the deceased was in BA graduate and computer science and undergone training, undergone a certification course in computer application. And he further submits that the salary certificate exhibit P. ಅಲ್ಲ, ಅದು ನಿಮ್ಮ ಸಬ್ಮಿಷನ್ ಅದನ್ನ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿಲ್ಲ ಅವರು ಅಂತ ಹೇಳಿದ. ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್ ವಾಸ್ ಎಕ್ಸಿಬಿಟ್ P18. Salary certificate exhibit P18 or P11?
P18 is the certificate.
CKVK P18.
P18, man. P11 is Suresh's.
P11 and P18 were not disputed in the cross-examination. Therefore, the tribunal was justified in considering both the income. The included award does not warrant any interference. Next paragraph, please. It is a settled proportion of law that when a person expects the courts to believe the existence of certain fact, the initial burden of proving the said fact is on him. The claimant to prove that that deceased was working as lab assistant under in our department of P18 in
Soil Science Department.
Soil Science ಇದೆಲ್ಲ P18. P18 January 2012 ನಿಂದ ಮೇ ಅಲ್ಲಿ ಹಾಜರಾಗಿಲ್ಲ. ಆಕ್ಸಿಡೆಂಟ್ took place in July 2012 ಅಲ್ಲ?
Yes, ma'am.
Science Department GKVK. The burden of proving the fact that that deceased was working as a lab assistant in Soil Science Department GKVK and earning rupees 6,000 per month. 6,000 per month. Per month. In the first round of litigation, the claimant had not adduced any evidence in that regard. Therefore, on his request, claimants on their request, the matter was remanded with a specific. In the course of the said order, this court specifically observed that to prove his employment, to prove his such employment and income from such employment, the claimants have neither produced the salary certificate nor examined the employer. Even after the remand, the claimants just produced the said salary certificate at Exhibit P18, but did not choose to examine the author of the said document. Though it was contended that the said salary certificate was not disputed, but in the cross-examination of PW1, it is specifically PW1, the respondent has denied that that deceased was working in GKVK. GKVK ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದಾರೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಅಲ್ಲ ಅದಕ್ಕರ ಏನ್ ವಾಟ್ ಆರ್ ದೋಸ್ P12 and P ಕೆನರಾ ಬ್ಯಾಂಕ್ ಇಂದ ಏನ್ ತೋರಿಸುತ್ತೆ ಇದು? ಅಲ್ಲ ಎಲ್ಲಿ ಎಂಟ್ರಿ ತೋರಿಸಿ ಯಾವ್ದು ಅಂತ, ಯಾವ ಎಂಟ್ರಿ ಅಂತ ನಿಮ್ಗೆ ರೆಕಾರ್ಡ್ ಕೊಡ್ಬೇಕಾ? ಅಲ್ಲ GKVK ಇಂದ ಕ್ರೆಡಿಟ್ ಆಗಿದೆ ಅಂತ ಅನ್ನೋದು ಇಲ್ಲೆಲ್ಲೂ ಕಾಣ್ತಿಲ್ವಲ್ರಿ? ಅಂಡ್ ನೋಡ್ರಿ ಬೇಕಂದ್ರೆ ಅವ್ರಿಗೆ ತೋರಿಸಿ. Exhibit P, therefore, Exhibit P18 was not proved. Under such circumstances, the tribunal was not justified in holding that Exhibit P18 and consequently the employment of the deceased in GKVK and his salary of his income of 6,000 per month by way of salary was proved. ಏನ್ ಅವ್ರು BA ಆಗಿತ್ತು ಅದನ್ನೆಲ್ಲ ತೋರ್ಸೋದಕ್ಕೆ ಏನ್ ಹಾಕಿದೀರಾ? NSS ಸರ್ಟಿಫಿಕೇಟ್, ಕಂಪ್ಯೂಟರ್ ಟ್ರೈನಿಂಗ್ ಸರ್ಟಿಫಿಕೇಟ್, ಡಿಗ್ರಿ ಸರ್ಟಿಫಿಕೇಟ್. Exhibit P8 to 10, the degree certificate, computer training certificate and NSS certificate were of no help to show that the deceased had such employment or his income from GKVK or as a JCB supervisor. It is material to note that the deceased, according to the claimants, was BA degree graduate, BA graduate, BA graduate. But they claim that he was working as a soil, soil test.
Soil science.
Oh, he was lab assistant in the soil science department. Adheg ಮಾಡ್ತಾರೆ BA ಮಾಡಿದವರು soil test. And he was not a mechanical engineer or mechanical diploma holder. It is contended that he was working as a JCB supervisor. Therefore, this court is not inclined to accept that his employment under GKVK or under PW2. ಹೌದು ಜಿಯಾಲಜಿ ಒಳಗೆ ಬರುತ್ತೆ. ಏನಂತ ಅಲ್ಲಿ ಇದು ಹೇಳುತ್ತಲ್ಲ, he was BA graduate ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, he had no education in geology ಅಂತ. ಅಲ್ಲ, ಬರೀ ರೈತರಾದ್ರೆ ಜಿಯಾಲಜಿ ಡಿಗ್ರಿ ಬೇಕಿಲ್ಲ, ಅವ್ರು ಹೇಗೋ ಮಾಡ್ತಾರೆ. ಲ್ಯಾಬ್ ಅಸಿಸ್ಟೆಂಟ್ ಅಂದ್ರೆ ಸಾಯಿಲ್ ಏನ್ ಮಾಡ್ತಾರೆ, ನೀವು ಅವ್ರಿಗೆ ಎಕ್ಸಾಮಿನೇ ಮಾಡಿಲ್ಲ. ಲ್ಯಾಬ್ ಅಸಿಸ್ಟೆಂಟ್ ಅಂದ್ರೆ ಲ್ಯಾಬ್ ಅಲ್ಲಿ ಏನೋ ಮಾಡ್ಬೇಕು, ಇಲ್ಲ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಏನೋ ಕ್ಯಾಶ್ ಕೌಂಟರ್ ಅದು ಇದು ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಅದನ್ನೂ ಇಲ್ಲ ನಿಮ್ದು. They are not inclined, but no injustice will be caused to you because we are going to take it on the higher side only, based on this local election. Therefore, the income of the deceased has to be notionally assessed. Having regard to the qualification and age of the deceased and the wage rates and cost of living during 2012, his income can be notionally assessed at ₹7,000 per month. As per the judgment of the Supreme Court in Pranay Sethi's case, as the deceased had no permanent employment, as per the judgment of the Supreme Court in Pranay Sethi's case, 30%, no? His age is to 29 years. 40% has to be included, added to his income by way of future prospects. Therefore, his monthly income comes to ₹7,000 plus 2,800, 9,800. The deceased was a bachelor. Therefore, as per the judgment of the Supreme Court in Sarala Verma's case, 50% of his income has to be deducted for his personal expenses. Therefore, his monthly income, his monthly contribution to the family comes to ₹9,800 divided by 2, 4,900. For his age, applicable multiplier is 17. Therefore, the compensation payable in the head of loss of dependency comes to, please take your seat, 4,900 into 12 into 17, 9,99,600. The claimants are the aged parents and younger unmarried sisters of the deceased. Therefore, they are entitled to, therefore, as per the judgment of the Supreme Court in Pranay Sethi's case and Magna Corporation case, they are entitled to compensation of ₹40,000 per each with escalation of 10%. 40,000 ರೀ, 20% ಹೇಳಿಲ್ಲ. ನೋಡಿ, ಈ ಇವ್ರು ಪ್ರಾಬಬ್ಲಿ ದಿ ಸಿಸ್ಟರ್ಸ್ ಆರ್ ಮ್ಯಾರಿಡ್ ಅನ್ಸುತ್ತೆ ಇಷ್ಟಕ್ಕೆ. ಐ ಮೀನ್ ದೇವರ್ ಮೇಜರ್, ಅದು ಒಂದು ಆಗಿದೆ, ಅದು 44,000 2012 accident. Similarly, in the light of the judgment in the Supreme Court in Pranay Sethi's case, on the conventional heads of loss of estate and funeral expenses, 15,000 on each head with escalation of 10% has to be awarded. Therefore, the just compensation payable is as follows: loss of dependency 9,99,600, consortium 2,20,000, funeral expenses and loss of estate 33,000, total 12,52,600. Okay. since exhibit P18 is not accepted by this court, the additional evidence sought to be produced under I number 3 of 17 is redundant, and therefore the said application deserves is liable to be dismissed.
Lord,
And so,
8
No,
lakhs,
this-
8,75,000 is already been deposited before the tribunal, my lord.
we'll come to that. Therefore, for the aforesaid reasons, appeal deserves to be allowed in part, hence the following order. The appeal is partly allowed. The impugned award is modified as follows. The claimants are entitled to compensation of rupees 12,52,600 with interest thereon at 6% per annum from the date of the petition till its realization. The respondent shall deposit the said amount on adjusting the amount already deposited, if any, before the tribunal within 4 weeks from the date of the receipt of the copy of this order.
4 weeks, but 8 weeks. Idu any case.
ಅದ್ರಲ್ಲೇ ಅಲ್ರಿ ಅವ್ರು
My
8
lord,
weeks
this is-
ಕೊಡೋದು. ಈಗ ಆಲ್ರೆಡಿ ಡೆಪಾಸಿಟ್ ಅವ್ರಿಗೆ
I-
ಲಾಸ್ ಆಗಿದ್ದಾರೆ. ಫ್ರೀ ಟಿಕೆಟ್ ಕೊಟ್ಟು ಅವ್ರು ಲಾಸ್ ಆಗಿದ್ದಾರೆ ಈಗ ಅಂತ ಹೇಳ್ತಾರೆ. 6 weeks ಮಾಡಿ 6 weeks ಮಾಡ್ತಾರೆ.
Much obliged.
ಏನ್ ಟ್ರಿಬ್ಯುನಲ್ ನಲ್ಲಿ ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಹೇಗ್ ಮಾಡಿದ್ದಾರೆ, ತಂದೆ ತಾಯಿಗೆ ಅಷ್ಟು ಕೊಡ್ಬೇಕು, ಉಳಿದವ್ರದೆಲ್ಲ ಬರೀ ಹೌ ಇಸ್ ದ ಅಪೋರ್ಷನ್ಮೆಂಟ್ 45 10 15 15 15 ಮಾಡಿದ್ದಾರೆ. ಆಯ್ತು, ಹಾಗೆ ಮೇಂಟೈನ್ ಏನಿದು 45 10 ಮದರ್ 45 ತಂದೆಗೆ 10%. ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಚೇಂಜ್ ಮಾಡಲ್ಲ. ಅವ್ರು ಎಂಪ್ಲಾಯ್ಡ್ ಮ್ಯಾರಿಡ್ ಇದ್ರೆ ಪಾಪ ವಯಸ್ಸಾದ ತಂದೆಗೆ ಬರುತ್ತೆ, ಇಲ್ಲಾಂದ್ರೆ ಅವರೇ ತಗೊಂಡ್ ಹೋಗ್ತಾರೆ. ಎಸ್ ವಾಟ್ ಈಸ್ ಎ ಕ್ಲೇಮೆಂಟ್ಸ್ ಅಡ್ವೊಕೇಟ್ ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಅವ್ರಿಗೆ ಇದೇನ್ ಕಾನ್ಸೋರ್ಷಿಯಂ ಏನ್ ಬಂದಿರುತ್ತೋ ಅದನ್ನ ತಗೊಳ್ಳಿ ಸಿಸ್ಟರ್ಸ್, ಉಳಿದಿದ್ದನ್ನ ಪೇರೆಂಟ್ಸ್ಗೆ ಮಾಡ್ಬೋದ. ಸಿನ್ಸ್ ಕ್ಲೇಮೆಂಟ್ಸ್ 3 to 5 are major sisters and probably by this time they are married. ಅಲ್ಲ, ಎಲ್ಲ ಪೇಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ, ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ಟಿದಾರ ಈಗಾಗಲೇ. ಈಗ ಅವ್ರಿಗೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ 15 ಅಲ್ಲೇ ಅವ್ರು ತಗೊಂಡ್ಬಿಟ್ಟಿದಾರ. ಅದನ್ನ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಳಕ್ ಬರುತ್ತೆ, ಬರೀ ಕಾನ್ಸೋರ್ಷಿಯಂ ಅಷ್ಟೇ ಕೊಟ್ರೆ. ಈಗ ವಾಟ್ ಅವರ್ 15%. ಓಹೋ, ಇದು ಅಮೌಂಟ್ ಜಾಸ್ತಿ ಇತ್ತಲ್ಲ. ಈಗ ಹಾಗಾದ್ರೆ 15% ಅಲ್ಲ, ಈಗ ಅವ್ರು 50% ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರು, ಅದ್ರಲ್ಲಿ ಮಾತ್ರ ತಗೊಂಡಿದ್ದಾರೆ. ದೆನ್ ವಿಲ್ ಮೇಂಟೈನ್ ದಟ್ ಅಷ್ಟೇ. The order of the tribunal with regard to the apportionment and apportionment is maintained. ಇಲ್ಲಿ ರಿಲೀಸ್ ಮಾಡಕ್ ಹೇಳ್ತೀವಿ 2012 ಅದಲ್ಲ. On the deposit of the amount, the tribunal shall release the amount to the claimants.
Number 10, Vajna case, this is Singha Travel.
Even present when claimant is an unjust. ರವಿಶಂಕರ್ ಅವ್ರು ಏನು ಮಾಡ್ತಾ ಇಲ್ವಲ್ಲ. ಸಿ ದ ಕಾನ್ಸೋರ್ಷಿಯಂ ಟು ದ ಚಿಲ್ಡ್ರನ್ ಎಲ್ಲ ಇದೆ ಅಲ್ಲ, ದ ಪ್ರೆಸೆಂಟ್ ಸ್ಟೈಲ್ ಆಫ್ ಲಿವಿಂಗ್ ಇದೆ, ದಟ್ ಇಸ್ ಅನ್ಜಸ್ಟ್. ಯಾಕಂದ್ರೆ ಈ ಹುಡುಗರು 20 ವರ್ಷ ಆದ್ಮೇಲೆ ಯಾರು ತಂದೆ ತಾಯಿ ಜೊತೆಗೆ ಇರಕ್ ಇಷ್ಟಪಡೋದಿಲ್ಲ. ಮೋಸ್ಟ್ ಆಫ್ ದಮ್ ಮೇಜರ್ ಚಿಲ್ಡ್ರನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ಕೊಡ್ಬೇಕಾಗತ್ತೆ. ಸಮ್ ಕೇಸಸ್ ಇಟ್ ವಿಲ್ ಬಿ ದೇರ್. ಈ ಮ್ಯಾರಿಡ್ ಆಮೇಲೆ ಮೇಜರ್ ಸನ್ಸ್ ಅದೆಲ್ಲ ಇದ್ದಾಗ ಅಲ್ಲ. ಆದ್ರೆ ನೀವೇನ್ ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದೆ, ವಿ ಹ್ಯಾವ್ ಟು ಫಾಲೋ ಇಟ್. ವಿ ಅಗ್ರಿ. ಆದ್ರೆ ಇತ್ತೀಚೆಗೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಪ್ರೆಸೆಂಟ್ ಇಲ್ಲ ಒಂದು ಕಂಡೀಷನ್ ಹಾಕ್ಬೇಕು. ಇಫ್ ದೇ ಆರ್ ಲಿವಿಂಗ್ ವಿತ್ ದರ್ ಪೇರೆಂಟ್ಸ್ ಕೊಡ್ಬೇಕು ಅಂತ. ದೇ ಹ್ಯಾವ್ ಟು ಪ್ರೂವ್ ದಟ್ ದೇ ಆರ್ ಲಿವಿಂಗ್ ವಿತ್ ದರ್ ಪೇರೆಂಟ್ಸ್. ಇಫ್ ದೇ ಆರ್ ಲಿವಿಂಗ್ ವಿತ್ ದ ಪೇರೆಂಟ್ಸ್ ಹೋಗ್ಲಿ ಬಿಡಿ. Yes, what is this is a appeal and
Number 10.
IA number Directions to issue summons to produce documents. You're not pressing? ಇದರಲ್ಲಿ ರವಿಶಂಕರ್ ಅವ್ರದ್ದು ರೋಲ್ ಚೇಂಜ್ ಆಗಿದೆಯಾ? ಅಲ್ಲ ಕರೆಕ್ಟ್, ನೀವು ಯು ಹ್ಯಾವ್ ಕಮ್ ಫಾರ್ ಕ್ಲೇಮೆಂಟ್ಸ್ ಹಿಯರ್. ಓ ಹೀಗಾಗಿದೆಯಾ? So you represent insurer, he represents claimant. So IA 1 of 2023 is your application. Now counsel for the appellant submits that he does not press IA number 1 of 2023. Therefore, IA 1 of 2023 is disposed of as not pressed. IA 2 of 2023. You need time, no? Remand. What was his employment? ಅಲ್ಲ ಅದ್ರ ಅಷ್ಟೇ ಎವಿಡೆನ್ಸ್ ಮಾಡಿ ರೆಕಾರ್ಡ್ ಸಬ್ಮಿಟ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬೋದಲ್ಲ, ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ರಿಮೈಂಡಿಂಗ್ ದ ಎಂಟೈರ್ ಮ್ಯಾಟರ್. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಏನು TCS ಕಂಪ್ನಿ ಹೇಳಿದ್ರ? ಏನು TGS? ವಾಟ್ ವಾಸ್ ಹಿಸ್ ಕ್ವಾಲಿಫಿಕೇಶನ್? ನೀವು ಇದೇ ಹಾಕಿದ್ರಿ ಫಾರ್ಮ್ ನಂಬರ್ 16 ಅಸೆಸ್ಮೆಂಟ್ 2015. ಅದ ವಾಟ್ ವಾಸ್ ದ ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್? ಅದ್ರ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಇಯರ್ ಅಲ್ವಾ ಇವೆಲ್ಲ ಆಗಿದ್ರೆ ತಗೊಳ್ಳೋ ಸಾಕಾಗ್ತ. ಅಲ್ಲ ಇವ್ರ ಪ್ರಕಾರ ವಾಟ್ ವಾಸ್ ಹಿಸ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್? TGS Construction Private Limited as a field manager. TGS Construction Private Limited. What was his qualification? Diploma in civil engineering. Age 34 years. 35. Date of accident?
7/10/2015.
No, sorry. Computerized copy of Kotak Mahindra Bank. Oh. Now we have produced. Now you have produced the certificate along with certificate. 65 is certificate. Bank or bankers. Yearly, according to his salary was 34,200. 2015 nanne 1 ತೋರಿಸಿದ್ದಾರೆ. ಅದು February 2015. ಆಮೇಲೆ ಈಚ್ ಬಂತದ್ದು ಎಲ್ಲಿ ತೋರಿಸ್ತಾರೆ? ಸೆಕೆಂಡ್ ಪೇಜ್ ಅಲ್ಲಿ 14,300. 34,870.
19.5 salary graded construction 32,984.
Other next page, 32,994.
In next page, what of 22,615 salary per month of
33,206.
And next page also the 16,715 salary 33,260.
30. Next page already. Other next page. 33,206.
This page still 4 graphs. 88,015 salary for the month of July 15. 33,216. And what are
33,793.
Yes, that is the last paragraph.
10,9. ಇದು ಬ್ಯಾಂಕರ್ಸ್ ಬುಕ್ಸ್ ಆಫ್ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಅಡ್ಮಿಸಬಲ್ ಅಲ್ಲ ಇವರಿಗೆ? ಅಲ್ಲ ಅದು ಈಗ ಕೋಟಕ್ ಮಹೀಂದ್ರಾ ಬ್ಯಾಂಕ್ ಯಾವ ಬ್ರಾಂಚ್ ಇದು? ಕೋಟಕ್ ಮಹೀಂದ್ರಾ HSR.
Already marked exhibit P9.
If it goes to the trial court, then you want them to examine this bank manager. No, this document was already marked, but it was not certified copy ಅಂತ ಹೇಳ್ತಾರೆ. This was already marked exhibit P9. Computerized copy of Kotak Mahindra Bank. Computerized copy issue ಮಾಡಿದ್ರು. ಅಲ್ಲ ಅವಾಗ ಮಾಡಿದ್ರು, ಈಗ ಅವ್ರು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಂಡು ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಇಲ್ಲ, ಬೇಕಂದ್ರೆ ಇಲ್ಲೇ ಇನ್ನೊಂದು ತಗೊಂಡು ನಿಮ್ ಬ್ಯಾಂಕ್ ಇವ್ರಿಗೆ ಕೇಳಿ, ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಅವ್ರನ್ನ. ಅಂದ್ರೆ why should it be remanded? ಈಗ they are not going to, you are going to examine that bank manager. ಒಂದ್ ವೇಳೆ ಕೊಟ್ರೆ ಒಂದ್ಸರಿ ಸುಮ್ನೆ ನಿಮ್ಗೂ ಇಂಟ್ರೆಸ್ಟ್, ಈಗ ರಿಮಾಂಡ್ ಅದೆಲ್ಲ ಆದ್ರೆ ಫೆಟಾಲಿಟೀಸ್ ಇನ್ಕ್ರೀಸ್, ನಿಮ್ಗೂ ಇಂಟ್ರೆಸ್ಟ್ ಕೇಳ್ಕೊಳ್ಳಿ. ಅದಕ್ಕೆ ಇದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ಕೊಂಡು ಅಂದ್ರೆ ಇಫ್ ದೇ ಅಗ್ರಿ ಇದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ಕೊಂಡು ಮಾಡ್ಬೋದು ಅಲ್ವಾ? ರಿಮೈಂಡ್ ಮಾಡೋದು ಅಂತಂದ್ರೆ ಅನ್ನೆಸೆಸರಿ ಟೈಮ್ ಆಯ್ತು. ದಿಸ್ ಇಸ್ ಸರ್ಟಿಫೈಡ್ ಬೈ ದಟ್ ಬ್ಯಾಂಕ್, ಅದ್ರ ಸೀಲು ಇದೆ ಅದ್ರ ಮೇಲೆ. Counsel for the respondent. Counsel for respondent seeks time to take instruction with regard to the documents produced under IA2 of 2023. List on ಎಷ್ಟು ದಿವಸ ಬೇಕು ಟೈಮ್? 10 days. After 10 days on date. ಯಾಕಂದ್ರೆ ಬ್ಯಾಂಕರ್ಸ್
Yes, I appear for the appellant in this case.
It is non-filing of memo for having deposited 50% of compensation. With up to date.
That is
In main matter discuss ಮಾಡ್ಬೋದಲ್ಲ.
that problem alerts, it is already deposited.
All right, correct. Argument ಮಾಡ್ಬಿಡಿ, ಅದನ್ನ main matter discuss.
May I request it on next Monday or Tuesday? I am not well minutes today.
You are not well.
Monday or Tuesday.
As requested by the appellant's counsel. ಅಲ್ಲಿ ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡೋಣ ಅವ್ರದ್ದು, ಇದ್ರಲ್ಲಿ ಇದು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಇದೆ.
Please sir, condone ಮಾಡಬಹುದು.
58 days ಡಿಲೇ ಅದು ಕೊಟ್ಟು ಏನು, what is the reason assigned by you for delay? 58 days. Case of injury or death.
Death is sir.
Further legal remedy, I could not be able to approach, depress the shock. 11.1. Third, accepting the reasons assigned to explain the delay of 58 days in filing the cross objection is hereby condoned. In the interest of justice, IA1 of 2022 is disposed of accordingly. Our ವಕಾಲತ್ತು ಹಾಕಿಲ್ಲ, ಅದ್ರಲ್ಲಿ ವಕಾಲತ್ ಹಾಕಿವೆ ಅಶೋಕ್ ಪಾಟೀಲ್.
I will get the by that.
As requested, list on.
Number 12, Marigoda, the case for R1 to R3.
Objection, non-compliance of office objection for fourth time. In office objection, just a minute, we'll see what is the office. Post appeal admitted, citations and synopsis filed by the advocate for respondent, other side copy to be served. Non-filing of citations and synopsis by the advocate for appellant. Synopsis ಹಾಕೋದಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿತ್ತ ಈ ಮರಿಗೌಡ ಸೆಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ is permitted to file ವಕಾಲತ್.
4 objections ಇದೆ. 4 objections ಇದೆ. Previous page.
ಎರಡೇ ಇದೆ, ಒಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ. ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಮೊದಲು ನೋಡೋಣ. 12 ಅಲ್ಲಿ there are 2 objections. ಒಂದು ಕಾಪೀಸ್ ಅವರು ಮಾಡಿದಾರಲ್ಲ, ಅವ್ರು ನಿಮ್ಮ ಮೇಲೆ ನೀವು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲ, ಅದನ್ನ ಕ್ಲಿಯರ್ ಮಾಡೋಣ. First matter, counsel for the appellant submits that he has received the copies of citations and synopsis submitted by the counsel for respondent. Therefore, office objection in that regard stood complied. ಇನ್ನೊಂದ್ರಲ್ಲೇನೋ 4 office objection ಇದೆ ಅಂತಲ್ಲ ಕ್ರಾಸ್ objection ಅಲ್ಲಿ. Non-compliance office objection. ಎಲ್ಲಿದೆ 4 objection? Acknowledgement for having served.
Objections.
Value of the appeal to be correctly stated. Dates at 12% additional market value to be clarified, since date of possession is earlier than the date of 4-1 notification. Later value to be stated. Date of service of notice to be stated regarding limitation para. Extent of the land stated at valuation slip to be correctly stated. If necessary, deficit court fee to be paid. ಇದರಲ್ಲಿ ಇಷ್ಟ objection ಇದೆ ಅಂತ ಬರೆದಿದ್ದಾರಲ್ಲ ಕ್ರಾಸ್ objection ಅಲ್ಲಿ. ಏನು 4 4 objections they have shown. Verify marks. We say that you have asked the registry to verify. You say that we record that you submit that you have complied the office objection. Let them verify and come back. ಅವ್ರ ಪ್ರಕಾರ ನೀವು ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ, ನೀವು ಮಾಡಿದಿರಿ ಅಂತ ಹೇಳ್ತೀರಿ, ಇನ್ನೊಂದ್ಸರಿ ಚೆಕ್ ಮಾಡ್ಲಿ ಅವರು. ಎಸ್ ನೀವು ಅವ್ರಿಗೆ ಗೊತ್ತಿದೆ ಇರೋ. ಬಟ್ ದೇರ್ ಆರ್ 4 objections. ಏನದು ವ್ಯಾಲ್ಯೂ ಆಫ್ ದ ಅಪೀಲ್ ಟು ಬಿ ಕರೆಕ್ಟ್ಲಿ ಸ್ಟೇಟೆಡ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಆಮೇಲೆ ಯಾವಾಗ ನೋಟಿಸ್ ಸರ್ವ್ ಆಯ್ತು ಅಪೀಲ್ ನೋಟಿಸ್ ಅಂತ ಹೇಳಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾಕಪ್ಪ correct? Have you stated that in the where? You have to file citations also. You message. ಎರಡು ಅವರು ಅದನ್ನು ಚೆಕ್ ಮಾಡ್ಲಿ. ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ ಸಮ್ ಅದರ್ ಡೇ. ಇಲ್ಲ ಅಂತಂದ್ರೆ ಹೋಗಿ ಬರ್ಲಿ, ಕೆಳಗೆ ಹೋಗಿ ಬರ್ಲಿ, ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ತೀವಿ. Let the registry verify. You say you have complied. They say you have not complied. But ಇದರಲ್ಲಿ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಏನಂತ ತಗೊಳ್ಳಿ. Now counsel for the appellant shall submit the synopsis and the citations on or before next hearing date. Okay. 12.1 ಅಂತ ತಗೊಳ್ಳಿ. Now counsel for the cross objector submits that he has complied the office objections.
Deficit court fee ಕೊಡ್ಬೇಕಾಗುತ್ತೆ. Deficit court fee ಕೊಡ್ಬೇಕಾಗುತ್ತೆ.
ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೇಲೆ ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅಲ್ಲ, ನೀವು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಹೇಳಿದ ಮೇಲೆ ಗೊತ್ತಾಗುತ್ತೆ ಅಂತಾರೆ ಅವರು. ರಿಜಿಸ್ಟ್ರಿ ಶಾಲ್ ವೆರಿಫೈ ಲಿಸ್ಟ್ ಆನ್ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ. ಫ್ರೈಡೆ ಬೇಡ, ಥರ್ಸ್ಡೇ ಹಾಕೊಳ್ಳೋಣ, ಯಾಕಂದ್ರೆ ಫ್ರೈಡೆ ಮತ್ತೆ ಸ್ಪೆಷಲ್ ಬೆಂಚಸ್ ಎಲ್ಲ. ಈ ಥರ್ಸ್ಡೇ ನೆಕ್ಸ್ಟ್ ಈ ಥರ್ಸ್ಡೇನಾ? ಆಯ್ತು. ಇಲ್ಲ ಅಂದ್ರೆ ಅದನ್ನೆಲ್ಲ ವೆರಿಫೈ ಮಾಡಿ ನಾಳೆ ಲಿಸ್ಟ್ ಮಾಡ್ಲಿ. ನಾಳೆ ಆಗ್ಬೋದಾ? Then which date is convenient for you? 22.
I am for a respondent. My lord, just to cut short and say to save the time of the court, my lord, his RP may be allowed without going to the other aspect. ಯಾಕಂದ್ರೆ ನಾನು ನೆಟ್ಟಲ್ಲೆಲ್ಲ ನೋಡಿದೆ, ಬಹಳಷ್ಟು ವಿಷಯ ನಡೆದಿದೆ, ಅದು ಯಾವುದು ಮಾಡದೆ RP may be allowed and the order passed in my favor may be recalled. ಅದು ಒಂದೇ ಕೇಸಲ್ಲಿ 2 ಜಡ್ಜ್ಮೆಂಟ್ ಆಗೋಗಿದೆ. ಅದರಲ್ಲಿ ನನಗೆ ಅಲ್ಲ
ಯಾಕೆ ಹಾಗಾಯ್ತು? ಸೇಮ್ ಅಡ್ವೊಕೇಟ್ ಅಪಿಯರ್ಡ್ ಇನ್ ಬೋತ್ ಕೇಸಸ್. ಇದು ಯಾವ್ದೋ ಹಿಂದೆ ಒಂದ್ಸರಿ ನಮ್ಮ ಮುಂದೆ ಬಂದಿತ್ತಲ್ಲ.
ಹೌದು 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 ಹೌದು. ನಾನು ಐ ಆಮ್ ಮೇಕಿಂಗ್ ಎ ವೆರಿ ಫೇರ್ ಸಬ್ಮಿಷನ್ ಬಿಕಾಸ್ just to avoid the awkward situation. Just that is why
we have only 2 years. ಇಬ್ಬಿಬ್ರು ಮಾಡಿದ್ರೆ ಕೇಳಕ್ ಆಗಲ್ಲ. ಅವ್ರ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಅವ್ರ ಮೊದಲು ಆರ್ಗ್ಯೂ ಮಾಡ್ಲಿ.
ಅಲ್ಲ, ನಾನು ಕನ್ಸರ್ನ್ ಕೊಡ್ತಾ ಇದ್ದೇನೆ, ಯಾಕಂದ್ರೆ ಬಹಳ
ಕೊಡ್ತಾ ಇದ್ದೀರಿ. ಆದ್ರೆ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ 2 ಕೇಸ್ ಗೊತ್ತಿದ್ರು 2 ಆರ್ಡರ್ ತಗೊಂಡು.
ಅದು ಅಲ್ಲ, ಅದು ನನಗೆ ಗೊತ್ತಿರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳೋಕೆ ನಾನು ನೆಟ್ಟಿಂದ ಬಹಳಷ್ಟು ವಿಷಯವನ್ನು ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದೀನಿ. ಅದು ಯಾವ್ದು ಬೇಡ ಸ್ವಾಮಿ,
ಹೇಳ್ಬಿಡಿ. ಅದಕ್ಕೆ ಸಿ ದಿಸ್ ಇಸ್ This is the abuse of the process of the court. ಎರಡೆರಡು ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಕೋರ್ಟ್ ಟೈಮ್ ಆಮೇಲೆ ರಿಸೋರ್ಸಸ್
ಅಲ್ಲ
ಡೈವರ್ಟ್
ಸ್ವಾಮಿ,
ಆಗುತ್ತೆ.
ಅದು ಅವಾಗ ಫಸ್ಟ್ ನನಗೆ ನಾತ್ರ ಮಟೀರಿಯಲ್ ಇದೆ, ಅದೆಲ್ಲದಕ್ಕೂ ನೆಟ್ಟಲ್ಲೇ ಮಟೀರಿಯಲ್ ಇದೆ.
ಅದಕ್ಕೆ
ಹೇಳ್ತೇನೆ ಅಲ್ಲ ಅದು ಯಾವ್ದು ಈಗ ಅಲ್ಲ ಅವ್ರು ಅಲ್ಲ ಈಗ ಅವರು ನಾನು ಯಾವ್ದಲ್ಲ
ಅವ್ರ ಪಿಟಿಷನರ್ ಮೊದಲು ವಿಲ್ ಕಾಲ್ ಅಪಾನ್ ಹಿಮ್ ಟು ಆರ್ಗ್ಯೂ, ದೆನ್ ವಿಲ್
ಆಯ್ತು,
ಗಿವ್ ಯು
ತೊಂದ್ರೆ ಇಲ್ಲ. I started my submission with the humble request.
ನಾವು ಹಾಗೆ ಮಾಡೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದೀವಿ. ನಾವು ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತೀವಿ. If there was no
that is okay.
intention, then we'll just simply allow the review petition. That's all. If we find something wrong, then we'll impose heavy cost.
ಅಲ್ಲ ನಾ ಹೇಳ್ತೇನೆ ಅದಕ್ಕೆ, ಸ್ವಾಮಿ ಪಾರ್ಟಿ ಸತ್ತು ಹೋಗಿದ್ದಾರೆ, ಎಂತದ್ದು ಅದ್ರ ಈ ಕೆದಕ್ತಾ ಹೋದ್ರು ಬಹಳ ವಿಷಯ ಇದೆ ಇದ್ರಲ್ಲಿ, ಅದಕ್ಕಾಗಿ ಅದೆಲ್ಲ ಬೇಡ.
ನಾವು ಕೇಳ್ತೀವಿ, ನಾವ್ ಇರೋದೇ ಕೇಳೋದಕ್ಕೆ, ಕಡಿಮೆ ಇದ್ರು ಕೇಳೋದು, ಬಹಳ ಇದ್ರು ಕೇಳ್ತೀವಿ.
ಈಗ ಅವರಿಗೆ ಅಲೋ ಮಾಡ್ಬೇಕಲ್ಲ, ಅದಕ್ಕಾಗಿ ಅಲ್ಲ ಐ ಹ್ಯಾವ್ ಆಂಪಲ್ ಮೆಟೀರಿಯಲ್. yes I am ready to proceed argue the matter, but my humble again and again I am making the request. ನನಗೆ ವಕಾಲತ್ ತಂದು ಕೊಟ್ರು ಹಾಕ್ಬಿಟ್ಟಿದ್ದೇನೆ, ಅದು ಅವಾಗ ಬಳ್ಳಾರಿ
ಯಾಕೆ ಅವರು ರಿವ್ಯೂ ಪಿಟಿಷನರ್ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿ, ನಂತರ ನಿಮ್ಮನ್ನ ಕೇಳ್ತೀವಿ ಅಂದ್ರೆ why are you interrupting like this?
ಆಯ್ತು ಸ್ವಾಮಿ, ಆಯ್ತು.
ಇನ್ನು 2 ನಿಮಿಷ ಇದೆ, ಆಫ್ಟರ್ನೂನ್ ತಗೋ. 2 ನಿಮಿಷದಲ್ಲಿ ನಿಮ್ದು ಕನ್ಕ್ಲೂಡ್ ಆಗುತ್ತಾ? ಹಾಗೆ ಹಾಗಾದ್ರೆ ಮಧ್ಯಾಹ್ನ ತಗೋ.
ನಾಳೆ ಇಟ್ಕೊಳ್ಳಿ ಸಮಯ
ಮಧ್ಯಾಹ್ನ ನಾವ್ ರೆಡಿ ಇದೀವಿ, ಬೇಕಂದ್ರೆ ಇನ್ನು 2 ಗಂಟೆವರೆಗೂ ಕುತ್ಕೊಳ್ಳೋದಕ್ಕೆ. ಇಲ್ಲಿಂದ ಯಾವ ತರ ಇನ್ನು 2 ನಿಮಿಷ 1 ನಿಮಿಷ ಅಷ್ಟೇ ಉಳಿತಾ. ಆಯ್ತು, ವಿಲ್ ಕಂಟಿನ್ಯೂ ಇನ್ ದ ಆಫ್ಟರ್ನೂನ್ ರೆಸ್ಟ್ ಆಫ್ ದ ಮ್ಯಾಟರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಇದರಲ್ಲಿ 2497 of 2005 ಇದು ಅಪೀಲ್ ಫೈಲ್ಡ್ ಬೈ ಮೀ ಅಂದ್ರೆ ಇದ್ರಲ್ಲೇ ಇದು ಸಿ ನಂಬರ್ 13 ಅಲ್ಲಿ ಇದರಲ್ಲಿ ನಾನು ಒಂದು ಅಲ್ಲ 8520 of 2004 ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಪೀಲ್ ಅಲ್ಲಿ 8520 ಇದರಲ್ಲಿ 11/1/2011 ನಾವೊಂದು IA ಫಾರ್ ರಿಕಾಲಿಂಗ್ ಹಾಕಿದ್ದೇನೆ ಅಂತ ನೆಟ್ ತೋರಿಸ್ತಾ ಇದೆ.
ರೆಕಾರ್ಡ್ ಎಲ್ಲ ಇದಾಗ್ತಿದೆ, ಸ್ವಲ್ಪ ಮಕ್ಕಳಿದೆ.
11/1/2011 ನಾನೊಂದು IA ಫೈಲ್ ಮಾಡಿದ್ದೇನೆ ಅವ್ರ ಕೇಸಲ್ಲಿ 2011ರಲ್ಲಿ. ಅದು ಎಂತ IA, ಏನು ಎತ್ತ, ಯಾರು ಫೈಲ್ ಮಾಡಿದ್ವಿ ಎಂತದ್ದು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. 11/1/2000 ಅಲ್ಲ ನೆಟ್ಟಲ್ಲಿ ತೋರಿಸ್ತಾ ಇದೆ. 11/1/2011 ಐ ಫೈಲ್ಡ್ ಎನ್ IA.
ಸರ್ 8520 ಅಲ್ವಾ?
ಹೌದು, 8520.
ಅದ್ರೊಳಗಡೆ ಯಾವ್ದೂ ಇಲ್ಲಿ ಬರ್ತಾ ಇಲ್ಲ ಸರ್.
ನೆಟ್ಟಲ್ಲಿ ಸ್ವಲ್ಪ ಚೆಕ್ ಮಾಡಿ. 11 ಅದಕ್ಕಾಗೆ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೇನೆ. 11/1/2011 ಐ ಫೈಲ್ಡ್ ಎನ್ IA.
Court officer? Court officer?
ಹೇಳಿ ಸರ್.
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 3 ನಂದು ನನ್ನ ಹಿಯರಿಂಗ್ ಆಗಿತ್ತು ಅವ್ರು ಬರ್ತಾರೆ ಅಂತ ಕಾಯ್ತೀನಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಮೇಡಮ್.
ಪಾಸ್ ಓವರ್ ಆಗಿದೆ, ಕಾಲ್ ಔಟ್ ಆಗುತ್ತೆ.
ಅದೇ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಬಂದ್ರ ಅವರು ಅಂತ. ಅಲ್ಲ ನಂದು ಹಿಯರಿಂಗ್ ಆಯ್ತು ಅವ್ರು ಬರ್ಲಿ ಅಂತ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ರು. Hey ರವಿಶಂಕರ್, ಅಲ್ಲ ಒಂದ್ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ನಿಮ್ ಕೈಲಿ ಕೊಡ್ತೀನಿ ಅಂದಿದ್ರೆ ಏನಾಯ್ತು?
Number 27, Vijay Prasad KT.
I appear for the appellants. First respondent is New India Assurance Company.
New India ಯಾರು ಇದಾರ? New India Assurance Company. GS Moralaya, Lawrence Standing Concept Correspondent number 1 is requested to accept notice correspondence. Or copy sir, GS Moralaya.
ಮಾಡ್ತೀನಿ. R to remand expert.
Then you have to file a memo for decision.
ಕೊಡ್ತೀನಿ.
Liability
is on the insurance company.
When do you submit the memo?
ಇವತ್ತೇ ಕಳಿಸ್ತೀನಿ.
Notice to respond number 2. The records show that respondent had not contested the matter before the tribunal. Under the impugned award, the liability is fastened to respond number 1. Therefore, notice to respond number 1 is this. Response to is dispensed with as paid for. Delay the or copy sir ಮಾಡಿ, then let him say what. Four weeks. 11. There was no policy. It was not renewed, or what is that? It was not renewed, or totally case of no policy only. What was exhibit R1? Policy. Issue notice to the respondents. Interim stay of execution of the impugned award. Subject to the appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of the receipt of copy of this order. This year's call for Madam Cycle. List on date.
Number 29, D. Vijay Kumar.
My lord, this appeal is by the Reliance General Insurance Company challenging the negligence, involvement of the vehicle, and also liability to pay the compensation. Tribunal has awarded, my lord, 23,68,000. I am ready to deposit 50% of the award.
Notice to the respondents. Interim stay of the execution of the impugned award till next hearing date. Subject to the appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of the receipt of a copy of this order. List on date. 1.
Number 30.
Much obliged.
Raman.
HDFC Irko General. Please, your number here. It is submitted that this appeal is connected to MFA number so and so. List both the matters together in the next week.
Number 31, Shankraj K.
Yes. United India Assurance. ಯಾರಿದ್ದಾರೆ ಯುನೈಟೆಡ್ ಇಂಡಿಯಾದವ್ರು ಯಾರು? ಯುನೈಟೆಡ್ ಇಂಡಿಯಾದವ್ರು ಯಾರು ಇದ್ದೀರಾ? ಮರಳಯ್ಯ ಈಗ ತಗೊಂಡು GS ಮರಳಯ್ಯ ಲಯನ್ಸ್ ರನ್ನಿಂಗ್ ಕಾನ್ಸೆಪ್ಟ್ ಕರೆಸ್ಪಾಂಡ್ ಮಾಡೋದು ಡೈರೆಕ್ಟ್ ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಅಶ್ಯೂರೆನ್ಸ್ ಅದು ಮತ್ತೆ ಅಶ್ಯೂರೆನ್ಸ್ ಅಂತ ಇದೆ ಇದ್ರಲ್ಲ ಅದಕ್ಕೆ ಅದು ಸರಿ ನ್ಯೂ ಇಂಡಿಯಾ ಅಶ್ಯೂರೆನ್ಸ್ ಅದು ನೀವು ಯಾರಿಗೆ ಅಲ್ಲಲ್ಲ ಸರಿ ವಿ ಮೇಡ್ ಅ ಮಿಸ್ಟೇಕ್ ನ್ಯೂ ಇಂಡಿಯಾ ಅಶ್ಯೂರೆನ್ಸ್ ನೀವು ನ್ಯೂ ಇಂಡಿಯಾಗೂ ಹೋಗಿರಾ notice correspond number 1 copy sir what issue notice to respond number 2. Miss call. 6 weeks are left.
19/7.
19.
Number 32, Shantaraj case.
Reliance, or maybe right? Reliance, or
Reliance, I'll take, my lord.
Team, Vijay Kumar, in of the initial. Vijay Kumar, Lalit Standing Council for Respondent 1 is requested to accept notice for Respondent 1. With a copy, sir, there is delay. ಇನ್ನೊಬ್ಬರಿಗೆ ಹೋಗ್ಬೇಕಲ್ಲ ನೋಟಿಸ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಲಿಸ್ಟ್ ಡೌನ್
33, yes, keep and draw.
I am for appellant number appellant in 33.2 and 33.3. In 33.2, I have filed a second set of
IA 1 of first matter, IA 1 of 2019 has filed, there is office objection on that. Other side copy to be served. Second set of IA 1 of 2019 to be filed. ಏನದು ಸೈಯದ್ ಅವರು ಇರ್ತಾರಲ್ಲ ರೆಗ್ಯುಲರ್ಲಿ
I am in 33.2, I have filed my this one.
33 we are speaking about 33.
33.2.
Objections have to be applied.
ನಿಮ್ಮದಲ್ಲ ಅವ್ರ ಸೈಯದ್ ಅಬ್ದುಲ್ ಸಬೂರ್
I have complied, my lord. 33.2, I have complied, my lord. I have filed today second set of
ಆಕಾಶವಾಣಿಯಲ್ಲಿ ಮಾತಾಡೋರ್ಗೆ ಈ ಕಡೆಯಿಂದ ಏನ್ ಹೇಳ್ತೀವಿ ಇಲ್ಲ ಇದು ಬರ್ಕೊಳ್ಳಿ. No representation for the response. Finally, 1 week time is granted to do the entry, failing which IA 1 of 2019 shall stand dismissed. 33.1 ನಲ್ಲಿ correct address 4 and 5. 4 and 5.
4 driver ಅವ್ರಿಗೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಆಗ್ತೇನೆ 5 ತಗೊಂತೀನಿ ಸರ್.
ನಾವು ನೋಟಿಸ್ ಆರ್ಡರ್
4 is the driver.
ಅಲ್ಲಿ ಸರಿ ಹಾಕೋದಿದ್ರೆ ಮೆಮೊ ಫೈಲ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Memo R4 ಹಾಕ್ತೀನಿ ಸರ್. ಫೈಲ್ ಇನ್ ಆಫೀಸ್.
ಕಾನ್ಸಿಕ್ವೆಂಟ್ ಆಗುತ್ತೆ.
R5 ಚೆಕ್ಸ್ ಕೊಡ್ತೀನಿ.
To do the needful in respect of 4 and 5. 1 week time is granted to the needful. In respect of IA 1 of 2019, finally 1 week time is granted to do the needful, failing which the application shall stand dismissed. Okay. 33.2 second set of appeal, Syed Abdul Sabur. No represent 2016. ಎಲ್ಲಿದ್ದಾರೆ?
3.2.
ಅಲ್ಲಿ ಬಂದ್ರು. ಯಾವಾಗ ಹಾಕಿದ್ದೀರಿ? You have the proof of that?
Yes, my lord. Today I have filed, my lord.
Hey, no,
Acknowledgement I am having, my lord.
Registry shall verify. Yes, that 33.3 ನಲ್ಲಿ ಏನು ಇಲ್ಲ ಅಷ್ಟೇ ಅಲ್ಲ ಅಷ್ಟೇ.
34.
Correct address to issue notice to R1 for the second time. ನೀವ್ಯಾರಿಗೆ? R3. No representation for the appellant. 2018 ಅದ R1. Who is R1? ಅವ್ರ ಮೇಲೆ ಹೋದ್ರೆ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಮೇಲೆ ಹೋಗುತ್ತೆ. There are 2 respondents. ಏನ್ 2 ಓನರ್ ಬೇರೆ ಪಾಲಿಸಿ ಹೋಲ್ಡರ್ ಬೇರೆ ಇದಾರ ಹೇಗೆ? No representation for the appellant. Finally, 10 days the time is granted to do the needful, failing which appeal against respondent number 1 shall stand dismissed.
35. Remanded.
Second time for R2 insufficient. ಹೌದಲ್ಲ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ಅವ್ರಿಗೆ. It is submitted that CH-6 Keshav Prashant Pranad also for R1 unfortunately passed away. Therefore, registry shall not show his name in the court list henceforth. ಯಾರು ಬೇರೆಯವ್ರು ತಗೊಳ್ತಾರೆ ಇನ್ ಕೋರ್ಟ್ ನೋಟಿಸ್ ಫೈಲ್ಸ್ ಇರೋದು. Issue court notice to respond number 1. Based on For it.
Number 36, Raja Ramesh, Rajshekar S. for R1 and R2, Geeta Raj for R3,
First, R4 and R5 steps over. No representation for the appellant. Finally, 2 weeks time is granted to the needful. Failing which appeal against R4 and 5 will stand dismissed.
number 37, Raja Ramesh, MB Punasam,
ರಾಜಾರಾಮೆಲ್ಲೂ ಬಂದೇ ಇಲ್ಲ ಟೋಟಲ್ ಪ್ರಾಬಬ್ಲಿ ಅವರು ಮೂವ್ ಮಾಡಿರ್ತಾರೆ. ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್. ಫೈನಲಿ granted to the needful failing which appeal against as considered shall stand dismissed.
number 38, Unnikrishnan M,
Dismissal of IA 1 into as per the court order dated compliance. IA 6 2023. No representation for the appellant. The current order dated 5/6/2023 is not complied. Therefore, appeal IA 1 and 2 are for recalling again. One is for condonation of delay. 3,367 days in filing the appeal. IA 1 and 2 ಬರೀ IA 1 and 2 ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಯಾವ ಇಯರ್ ಅಂತ ಬರ್ದಿಲ್ವಲ್ಲ. ರಿಕಾಲಿಂಗ್ ಅದೇ 2 of ರಿಕಾಲಿಂಗ್. (38 2021). Therefore, IA 1 and 2 of 2023 already stood dismissed. No further orders are required.
Nagaraj,
In view of the petitioner in this matter, your lordships, all the office objections have been complied except one of them, which is the payment of court fees. So in fact, after the recalculation of the valuation of the petition, there is a deficit of about 70,000 that has to be paid. The petitioner is a senior citizen. He had very limited means of income. He said he's arranged for the funds finally. 1 week may be granted, I'll comply with that. If all the other office objections have been complied with.
It is already dismissed. And if he is senior citizen and unaffordable, our legal services authority will provide free legal aid.
No, he's arranged for the funds right now. It's only a question of the court fee. All the other objections have been
In
complied
LIC,
with.
NBC cases, they do not go to the legal services authorities.
1 week's time may be granted, your lordships.
Not compared, therefore appeal already stood dismissed. No further orders are required.
Harish Kumar BG,
No representation for the appellant. No ceremony. The parental order dated 28/3/2023 is not complied. Therefore, appeal already stood dismissed. No further orders are required.
number 41, Pavan Chandra Shetty H,
Parental order is not complied. Finally, 1 week time is granted to do the needful, failing which appeal shall stand dismissed. 5/4. By the time appeal was filed.
we sustained a legal reservation. 50% of this legal was removed because of the accident.
Correct. Now, yeah, what was that compliance he had to do? Now, what is that needful that was to be done? Appellant is measure, he has to execute wakalat. ಈಗ ಏನ್ ಮಾಡ್ತೀರಿ ರೈಟ್ ಕರೆಕ್ಟ್ ಏನ್ ಯಾರಾದ್ರೂ ಎಲ್ಲಾಸ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾರೆ ಬಟ್ ಈಗ ಆಲ್ರೆಡಿ ದಿಸ್ ಇಸ್ ಡಿಸ್ಮಿಸ್ಡ್ ಯು ಕ್ಯಾನ್ ಫೈಲ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ like Remanded order it is 5/2020 is not compliant. Therefore, appeal already you can file application to recall. You have to file LR application also. Appeal already is to dismiss no further order, sir. From the question. Now stating of prayer. ಮಾಡಿ ಇನ್ನೊಂದು ದಿವಸ ಲಿಸ್ಟ್ ಮಾಡ್ತೀವಿ as requested by the you want a date to be given comply ಮಾಡಿದ ಮೇಲೆ will come issue notice if any of them are here if they take notice all right will issue. Who is the counsel for NI? Who is the counsel? Prasanna Kumar. This case ಅಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲಿ ತಗೊಂಡಿದ್ರು NI alone is a party. Shri, or initial Prasanna P. Prasanna Kumar. The standing counsel for the respondent is requested to accept notice for the respondent and the registration. Sir, the copies and as requested list on 28/6. In the meantime, the officer will be compliant. Yes.
I am advocate for appellant, my lordship. There is a delay of 31 days in filing, my lordship.
Clement Patel. 2018, it was not listed at all since 2018?
Because it is earlier dismissal for non-compliance of office objection. Later it is restored, my lordship, and then there is a office objection for maybe division bench. Hence I filed second set. Today it
National
is
Insurance Company. National Insurance. Shri Rajendra Hegde, standing counsel for respondent number 1, is requested to accept notice for respondent number 1. He served the copies on Mr. Rajendra Hegde.
much obliged, my
What
lordship.
about respondent number 2?
He is expertly before trial court, my lordship. Kindly notice may be dispensed with, ma'am.
You have to come here and submit a memo to that effect.
I'm sorry, my lord. Apologize.
Load in part ಆಗಿದೆಯಾ? But issue notice to respondent number 2. If you file a memo, we'll dispense with them.
Yes, my lord.
20?
Much obliged, ma'am.
27.
Number 44, Nothing Murthy TV.
IA 1 of 2020 is not pressed. What is the IA? IA 1 exempt application. You are not pressing this exemption of court fee. IA 1 of 2020. Not pressed. You have paid the court fee?
Now paid.
You are going to pay or paid?
And they are not sure, so I can't say.
All right. Then Suran Baila. Narsimurthy GV. In pleading, ಅದ್ರ ಮೇಲೆ ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಅಂತ ಬರೆದಿದ್ದಾರೆ. In view of the endorsement of the Defense Council and the Council that IA 1 of 2020 is not pressed, the same is disposed of as not pressed. Then in pleading application, whether court fee sufficient, note hakkidaralla. Court fee sufficient. Yes, sir. Issue notice of IA 1 and 2 of 2023, IA 1 of 2018 and IA 1 of 2023. The response, HCB notice ತಗೊಳ್ತಾರ ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್ HRP ಹಾಸನ and executive engineer legacy project ಬಹುಶಃ ಇವ್ರು ಬೇರೆ ಇರ್ಬೇಕು. ಏನು ಇಶ್ಯೂ ನೋಟಿಸ್ IA 1 of 2018 and IA 1 of 2020. The respondent and the proposed, who is the proposed respondent? Proposed respondent number 3. Proposed respondent number 3. Simultaneously, the counsel for the appellant is permitted to serve notice on learned SCP on behalf of for respondent number 1 and 2. The registry shall show his name in the process accordingly. This stand notice. Notice, we are ordering notice.
20th. Number 45, Manjesh HM.
Divisional manager KSRTC. HD ಕೊಟ್ಟಿದ್ದೀವಿ. ಯಾರಿದ್ದಾರೆ KSRTC ಅವರು? ಇವರು ವಿಜಯ್ ಕುಮಾರ್ ಇದಾರೆ ನಾನು. ಡೈಲಿ ಇದಾರಲ್ಲ. ಶ್ರೀ ಹರೀಶ್ ಭಂಡಾರಿ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಸ್ ರಿಕ್ವೆಸ್ಟ್ ಟು ಆಕ್ಸೆಪ್ಟ್ ದಿಸ್ ಕರೆಸ್ಪಾಂಡೆಂಟ್. ಉಳಿದೆಲ್ಲ ಹಾಕೊಂಬಿಡಿ. ಅವ್ರಿಗೆ ಯಾರು ಅವ್ರ ಕೌನ್ಸಿಲ್ ಇಲ್ಲ ಆಫೀಸ್ ಅವರು ಮಾಡಿದಾಗ ರೆಸ್ಪಾಂಡ್. Issue notice to respond number 1. 2019 ಇಂದ ನೋಟಿಸ್ ಕೂಡ ಇಶ್ಯೂ ಆಗಿರೋದು.
Serial number 46, my lord, I appear for respondent number 3. I have not been served with the IA copy, my lord. It's about 4 years delay is there.
Respond number 3 ಯಾರು? ಅಶೋಕ್ ಪಾಟೀಲ್, ಸುರೇಶ್.
Suresh, also. The appellant may be directed to serve a copy on.
Yes, Suresh, Third Council has appeared for R3. Registry shall show only his name in the process, henceforth for R3. Okay. Submits that the copies are not served on him. No representation for the appellant. Yaar, who has moved it? Court hall moved anta ಇದೆ. ಅವರೇ ಮೂವ್ ಮಾಡ್ತಾರೆ, ಅವರೇ ಬರೋದು. List on date. 5/7.
Yes, ma'am.
One memo we did not dispose. ಅವರೇ ಹಾಕಿರ್ಬೇಕು ವರ್ಷ. Yes. We are the beneficiary. What is the award amount? Where is your valuation? Valuation slip ಹಾಕಿದ್ದೀರಾ? ಇಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ. valuation slip. ಇಲ್ಲ ಪೇಜ್ ನಂಬರ್ ಎಲ್ಲ valuations. 23 ಅಂದ್ರೆ ಕಾಸ್ಟ್ ಐಟಮ್ ಕಾಣ್ತಾ ಇದೆ. ಈ ಕಡೆ ಬ್ಯಾಕ್ ಸೈಡ್ 1 crore. So execution is passed, filed or Okay. Issue notice to the respondent. Interim stay of execution of the included award till next hearing date. Subject to the appellant depositing 50% of the award amount before the reference court within 4 weeks from the date of the receipt of a copy of this order. 40%. 40%. 40% of the award. List on 30. Till next year. Oh, sorry. ನಮಗೆ SCP ಇರೋದೇ ಇಲ್ಲ ಹಾಗಾಗಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾನ್ಸ್ ಅಂತ ಮಾಡಿದ್ವಿ ಅದರಲ್ಲಿ ರೆಸ್ಪಾನ್ಸ್ 1 to 7 ಅಂತ ಮಾಡಿದ್ವಿ. Learned SCP is directed to accept notice for respond number 8. ಇದೆಲ್ಲ ಹಾಕ್ಬಿಡಿ ಕಾಪಿ ಸಾರು ಮಾಡಿ ಅವ್ರಿಗೆ ಇಷ್ಟ.
Number 48, A. Ravishankar.
As requested, Oriental Insurance Company. ಇವ್ರು ಬೇರೆ ರವಿಶಂಕರ್ ಅವ್ರು ಬೇರೆ ರವಿಶಂಕರ CR ರವಿಶಂಕರ್. ನೀವು ಅವ್ರಿಗಿಂತ ಮೊದಲಲ್ವಾ? A comes before C. You should be very prompt. Yes. As requested, list in the next week.
Number 49, I will fetch.
My lord, in this case, I am for the appellant. My lord, the order dated 5/6, my lord, non-taking of steps as against 1 and 2. It was on first occasion at 10:30 I was taken, my lord, on very same day.
Now you have taken. You have paid the process, you know?
Yeah, on 5/6 or 2013, 2020-23, my lord, which was listed on 230 list. And 10:30, my lord, before the counter, I have paid the process and taken steps, my lord.
Verify my list barley hagidre, then we'll pass order.
And also one more request, my lord, I may permitted to serve, my lord, trial court advocate 1 and 2 simultaneously, my lord.
Notice ಆದ್ರೆ ಹೋಗಿ ಬರ್ಲಿ, why such urgency?
ಅಲ್ಲಿ ಅಡ್ರೆಸ್ ಬರೀ ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ ಸಮಯ ಅದರಲ್ಲಿ 2 ಸಾರಿ ತಗೊಂಡಿದ್ದೀನಿ. In case it is not served, my lord, again very
Permit ಮಾಡೋದಿಲ್ಲ. It's a claimant's appeal.
Yes, my lord. My claim petition is dismissed.
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ? ಕಟ್ಟಿದ್ದಾರೆ ನೀವೆಯಾ? Sorry.
On 5/6 itself, I paid.
That was only against recall the order dated 5/6. The dismissal was for the entire appeal.
No, insofar as the 2 and 3.
Appeal against respond number 1 and 2 already.
Yes, my lord, 1 and 2, my lord.
ಇವ್ರು ಯಾರಿಗೆ ಕಟ್ಟಿದ್ದಾರೆ process 1 and 2. Order 1 of 2023. Since the appellant has done the needful in respect of his call number 1 and 2, the order dated 5/6/2023 dismissing the appeal against them is hereby recalled. IA 1 of 2023 is disposed of accordingly. Issue notice to respondents
1 and 2.
1 and 2.
And also permitted to serve, my lord.
Now, why should this permit to you take necessary steps? If they do not appear, then you can take sub-service also.
ಈ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಇದಾರೆ ಸ್ವಾಮಿ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ
Accountable if you serve there. ಅವ್ರು ಬಂದು ಅಪಿಯರ್ ಆಗೋದಿಲ್ಲ, ಅವಾಗ ಏನ್ ಮಾಡ್ತೀರಾ?
ಅದರ್ವೈಸ್ ಐ ಟೇಕ್ ಔಟ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್.
ಇಲ್ಲ ಪರ್ಮಿಟ್ಸ್ ಮಾಡೋದಿಲ್ಲ.
Number 50, P. Maheshra.
What about respond number 1? HDFC ಯಾರಿದ್ದಾರೆ?
I will take notice, my lord, HDFC.
And the star due to the release.
ನಿಮ್ ಇದರಿಂದ ಏನೋ ಸ್ಟಾರ್ ಗಿರ್ ಎಲ್ಲ ಬರ್ತಾ ಇದೆ, ವಿಜಯ್ ಕುಮಾರ್ ಅವ್ರದ್ದೇನದು?
Please, my lord.
Some dictation we are hearing from your office.
I'm sorry. Please, madam.
HS Lingaraj, D Vijay Kumar.
ತಗೊಳ್ತಾರಂತೆ ಬಿಡಿ. Shri D. Vijay Kumar, standing counsel for respondent is requested to accept notice for respondent, but ಅದೆಲ್ಲ ಉಳಿದಪ್ಪ issue notice for respondent number 1. Delay ಇದೆಲ್ಲ ಏನು list of
21/7. Number 51, Nakarti.
Learned ECP is requested to accept notice for respondent number 2. Issue notice to respondent number 1. Interim staff ಇದರಲ್ಲಿ 26 lakhs ಇದೆ ಅಲ್ಲ 50% ಕಟ್ಟಿ. Interim staff execution of the include award till next year in date, subject to the appellant depositing 50% of the award amount before the reference court within 4 weeks from the date of the receipt of the copy of this order. List on 31/7.
Number 52, DS Sachiv.
National Insurance Company ಯಾವಾಗಿಲ್ಲ given. Shri Rajendra Hegde, Learned Standing Counsel is requested to accept notice for respondent number 2. What about respondent number 1? Right, ಅವ್ರು summons notice ತಗೊಳ್ತೀರಾ ಏನು ಅವ್ರಿಗೆ ಏನ್ ಮಾಡಿದ್ರು ಕೆಳಗಿನ ಕೊಟ್ರಿ issue notice to respondent number 1. List on later. 22.
Number 53, Harish Mandavati.
Here are national insurance. No, this is a claimant's appeal. National error. Rajendra Hegde Mulkala. Shri Rajendra Hegde Mulkala, Learned Standing Counsel for respondent number 3 is requested to accept notice for respondent number 3. Copy serve ಮಾಡಿ ಅವ್ರಿಗೆ. What about 1 and 2? 1 and 2. ಹಾಗಿದ್ರೆ ಮೆಮೊ ಹಾಕ್ಬೇಕಲ್ಲ ಏನು whether they were they are contested or are not contested. First respondent is the driver. Response 1 and 2 contended that first respondent is in our statement of objection. I can issue notice to respondent number 1 and 2. List on 21st. Delay ಇದೆ ಹಂಗಂದ್ರೆ.
Number 54, Raja Ramesh. Raja Ramesh.
Reliance Insurance. Reliance ಯಾರಿದ್ದಾರೆ? ಎಲ್ಲರೂ ಇಲ್ಲ.
HS Lingaraj, Ashok and Patil, D Pradeep, D Vijay Kumar, DS.
These are
DS.
yes, these are Learned Standing Counsel for respondent is requested to respondent to ಅದೆಲ್ಲ ಮಾಡ್ತೀನಿ. Issue notice to respondent number 1. List on
21/7. Number 55, PR.
$54 lakhs 12,000 217 ಇದೆ. 40% ಮಾಡಿ ಯಾವಾಗ ನೋಟಿಫಿಕೇಶನ್ ಯಾವುದು? ನೋಟಿಫಿಕೇಶನ್ ವಾಸ್ ಆಫ್ ವಿಚ್ ಇಯರ್? Award recent, but 1999 is you have not you have deposited 40% ಆದ್ರೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಅದನ್ನೇನು ಇಂಟ್ರೆಸ್ಟ್ ವೇವ್ ಮಾಡಿರ್ಲಿಲ್ವಾ ಆ ಪೀರಿಯಡ್ಗೆ? ದಟ್ ಡಿಸ್ಮಿಸಲ್ ಪೀರಿಯಡ್ ಮಾಡಿದ್ದಾರೆ. You have no idea. Interest with principal ಅಷ್ಟೇ ಕಟ್ಟಿ. Issue notice to the respondent. ಇದರಲ್ಲಿ ಒಬ್ರು ಇವ್ರು ಇರ್ತಾರಲ್ಲ. Learned HCP is requested to accept notice for respond number 2. ಉಳಿದಿದ್ದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. Issue notice to respond number 1. Interim stay of the execution of the improved award till next hearing date, subject to the appellant depositing 40% of the award amount before the tribunal. Within 4 weeks from the date of the receipt of copy of this order. Discount.
Number 56, Shrikant Patil case. Shrikant Patil.
Okay. Yes. Payments of payment. Case of death. Branch manager, United India Insurance Company. Yaar is United India Insurance yaar idira? Shri V.C. Shivanegoda, standing counsel for respondent number 3, is requested to accept notice for respondent number 3. Avrike serve ಮಾಡಿ DP Shri Shivanegoda ಅವರು. There is delay. Issue notice to respondents 1, 2 and 4. List on. File the appeal. Which is the appeal number? Then why did you not mention so far? You don't have appeal number. Then let the notice go there. After service, you can get that. We do not even know which advocate has filed that appeal. Insurance company has preferred the appeal. You will grant you some time, then come up, examine and come to us. Other notice as requested by 56, as requested by the appearance council. List on date hearing.
27-6.
If by next hearing date you come up with that particulars.
Number 57, Srinivas Reddy.
Oriental Insurance Company. ಯಾರಿದ್ದಾರೆ? ಯಾರಿದ್ದಾರೆ? ಶ್ರೀ ಜನಾರ್ದನ್ ರೆಡ್ಡಿ ಅವರೆಲ್ಲ ಇದ್ದಾರೆ. Shri Janardhan Reddy, standing counsel for respondent, is requested to accept notice for respondent number 2. Copy serve ಮಾಡ್ಯಾರ. Notice respondent number 1 ಹೋಗ್ಬೇಕಾ? Fiction is partly allowed. Whom the liability is fastened? Then you want to take notice to respondent number 1? Respondent number 1 was expert. Then you file a memo. You file memo for dispensation. Allow counsel for the appearance of this memo for dispensation of notice to respondent number 1. Respondent number 1 was expert, was placed expert before the tribunal. Therefore, notice to respondent number 1 is dispensed with as paid for. Delay ಎಷ್ಟಿದೆ? ಏನು ಕಂಡನ್ ಮಾಡಬಹುದಾ ಅಥವಾ ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ರೆ? In case of injury, no? Injury case or death? I suffered severe pain actually. What was the disability? Percentage of disability? Complete ground ಮಾಡಿದ್ದಾರೆ. Was there any permanent physical disability? Not accepting the reasons assigned to explain the delay. Delay of 104 days in filing the appeal is found in the interest of justice. I number 1 of 2023 is disposed of accordingly. Admit call for TCRs. List of very ಅಲ್ಲ disability point ಇದ್ರೆ settle ಮಾಡ್ತಾರಾ record as requested by both sides. Refer to
Number 58, Mushtaq Ahmad.
Reliance, huh? Reliance Insurance, ಯಾರಿದ್ದಾರೆ ರಿಲಯನ್ಸ್ ಅವರು ಲೋಕಲ್ ಇಲ್ಲಿದ್ದವ್ರು ಯಾರು ಇಲ್ವಾ?
I'll take notice, my lord.
ತಡೀರಿ ಬೇರೆ ಇನ್ಯಾರ್ಗಾರ ಕೊಡೋಣ ಇಲ್ಲಿರೋರ್ಗೆ.
ನೋಡಿ ಯಾರನ್ನ ಇದ್ರು ಕೊಡಿ.
Raju Ashok and Patil, B Pradeep, D Jaykumar, D Sridhar, HC Betsu.
ಬೆಕ್ಸೂರ್ ಅಂದ್ರೆ ಯಾರಂತ ನೋಡಿಲ್ಲ.
HS ಲಿಂಗರಾಜ್.
ಇವ್ರು ಕೊಡೋಣ ಯಾರು ಅಶೋಕ್ ಪಾಟೀಲ್ ಅದ.
HS ಲಿಂಗರಾಜ್.
HS ಲಿಂಗರಾಜ್ ಅವ್ರಿಗ ಆಯ್ತು. HS ಲಿಂಗರಾಜ್ ಪ್ಲಾನಿಂಗ್ ಕೌನ್ಸಿಲ್ ಕರೆಸ್ಪಾಂಡ್ ಟು ರಿಕ್ವೆಸ್ಟ್ ಟ್ಯಾಕ್ಸ್ ಆಫ್ ನೋಟಿಸ್ ಕರೆಸ್ಪಾಂಡ್ ಬಿಟ್ಟು ಅದೆಲ್ಲ ಬರ್ಕೊಳ್ಳಿ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡ್ ಮಾಡೋಣ ಲಿಸ್ಟ್.
Number 59, Mahesh Bayal.
Tata AIG. Tata AIG. SV Hegde. SV Hegde ಮತ್ತು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಕರೆಸ್ಪಾಂಡ್ ಬಿಟ್ಟು ರಿಕ್ವೆಸ್ಟ್ ಟ್ಯಾಕ್ಸ್ ಆಫ್ ನೋಟಿಸ್ ಕರೆಸ್ಪಾಂಡ್ ಬಿಟ್ಟು ಅದೆಲ್ಲ ಬರ್ಕೊಳ್ಳಿ. Issue notice to respondent number 1. There is delay. List down.
Number 60, D Jaykumar.
My lord, this appeal is by the HDFC Ergo General Insurance Company Limited, challenging the liability involvement of the vehicle in the accident. My lord, it is a self-fall, my lord. Vehicle is not involved in the accident. And moreover, my lord, the alleged vehicle involved in the accident is the HGV. He is having only LME and transport. Therefore, my lord, no liability. And 50% of the award amount.
Issue notice to the response. Interim stay of the execution of the intent award till next hearing date. Subject to the appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of the receipt of the copy of this order. List count 31.
Please, my lord.
Hearing. ಇದ್ರು ತಗೊಳ್ಳಿ ಅವ್ರು ಇವ್ರು ಅವಾಗಿಂದ ಕಾಯ್ತಾ ಇದಾರಂತೆ.
Number 30, they are represented because Shastri.
Review 7th April 2010. We are seeking review of this order 7th April 2010. Mandana Associates were representing in that case. Yes. What is the other case?
Other case is there.
Oh, that is March 2010.
2497 of 2005. Other one is January 85 2012. Filed by the insurance company. Allowed on 15 March 2010. The claimant is allowed on 7th day of April 2010.
One appeal was your appeal, insurance.
85/20 of 2004.
So, what had happened in that case? Petitions. In all, petitions are entitled to 5,43,000 as against, so that was reduced. Reduced.
Our appeal reduced.
7,81,000.
And then their appeal enhanced. And same claimant totally offended in both cases. This appeal is allowed. Fees 7,81,500.
Here, it was enhanced.
Enhanced part.
This was filed in 2005. No?
2005.
2490.
2004.
05. In the earlier case, who were representing the company? Jay Prakash, R. Jay Prakash. Yes. Yes, that's all.
Yes, first, represented by both the claimants, by people. And one is the 2497, represented by Mandana, he is no more. That's why I am very happy hearing this one. And also, the worship, entire amount they are invited in 2085 received after a lapse of 9 years.
Now, when the amount was deposited and received? When the amount was deposited and when they had taken it? Memo. Okay.
Deposited on 716 entire amount.
ಒಂದು ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಹಾಕಿದ್ ಮೆಮೋ ಹಾಕಿದೀರಾ? ಅವ್ರು ಹಾಕಿದ್ದಾರೆ.
ಪಾರ್ಟಿ ಸತ್ತೋಗಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ನಾವು
Syriac Joseph is Syriac Joseph.
But the whole petition does not abate.
ಹೌದು ಹೆಂಡ್ತಿದ್ದಾರೆ ಅದಕ್ಕಾಗಿ ಅದನ್ನ ಆತರ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ, ಕೋರ್ಟ್ ಹಿಂದೆ ಆರ್ಡರ್ ಮಾಡಿ.
She is a surviving girl.
ಹೌದು.
ಯಾವ ಡೇಟ್ ಅಲ್ಲಿ ಅಂತ ನೋಡಕ್ಕೆ. When did you file that memo? File on 19/10/2022, na? ಯಾವ ಡೇಟ್?
Died on 23/10/2007.
ಯಾವತ್ತು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ? ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆಫ್ ಅಲ್ಲ ಇದೆ, ಅದು ಸಿಕ್ತು. ಯಾವ ಡೇಟ್ ಹೇಳಿ?
This is the last payment is 27/7/16.
27/7/2016. ಅಂದ್ರೆ ಮೊದಲು you had deposited certain amount earlier. JDR execution was filed in 2020. Execution
only 24/27/2005.
One Indrani Rao filed the execution petition.
The amount has been taken out long back.
But ಇದು ಯಾರ amount? Execution 884. 2020. 884 of 2020.
884 of 2020. 20 payment. Order passed on 2010. They waiting for the accrued interest. Taking all the amount and accrued interest. Yes. Calculated, doubling the amount, but we got report for recovery of the amount. And then only we notice after that we have go to this court of the reason. When the execution also, he never come up before report at this time memo. The certificate to that he is continuing for attachment operation. This was explained to the and search the file and got out the file. Then we move before this.
Yes.
Cooperation, proper and for company to invest as well as the going also to withdrawing them. And as per this sort of report, we are not doing any order. And also same claiming for the effect. Each very low before report we not affect against the matter.
Now that execution is still pending.
The figure of this is there. The lawsuit has been paid in that. And the orders are also for this.
Yes.
And then after that, this one, we have filed the significantly.
Yes.
Judgment and retaining the.
Yes.
And was establishing appropriate order and not maybe good for a appropriate from 2010 to 2023.
Yes.
The government.
ನಿಮ್ ಅಡ್ವೊಕೇಟ್ ಏನ್ ಮಾಡ್ತಿದಾರೆ ಅವಾಗ ಹಂಗಾದ್ರೆ ನೋಟಿಸ್ ಆಫ್ ದಿ ಕೋರ್ಟ್ ಅಲ್ವಾ? ವಾಪೀಸ್ ಒಂದೇ ಅಲ್ವಾ?
One docket. I will explain everything. I will try to explain with the date.
ಒಂದೇ ಅಲ್ಲ.
Which
Admin duty ಇದೆ. ದುಡ್ಡು ತಗೊಳ್ಳೋದು. Who has the duty? Advocate ಸತ್ತೋದ ಮೇಲೆ ಅವ್ರಿಗೆ
advocate ಸತ್ತದ ಇತ್ತೀಚೆಗೆ.
ಕರೆಕ್ಟ್. ಎರಡು ಕೇಸಲ್ಲಿ ಒಬ್ಬರೇ ಅಪಿಯರ್ ಆದವ್ರು ನಿಮಗೆ
ಹೇಳ್ತೇನೆ. One by I kept quiet and with the date when I appeared, when the order passed, when the response.
ಯಾಕೆ ಇದು ಮಾಡ್ಕೊಳ್ತೀರಾ ಒಬ್ಬೊಬ್ರಾಗಿ? ನಿಮ್ಮನ್ನಂತೂ ಕೇಳಿರಲಿಲ್ಲ ಶಾಸ್ತ್ರಿ ಅವರೇ.
ನಾನು kept quiet.
ಇಲ್ಲ ರೀ, ಆಯ್ತು. ಏನಾದ್ರು ಆಕ್ಸಿಡೆಂಟಲ್ ಎರರ್ ಏನೋ ಇದ್ರೆ ವಿಲ್ ಕನ್ಸಿಡರ್ ದಟ್. ನೋಡೋಣ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತ ಅವರು. ಈಗ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೇಸ್ ಇನ್ನೂ ಪೆಂಡಿಂಗ್ ಇದ್ರು ವಿತ್ಡ್ರಾನು ಮಾಡೋದಿಲ್ಲ.
ಮಾಡಿಸ್ತೇನೆ ಸೋಮ.
ಈಗ ಮಾಡಿಸ್ತೀನಿ ಅಂದ್ರೆ ಆಯ್ತು. ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮುಗೀತಲ್ವಾ? ವೇಟ್. ಎಸ್
while drafting this petition, my learned friend has not at all noticed what is the truth available in the net. My lord, what happened is, my lord, with fairly I am submitting, and I am going to justify my submission that it is only by mistake and oversight these happened, and just to avoid further the problem, I am ready to accept my lord's order retaining this reduction order of the first order made by this honorable court. How? But if I made some investigation through this net, my lord, may kindly see in the first case 8520 of 2004. Very interesting point is there. ಇವ್ರು ಹೇಳ್ದಂಗೆ ಇವ್ರು ನೋಟಿಸಿಗೆ ಬಂದದ್ದು ಈಗಲ್ಲ, 2004 ಇಸ್ವಿಲೇ ನೋಟಿಸ್ ಬಂದಿದೆ. ಅದನ್ನ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಎಸ್ಟಾಬ್ಲಿಷ್ ದ ಸೇಮ್. 8520 filed by RJ Prakash. In this case is disposed on 12/3/2010. Immediately, copy has been applied by the insurance company on 22/3/2010. Immediately. And same is received on 21/6/2010. ಇಷ್ಟಕ್ಕೆ ಒಂದ್ಸಲ ನಿಲ್ಲಿಸ್ತೇನೆ. ನಮ್ ಕೇಸಿಗೆ ಬರೋಣ. ನಾ ಇದ್ರಲ್ಲಿ ಯಾವ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿದ್ದೇನೆ ನನಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ಈ ಕೇಸು. ಆವಾಗ ಬಳ್ಳಾರಿ ಎಕ್ಸ್ಪ್ರೆಸ್ ಆಗಿತ್ತು. ದಿನ 100-120 ಕೇಸ್ ಡಿಸ್ಪೋಸ್ ಆಗ್ತಿತ್ತು. ನಮ್ಗೆ ಇದು ಏನು ಈ ನೆಟ್ ಇದಿರ್ಲಿಲ್ಲ. ಯಾರೋ ವಕಾಲತ್ ಕೊಟ್ರು ಹಾಕ್ಬಿಟ್ಟೆ ಸ್ವಾಮಿ. ನನ್ಗೆ ಗೊತ್ತೇ ಆಗ್ಲಿಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟು ಕೊಟ್ಟಿಲ್ಲ. ಅದು ಆದೇಶ ಬಂದಾಗ ನಾನು ಪ್ರೆಸೆನ್ಸ್ ಕೂಡ ಇರ್ಲಿಲ್ಲ. ನಾನು ವಕಾಲತ್ ಕೂಡ ನೆಟ್ಟಲ್ಲಿ ಕಾಣ್ತಾ ಇಲ್ಲ. ನಾನು ಆಮೇಲೆ ಈ ಒಂದು ಐಎ ಕೂಡ ಹಾಕಿದ್ದೇನೆ ಇದ್ರಲ್ಲಿ.
ವಕಾಲತ್ ಇರ್ಲಿಲ್ವಾ? ಸೆಕೆಂಡ್
ಅಲ್ಲ, ಇದೆಯೋ ಇಲ್ಲ ಗೊತ್ತೇ ಆಗ್ತಾ ಇಲ್ಲ ನನಗೆ.
ಕಾಣ್ತಿರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಅದಕ್ಕೆ
ಅದೇ ಇದು ನೆಟ್ಟಲ್ಲಿ ಕಾಣ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದೆ. ನೆಟ್ಟಲ್ಲಿ ಕಾಣ್ಲಿಲ್ಲ.
ನೀವು ಕೋರ್ಟಿಗೆ ಬಂದು ರೆಕಾರ್ಡ್ ಚೆಕ್ ಮಾಡಿ. ವಕಾಲತ್ ಮೆಮೋ ಆಫ್ ಅಪಿಯರೆನ್ಸ್ ಇದೆ ಅಲ್ಲ ಇಲ್ಲಿ.
ಮೆಮೋ ಆಫ್ ಅಪಿಯರೆನ್ಸ್ ನಮ್ಗೆ ಗೊತ್ತೇ ಆಗ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಮೆಮೋ ಆಫ್ ಅಪಿಯರೆನ್ಸ್ ಎರಡು ಕಾಮನ್ ಹಾಕಿದ್ದಾರೆ ಅವರು.
ಆಗ್ಲಿ ನನಗೆ ಅದು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. ಅದು ನನ್ಗೆ ನೆಟ್ ಅಲ್ಲಿ ಸಿಗ್ಲಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಹೇಳ್ತೇನೆ. ನೆಕ್ಸ್ಟ್
ನಿಮ್ ಪಾರ್ಟಿ ಗೊತ್ತಿರುತ್ತಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಹೇಳ್ತೇನೆ. 70 ವರ್ಷದ ಮುದುಕ ಈಗಾಗಲೇ ಸತ್ತೋಗಿದ್ದಾನೆ. ಈ ಕಣ್ಣು ಕಿವಿ ಯಾವ್ದು ಕೇಳದೆ ಒಂದ್ ಮುದುಕಿ ಇದ್ದಾರೆ.
70 ವರ್ಷ. ಅವಾಗ ಇಷ್ಟು ವರ್ಷ ಆಯ್ತು, ಈಗ 70 ವರ್ಷ
ಆಯ್ತು ನಾ ಹೇಳ್ತೇನೆ ಒನ್ ಬೈ ಒನ್. ಈಗ ಇಟ್ ಈಸ್ ಓನ್ಲಿ ಅನ್ ಆಕ್ಸಿಡೆಂಟಲ್ ಆಕ್ಟ್ ಅಂತ ನಾನು ಜಸ್ಟ್ ಇಟ್ ಈಸ್ ಓನ್ಲಿ ಅನ್ ಆಕ್ಸಿಡೆಂಟಲ್ ಆಕ್ಟ್ ಅಂತ ನಾನು ಹೇಳಲಿಕ್ಕೆ ಹೊರಟಿದ್ದೇನೆ ಹೊರತು ಯಾವುದೇ ರೀತಿ, ಯಾಕಂದ್ರೆ ನನಗೆ ಯಾಕೆ ಬೇಕಾಗಿ ಸಮಯ, ಐ ಆಮ್ ಅಪೇರಿಂಗ್ ಓನ್ಲಿ ಇನ್ ಹೈಕೋರ್ಟ್, 3000 rupees ಲಾಯರ್ ನಾವು, ನಮ್ಗೆ ಯಾವ ಬೆನಿಫಿಟ್ ಇದೆ? ಇಟ್ ಈಸ್ ಓನ್ಲಿ ಅನ್ ಆಕ್ಸಿಡೆಂಟ್, ಇಟ್ ಇಸ್ ಓನ್ಲಿ ಮಿಸ್ಟೇಕ್, ಇಟ್ ಈಸ್ ಓನ್ಲಿ ಅ ಮಿಸ್ಟೇಕ್.
ಅದಕ್ಕೆ ನಾವು ಕೇಳ್ತಾ ಇದೀವಿ, ಶಾಸ್ತ್ರೀಯ ಕೇಸಲ್ಲಿ ಜನರಲಿ ಹೀಗೆ ಆಗೋದಿಲ್ಲ ಅಂತ.
ಆಗೋದಿಲ್ಲ. ಇಟ್ ದ ಫಸ್ಟ್ ಟೈಮ್ ಇನ್ ಇಟ್ ಇಸ್ ದ ಫಸ್ಟ್ ಟೈಮ್ ಇನ್ ಮೈ ಕರಿಯರ್ ಇನ್ 32 years ಸರ್ವಿಸ್.
ಹೇಳ್ತೀರಿ, ನಿಮಗೆ ಹೇಳ್ತಾ ಇಲ್ಲ, ಪಾರ್ಟೀಸ್ ಗೊತ್ತಿರುತ್ತಲ್ಲ.
ಗೊತ್ತಿರೋದಿಲ್ಲ ಸಮಯ, ಹ್ಯಾಂಗ್ ಗೊತ್ತಿರ್ತದೆ ನಮಗೆ? ಅಲ್ಲಲ್ಲ, ಗ್ರೌಂಡ್ ಹೇಳ್ತೇನೆ ನಾ ಹೇಳ್ತೇನೆ,
ತಂದು ಕೊಟ್ಟಿರ್ತಾರಲ್ಲ ಅವ್ರಿಗೆ ಗೊತ್ತಿರುತ್ತೆ. ನಿಮ್ ಬ್ರೀಫಿಂಗ್
ಗ್ರೌಂಡ್ ರಿಯಲ್ ಆವಾಗ ನೆಟ್ ಇರ್ಲಿಲ್ಲ, ಈಗಾದ್ರೆ ಇಮಿಡಿಯೇಟ್ ಗೊತ್ತಾಗ್ಬಿಡ್ತದೆ. ಅದು ಹಿಂಗಿದ್ದೆಲ್ಲ ಆಗದೇ ಇಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳ್ತೇನೆ ಸ್ವಾಮಿ. ಒನ್ ಬೈ ಒನ್, ವೆರಿ ಇಂಟ್ರೆಸ್ಟಿಂಗ್. ಡೇಟ್ಸ್ ಶೋಸ್ ಮೈ bona-fide and how the insurance company committed the mistake. Date shows, available in the net, it shows ಒಂದೇ ಡಾಕೆಟ್ ಅವ್ರದ್ದು. ನಮ್ದರ್ ಹಂಗಲ್ಲ, ವಕಾಲತ್ ಹಾಕಿದ್ವಿ, ಸೀರಲ್ಲಿ ಇಟ್ಬಿಟ್ವಿ, ಒಂದು ಲೆಜರ್ ಮೇಂಟೈನ್ ಮಾಡ್ತಿದ್ವಿ ಅವಾಗೆಲ್ಲ. ಈಗ ಅದು ಬೇಕಾಗೋದಿಲ್ಲ. ಆಮೇಲೆ ಎಷ್ಟೋ 6 ತಿಂಗಳಾದ್ಮೇಲೆ ಇನ್ನೊಂದು, ಯಾಕಂದ್ರೆ ಒಂದು 6 ತಿಂಗಳಾದ್ಮೇಲೆ ಪೇಪರ್ಸ್ ತಂದು ಕೊಡ್ತಾರೆ. ಓಹೋ, ಇಟ್ಸ್ ಅಪೀಲೇಬಲ್ ಕೇಸ್, ನಾವು ಅಪೀಲ್ ಆಗ್ತೀವಿ.
ನಾಟ್ ಅಬೌಟ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ರಿವ್ಯೂ ಪಿಟಿಷನರ್ ಬೀಯಿಂಗ್ ನೆಗ್ಲಿಜೆಂಟ್, ಇಟ್ ಈಸ್ ಅಬೌಟ್ ಪ್ಲೇಯಿಂಗ್ ಫ್ರಾಡ್ ಆನ್ ದ ಕೋರ್ಟ್.
ನಾಟ್ ಫ್ರಾಡ್ ಬರೋದಿಲ್ಲ ಸ್ವಾಮಿ.
ಅವ್ರ ನೆಗ್ಲಿಜೆಂಟ್
ಹೇಳ್ತೇನೆ. ಈಗ
ಆಫೀಸಲ್ಲಿ ಏನೇನ್ ಮಾಡ್ತಾರೆ ಯಾರಿಗ್ ಗೊತ್ತು?
ಅಲ್ಲ, ಮುಂದೆ ಹೇಳ್ತೇನೆ ಸ್ವಾಮಿ. ಸೊ the insurance company advocate received the copy on 21/6/2010.
Yeah, already said that, no repetition.
ಮುಂದೆ ಹೇಳ್ತೇನೆ. But we applied the copies, it is important, 13/10/2010. After about 6 months after disposal of my appeal, that is come to my knowledge that there is another appeal is filed, that is 13/12/2010 ನಾನು ಅಪ್ಲೈ ಮಾಡಿದ್ದೇನೆ, received on 3/1/2011. In my appeal is filed in 2497 of 2005. It is filed on 19/3/2005. 2497 filed by me is filed on 19/3/2005, and it is disposed of on 7/4/2010, and immediately next day, see my vigilance, my lord, 7/4/2010 is disposed agide. 8/4/2000 only next day I applied the certified copy and received the same on 10/5/2010. Only when it is come to the notice, when I send the copies to the trial court advocate, he said, "Arey, another mattondu appeal ide idralli anta." Avaga I applied the certified copy. Melad avaga 100-110 ಕೇಸ್ ವರೆ ಒಂದ್ ದಿನಕ್ಕೆ ಡಿಸ್ಪೋಸ್ ಆಗ್ತಿತ್ತು, ನಮ್ಗೆ ಗೊತ್ತೇ ಆಗ್ಲಿಲ್ಲ.
ಕರೆಕ್ಟ್, ಅದು 2010 ಅಲ್ಲಿ ನೀವು ಹೇಳೋದು.
ಹೌದು
2020 ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಯಾಕೆ ಫೈಲ್ ಮಾಡ್ಕೊಂಡ್ರಿ?
ಅದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಕೇಳಿ
ನಿಮಗೆ ಗೊತ್ತಾದ್ಮೇಲೆ ಮಿಸ್ಟರ್ ಶಾಸ್ತ್ರಿ
ಅವರಿಗೆ ಅದರಲ್ಲಿ ನಾ ಹೇಳ್ತೇನೆ, ಇಟ್ ಮೇ ಬಿ ಲೇಕ್ ಅಪ್, ಇಟ್ ಮೇ ಬಿ ಲೇಕ್ ಅಪ್.
ರಿಪೀಟಿಂಗ್, we are not asking about you or your conduct, your party's conduct. ಆಯ್ತು, ನೀವು 2010 ಅಲ್ಲಿ you did everything clearly, but your party applied. You said in 2010 only you came to know that there were 2 appeals. None of you filed any application for review or recalling this.
ಹಾಕಿದ್ದೇನೆ, ಅದಕ್ಕೆ ಬರ್ತಾ ಇದ್ದೇನೆ.
And then how did you file execution in 2020?
ನಾ ಹೇಳ್ತೇನೆ, 11/1/2011 I filed a petition before in the same, ಅದು ಫೈಲ್ ಅಲ್ಲಿ ಕಾಣ್ತಾ ಇಲ್ಲ, 11 ನೆಟ್ ಅಲ್ಲಿ ತೋರಿಸ್ತಾ ಇದೆ. 11/1/2011 ಗೆ by bringing it to all to the notice of this court, I filed a petition. ಅದಕ್ಕಾಗಿ ಇದೆಲ್ಲ ಬೇಡ ಸ್ವಾಮಿ, ರಿಕಾಲ್ ಮಾಡಿ, ನಂದೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. ಆದ್ರೆ ಒಂದೇ ಒಂದು ನನ್ಗೆ ಹರ್ಟ್ ಆಗ್ತಾ ಇರೋದು, ದೇರ್ ಇಸ್ ಎ ಫ್ರಾಡ್ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು ನನ್ಗೆ. ಇಟ್ಸ್ ವೆರಿ, ಯಾಕಂದ್ರೆ ನಾನು ಐ ಮೇ ಬಿ a part and I may become the part of that fraud. ಅದೇ that pinches me. ಇದ್ರಲ್ಲಿ ಏನು ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ಆ ಕಾಲುವೆ ಹಂಗಿತ್ತು. ಯಾಕಂದ್ರೆ ಅವಾಗ
why do you spend time in this? You said you have filed a petition. Which is that petition number ಕೊಡಿ ನೋಡೋಣ.
ಅದ್ರಲ್ಲೇ ಇದೆ, ನೆಟ್ ಅಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ. 10/1/2011
ನೀವು ಹೇಳಿದ ಮೇಲೆ ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋ ಜವಾಬ್ದಾರಿ ನಿಮ್ದು.
ಅಲ್ಲ, ಇದೇ ಫೈಲ್ ಅಲ್ಲಿ ಇದೆ, ಇದೇ ಫೈಲ್ ಅಲ್ಲಿ ಇದೆ, ನೆಟ್ ಅಲ್ಲಿ ಇದೆ, ನೆಟ್ ಅಲ್ಲಿ ಇದೆ.
ಕೇಸ್ ನಂಬರ್ ಕೊಡಿ. You can't claim too much. ನೆಟ್ ಅಲ್ಲಿ ಇದೆ, ನೀವೇ ನೋಡ್ಕೊಳ್ಳಿ. ವಾಟ್ ಇಸ್ ದಿಸ್?
ನಾಳೆ ನೀವೇ ನೋಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿಲ್ಲ ಸರ್, ದಯವಿಟ್ಟು ತಪ್ಪು ಸಿಟ್ ಮಾಡಬೇಡಿ ಸ್ವಾಮಿ. ಇದು ವಿಷಯ ನಾನು ನೋಡ್ತಾ ಇದ್ದೀನಿ. ದಯವಿಟ್ಟು ಇದು ಕೇವಲ ಮಿಸ್ಟೇಕ್ ಅಂತ ಹೇಳೋದಷ್ಟೇ ನನ್ನ ಕೆಲಸ.
ವಾಟ್ ವಿ ಆರ್ ಟ್ರೈಂಗ್ ಟು ಸೇ ದಿಸ್ ಅಟಿಟ್ಯೂಡ್ ಇಸ್ ಇನ್ಕರೆಕ್ಟ್ ಅಂತ ಹೇಳ್ತಾ ಇದೀವಿ. ಯಾಕೆ ಮಾಡ್ಕೋಬಾರ್ದಿತ್ತು?
ಅಲ್ಲ, ಈಗ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಸ್ವಾಮಿ ಈಗಾಗಲೇ ಸ್ಟೇ ಆಗಿದೆ, ಅದು ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀರಿ ತಾವು, ಅವ್ರು ಪ್ರೊಸೀಡ್ ಆಗ್ತಾ ಇಲ್ಲ, ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೈಸ್, ದುಡ್ಡು ಬರ್ತದ ಅನ್ನೋ ಆಸೆಗೆ ಹಾಕಿದ್ದಾರೆ. ಅದ್ರಲ್ಲಿ ನನ್ನ ಹತ್ರ ಕೇಳಲೂ ಇಲ್ಲ ಅದನ್ನ.
ಅದು ಡಿಸಾನೆಸ್ಟಿನೇ ಅಲ್ವಾ, ದುಡ್ಡು ಬರುತ್ತೆ ಅನ್ನೋ ಆಸೆಗೆ ಏನಾರ ಮಾಡೋದು.
ಅಲ್ಲ, ಒಂದ್ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ, ತಪ್ಪ ಸರಿಯೋ ಒಂದ್ ಆರ್ಡರ್ ಇದೆ. ಈಗ ಮತ್ತೊಂದು ಹೇಳ್ತೇನೆ, ಅಲ್ಲ ಒಂದ್ ಜಜ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ ಅವ್ರ ಪರವಾಗಿ.
Don't deviate. You said you have filed an application to recall. What is the number of that application?
11/1/2011 ಗೆ 11/1/2011
ಯಾವ ಕೇಸಲ್ಲಿ ಹಾಕಿದ್ರಿ?
ಇದಕ್ಕೆ ಈ ಅವ್ರ ಕೇಸಲ್ಲಿ ನಾವೊಂದು ಇದ್ರ ಹಾಕಿದ್ದೇನೆ ರಿಕಾಲಿಂಗ್ ಗೆ. ಇದು ಹಿಂಗ ಆಗೋಗಿದೆ, ತಪ್ಪಾಗೋಗಿದೆ ಅಂತ ನನ್ನ ಹತ್ರ ಕಾಪಿನೇ ಇಲ್ಲ.
ಕೇಸಲ್ಲಿ ಹಾಕೋಬೇಕಿತ್ತು.
2000 ಅದೇ ತಪ್ಪಾಗಿದೆ ಸ್ವಾಮಿ. ಅವಾಗ ನಾನು
ಅಲ್ಲಿ ರೆಡ್ಯೂಸ್ ಆಗಿತ್ತು, ಅದಕ್ಕೆ ಅಲ್ಲಿ ಹಾಕೊಂಡ್ರಿ.
ಅಲ್ಲ, ನಾ ಹೇಳೋದ್ ಕೇಳಿ ಸ್ವಾಮಿ, ನಾನು ಎರಡನ್ನು ಇದು 2010 ಅವನ ಯಂಗ್ಸ್ಟರ್, ಈ ತರ ವಯಸ್ಸಾಗಿ ಮುದುಕಾಗಿರ್ಲಿಲ್ಲ, ಅನುಭವನೂ ಇರ್ಲಿಲ್ಲ. ಆವಾಗ ಎಂತ ಇಲ್ಲ ರಿಕಾಲಿಂಗ್ ಹಾಕ್ಬಿಟ್ಟೆ, ಆಯ್ತಾ. ಆ ಕಾಪಿನೂ ನನ್ನ ಹತ್ರ, ಯಾಕಂದ್ರೆ ಪಾರ್ಟಿ ಸತ್ತೋಗಿದ್ದಾರೆ, ಇದ್ರಲ್ಲಿ ಪಾರ್ಟಿ ಸತ್ತೋಗಿದ್ದಾರೆ. ದ ಜಜ್ಮೆಂಟ್ ಡೆಲಿವರ್ ಈಸ್ ನಾವ್ ಆಲ್ಸೋ ರಿಟೈರ್ಡ್. ಈಗ ಮತ್ತೊಂದು ಮೇನ್ ಇಂಪಾರ್ಟೆಂಟ್, ಮಂದಣ್ಣ ಅವರು ಸತ್ತಿದ್ದು ಇತ್ತೀಚೆಗೆ, ಅವ್ರು ಇಮಿಡಿಯೇಟ್ಲಿ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪ್ನಿಗೆ. ಆದ್ರೆ ಹೇಳ್ಬೋದಿತ್ತು.
ಅಲ್ಲ ರೀ, ಎಷ್ಟು ಸರಿ ರಿಪೀಟ್ ಮಾಡ್ತೀರಿ ಅದನ್ನ? ನಾವು ಹೇಳ್ತಾ ಇದ್ದೇವೆ, ನೀವ್ ಏನ್ ಹೇಳ್ತಿರೋ ಜಸ್ಟಿಫಿಕೇಶನ್ ನಿಮ್ದು ಹೇಳ್ರಿ, ಆಯ್ತು. ದೇ ಹ್ಯಾವ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದೇ ಆರ್ ಎಟ್ ಫಾಲ್ಟ್, ನೆಗ್ಲಿಜೆಂಟ್ ಇದ್ದಾರೆ ಅಂತಂದ್ರೆ
ಇಲ್ಲ ನೆಗ್ಲಿಜೆಂಟ್ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ,
ಜಸ್ಟಿಫೈ ಮಾಡ್ಕೊಳ್ಳಿ ನೀವು.
ಅಲ್ಲ ನಾನ್ ನೆಗ್ಲಿಜೆಂಟ್ ಅವ್ರು ನೆಗ್ಲಿಜೆಂಟ್ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. ಇಟ್ ಈಸ್ ಆಲ್ ಏನು ಮಿಸ್ಟೇಕ್ ಸ್ವಾಮಿ. ಇದೆ ನಾ ಈಗ ಏನ್ ಹೇಳ್ತಾ ಇರೋದು, ನಂದಾಗ್ಲಿ ಅವ್ರದ್ದಾಗ್ಲಿ ಯಾವ್ದು ಇಂಟೆನ್ಷನಲ್ ಆಕ್ಟ್ ಇಲ್ಲ ಅಲ್ಲಿ. ಯಾಕಂದ್ರೆ ಅವಾಗ ಮೇನ್ ಅಂದ್ರೆ ಇಂಟರ್ನೆಟ್ ಇರ್ಲಿಲ್ಲ. ಈಗ ಲಿಂಕ್ಡ್ ಕೇಸಲ್ಲಿ ಕೊಟ್ಟು ಕೂಡಲೇ ಬಂದ್ಬಿಡ್ತದೆ. ಅವಾಗ
ಇಂಟರ್ನೆಟ್ ಇತ್ತು
ಇಲ್ಲ, 2010 ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. ಅವ ನಮ್ದು ಎಂತದ್ದು ಅವ ಬೋರ್ಡ್, ಸೈನ್ ಬೋರ್ಡ್ ಇರ್ಲಿಲ್ಲ. ಅದು ಒಂದು ನಮ್ಗೆ
2010 ನೀವು
ಇಲ್ಲ ನಮ್ಮಲ್ಲಿ ಕಂಪ್ಯೂಟರ್ ಆಗಿದೆ 2002
2002 ನಲ್ಲಿ ಕಂಪ್ಯೂಟರೈಸ್ ಆಗಿರೋದು.
ಅಲ್ಲ, ಈ ತರ ಈ ವ್ಯವಸ್ಥೆ ಎಲ್ಲ ಇರ್ಲಿಲ್ಲ ನಮ್ಮ ಹತ್ರ. ಯಾವ್ದೋ ಈಗ ನೆಟ್ ಅಲ್ಲಿ ನೋಡಿದ ತಕ್ಷಣ ಬರೋದು, ಅದ್ಯಾವ್ದು ಇರ್ಲಿಲ್ಲ. ಸ್ವಾಮಿ, ಅದ್ಯಾವ್ದು ಇರ್ಲಿಲ್ಲ. ಸೊ ಮೈ ರೆಸ್ಪೆಕ್ಟ್ಫುಲ್ ಸಬ್ಮಿಷನ್.
ಶಾಸ್ತ್ರಿಗಳೇ ನಿಮಗೆ ಗೊತ್ತಾದ ತಕ್ಷಣ ಯು ವುಡ್ ಇನ್ಫಾರ್ಮ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ನಾಟ್ ಟು ಪ್ರೊಸೀಡ್.
2015 ಮರ್ತೋಗಿದೆ ಸ್ವಾಮಿ. 2011 ಇಸ್ವಿಲ್
ಅದು ಹೇಳಿದ್ರೆ ಎಷ್ಟು ಸರಿ ಹೇಳಿದ್ರು ಹೇಳಿದ್ದೆ ಹೇಳ್ತಾ ಇರ್ತಾರೆ. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
You would have instructed your trial court advocate not to proceed because already their petition, I have filed a petition before the High Court for recalling that order ಅಂತ ಹೇಳ್ಬೋದಾಗಿತ್ತಲ್ವಾ?
ಶಾಸ್ತ್ರಿಗಳು ಅವ್ರ ಕಾಂಡಕ್ಟ್ ಬಂದ್ಕೂಳೆ ಪಾಪದವರು ಸ್ವಾಮಿ ಸತ್ತೋಗಿದ್ದಾರೆ, ವಯಸ್ಸಾಗಿದೆ, ಅಥವಾ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರದ್ದು ಕಾಂಡಕ್ಟ್ ಬಂದ ತಕ್ಷಣ
ನಾನು ನನ್ನ ನಿಜವಾದ ಪ್ರಯತ್ನ ಮಾಡಿದ್ದೇನೆ. ಇದು ಎರಡೂ ಪಾರ್ಟಿಯಿಂದನೂ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಹೇಳೋದೊರ್ತು ಯಾವ್ದು ಇಂಟೆನ್ಷನಲ್ ಆಕ್ಟ್ ಅಲ್ಲ ಇದು. ಆ ಆರ್ಡರ್ ರಿಕಾಲ್ ಮಾಡಿ ಅಂತೂ ಹೇಳ್ತಾ ಇದ್ದೇನೆ. ಇನ್ನು ನಿಮಗೆ ಬಿಟ್ಟಿ ಸ್ವಾಮಿ, ನಾ ಏನು ಹೇಳೋದಿಲ್ಲ. ಇಟ್ ಈಸ್ ಓನ್ಲಿ ಅ ಮಿಸ್ಟೇಕ್. ಪಾರ್ಟಿ ಸತ್ತೋಗಿದ್ದಾರೆ, ಮತ್ತೆ ಈ ದುಡ್ಡು ತಗೊಳ್ಳಿಕ್ಕೆ ಯಾರಿಗೂ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ. ಈಗ ಅವಳು ಒಂದು ಮುದುಕಿ ಇದ್ದಾಳಂತೆ, ಅವಳನ್ನ ನಾನು ಆಫೀಸಿಗೆ ಕರ್ಸ್ಲಿಕ್ಕೂ ಆಗಿಲ್ಲ, ಕಣ್ಣು ಕಾಣೋದಿಲ್ಲ, ಇದಿಲ್ಲ.
earlier amount they had deposited and that was withdrawn alwa.
ಹೌದು, ಅದಾಗೋಗಿದೆ ಬಿಡಿ. ನಾನು ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಇವ್ರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ದಾರೆ ಹೇಳಿ ಯಾವಾಗ 10 ವರ್ಷದ
Let's see, in these kinds of cases ಆಯ್ತು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನವರೇ ಮಾಡಬಲ್ಲಕ್ಕೆ. There is a kind of unethical practice here, either on the part of the parties or on the concerned advocate. ಇಲ್ಲ ಅಂದ್ರೂ ಅಲ್ಲ ಹೇಳ್ತೀವಿ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೋರು ನೀವೇ ಹೇಳಿದ್ರಿ, ಅವ್ರ ಈ ತರ ತಪ್ಪಾಗಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ರು. ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಇನ್ ದ ಅರ್ಲಿಯರ್ ಅಪೀಲ್, ದಟ್ ಇಸ್ ಯಾವ್ದ್ರಲ್ಲಿ ರೆಡ್ಯೂಸ್ ಆಗಿತ್ತು ಅದ್ರಲ್ಲಿ, ಅದಕ್ಕೂ ಏನು ಮಟೀರಿಯಲ್ ಇಲ್ಲ ಇಲ್ಲಿ. ಫೈಲ್ಡ್ ಎನಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಟು ದಿಸ್ ರಿವ್ಯೂ ಪಿಟಿಷನ್? ನೋ ಕೌಂಟರ್ ಇಸ್ ಫೈಲ್ಡ್ ಟು ದಿಸ್ ರಿವ್ಯೂ ಪಿಟಿಷನ್. ಹಾಕಿದೀರಾ ಕೌಂಟರ್?
ಇಲ್ಲ, ಅದಕ್ಕೆ ನನಗೆ ಯಾಕಂದ್ರೆ ಒಂಥರ ಹರಿ ಬರೀಲಿತ್ತು. ಅವರಿಗೆ ಸ್ಟೇ ಬೇಕಾಗಿತ್ತು. ಡಿಲೇ 1040 ದಿನ ಡಿಲೇ ಇತ್ತು. ನನಗೆ ಇವರು ನನಗೂ ಕಾಪಿಯನ್ನು ಕೂಡ ಅವ್ರು ಪೋಸ್ಟಲ್ ಕಳ್ಸಿದ್ರು. ನಾ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೆ, ಆಯ್ತಾ. ಕಡೆಗೆ ಅವ್ರು ಪಾರ್ಟಿ ಸತ್ತೋಗಿದ್ದಾರೆ, ಆಫೀಸಿಗೆ ಬರುವರಿಲ್ಲ. ಇವರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಅವ್ರ ಮನೆಗೆ ಹೋಗಿ ಅವ್ರ ಮಾತಾಡ್ಸ್ಕೊಂಡು ಬರ್ಬೇಕಾಯ್ತು. ಇಂಥದ್ದೆಲ್ಲ ಬಹಳಷ್ಟು ನಡೆದಿದೆ ಸ್ವಾಮಿ. ಸೊ ಲಾಸ್ಟ್ ಮೈ ಸಬ್ಮಿಷನ್ ಇಸ್ in this case, my lord, this happened only because of these, accidentally. ಎರಡು ಪಾರ್ಟಿ ಅವರು ಒಂದಲ್ಲ, ಅವರು ಕಾಮನ್ ಡಾಕೆಟ್ ಅದ್ರ ಮಾಡ್ತಾರೆ. ಕಾಮನ್
ಹೇಳಿದ್ದೆ ಹೇಳ್ಬೇಡಿ,
ಹಂಗಾರೆ ಹೇಳ್ತಾ ಹೋಗ್ತೇನೆ ಸ್ವಾಮಿ, ಬರ್ಕೊಳ್ತಾ ಹೋಗಿ. ಇನ್ನು 2497
ಅಷ್ಟೇ ಬರ್ಕೊಳ್ತೀವಿ, ಹೇಳಿ.
ಸಾರಿ ಒಂದೊಂದ್ಸಲ ನಮಗೂ ಹಂಗ ಆಗ್ಬಿಡ್ತದೆ. 2497
ಮೈಂಡ್ ಯುವರ್ ಲ್ಯಾಂಗ್ವೇಜ್.
ಹೌದು,
ನಾವು ಬರ್ಕೊಳ್ತಾ ಹೇಳ್ತಾ ಹೋಗ್ತೀವಿ, ನೀವು ಬರ್ಕೊಳ್ತಾ ಹೋಗಿ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, ಇನ್ ಲೈಟರ್ ವೇ ಹೇಳಿದ್ದೇನೆ, ಸೀರಿಯಸ್ ಆಗಿ ತಕೊಳ್ಬೇಡಿ. ತಪ್ಪಾಯ್ತು, ಹಂಗೇನಾರ ಆಗದಿಲ್ಲ ತಪ್ಪು ನಮ್ದು.
ಅಂದ್ರೆ you always think that court should not be serious.
ಹಂಗೆಲ್ಲ ತಿಳ್ಕೊಳ್ಬೇಡಿ ಸ್ವಾಮಿ, ಹಂಗೆಲ್ಲ ಹೇಳಿಲ್ಲ ನಾನು. ಒಂದಿಷ್ಟು ಡೇಟ್ ಇದೆ, ಮೊದಲಿಂದ ಹೇಳ್ತಾ ಇದ್ದೇನೆ. ಆ ಡೇಟ್ ಅನ್ನು ಸ್ವಲ್ಪ ನೀವು ನೋಟ್ ಮಾಡ್ಕೊಂಡು.
1/11/2021 ಗೆ filed an application in the earlier appeal ಅಂತ ಹೇಳಿ.
ಅದಕ್ಕಿಂತ ಮೊದಲು 2497 ಗೆ ಬರೋಣ. ಇಟ್ ಈಸ್ ಡಿಸ್ಪೋಸ್ ಆನ್ 7/4/2010 and Mandana is appearing in this case. Immediately he applied the certified copy.
Yes.
Mandana applied certified copy on 8/4/2010 and received on 10/5/2010. We applied on 9/4/2010.
8/4/2010 ತಗೊಂಡ್ರು ಅಂತ ತೋರಿಸೋದಕ್ಕೆ ಏನಿದೆ ಇದರಲ್ಲಿ?
ನಾನು I totally relied upon the net, my lord. Totally relied upon net.
ಈಗ ಇಲ್ಲೇನು ಮೆಟೀರಿಯಲ್ ನಮ್ಮ ಮುಂದೆ ಏನಿರುತ್ತೆ ಅದ್ರ ಮೇಲೆ ರಿಲೈ ಆಗ್ತೀವಿ.
ಹೌದು, ನೆಟ್ ಅಲ್ಲಿ
ನೋಡ್ಕೊಳ್ಳಿ, ನೆಟ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, ನೋಡ್ಕೊಳ್ಳಿ, ಹಂಗಲ್ಲ ನನ್ನ ಮಾತಿಗೆ ಅಷ್ಟು ನೀವು ಈ ತರ ಮಾಡ್ತೀರಪ್ಪ, ನಾನು ಏನ್ ಮಾಡ್ಲಿ?
ನಮ್ಮ ಮುಂದೆ ಏನು ಮೆಟೀರಿಯಲ್ ಇಲ್ಲ, ಅವ್ರು ಅಪ್ಲೈ ಮಾಡಿದ್ರು ತಗೊಂಡಿದ್ರು ಅಂತ ತೋರ್ಸೋದಕ್ಕೆ. ನೀವ್ ಹೇಳ್ತೀರಿ ಇಲ್ಲೇನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದಿಲ್ಲ.
ಅದು I have taken the photos of that. It's an official website.
Yes.
My lord, in my case, Wakalat is filed by the insurance company on 22/12/2005.
My case means both of them were
Nandu 2 by the claimant.
Subsequent appeal. Yes.
22/12/2005.
Yes.
Well, that is why, even though insurance company managing common docket, there may be while allotting the cases to the advocate, they may committed some mistakes. So, since in my case, in their case, it is true, I filed only these wakalat and I forgotten it. Only when they sent subsequently I filed the appeal. So, my lord, since the trial court advocate sent the papers to me, after seeing this, because the deceased was aged 24 years, well, it is a trainee customer survey care, earning 97,088 per annum. Well, he is a bachelor. Well, claimants are parents. Tribunal, without adding towards future prospect and without considering the age of the deceased, only taking the age of the mother.
Are we supposed to hear the merits of
why I decided to file the appeal? Why I decided to file the appeal ಅಂತ ಹೇಳೋದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೇನೆ. ಅವರು ಪೇಪರ್ ಕಳಿಸಿದಾಗ I filed the appeal. ಯಾವಾಗ 19/3/2005. 19/3. Because after seeing that there is a merit in the case, Avaga Namgo e-file number 8520 of 2004. Idu 2497 of 2005. Serial itbitu. ಅಥವಾ ಇದು ಡಾಕೆಟ್ ಮಾಡಿದೇವೆ ಹೇಳು ನಮ್ಗೆ ನೆನಪಾಗ್ತಾ ಇಲ್ಲ, ಯಾಕಂದ್ರೆ ಅದು ಬಹಳ ಹಿಂದೆ 20 ವರ್ಷ ಆಗೋಯ್ತು. ಸೊ while the disposal of their case, ಅವಾಗೂ ನಮ್ಮ ಪ್ರೆಸೆನ್ಸ್ ಇರ್ಲಿಲ್ಲ ಅಲ್ಲಿ. ಇಷ್ಟೇ ಆದ್ರಿಂದ ಇಟ್ ಈಸ್ ಓನ್ಲಿ ದಿಸ್ ಟೂ ಜಡ್ಜ್ಮೆಂಟ್ಸ್, the outcome of this appeal is only by the mistake of both the parties, not only ಒಂದೇ ಕೇಳಿ ಚಪ್ಪಾಳಿ ಆಗೋದಿಲ್ಲ, only the mistake, not only mistake of
ಅವ್ರು ಕಂಡಕ್ಟ್ ಮಾಡ್ಕೊಂತಾರೆ ಎನ್ಕ್ವೈರಿನ. whether your office has conducted any inquiry against those concerned officials.
ಅದಕ್ಕಿಂತ ನಾ ಹೇಳ್ತಾ ಇರೋದು ಇಷ್ಟು ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದೇನೆ, ಅದ್ರ ರಿಕಾಲ್ ಮಾಡಿ ಸ್ವಾಮಿ, ನಮ್ದೇನು ಅಬ್ಜೆಕ್ಷನ್, ರಿಕಾಲ್ ಮಾಡಿ.
ಆಫೀಸಲ್ಲಿ ನಿಮ್ಮ ಆಫೀಸಲ್ಲಿ whether any action was taken against the concerned, ಅದೇ ಆಯ್ತಲ್ಲ. ಈಗ ಹಿಂದಿಂದು ಯಾರೋ some official must be in charge of the office is reconstructed. This was subsequent to the formation of the bench, right? This fiction is filed. The order is in 114 CPC and order 47 of the so provision what amounts to contempt and subcontent. Yes. Interferes or tend to interfere with the due course of judicial proceeding. Two and three both ಬರುತ್ತೆ. Obstructs the administration of justice. Seeking review of the judgment of this court dated 7/4/2010 in MFA number 2497 of 2007. ರೆಸ್ಪಾಂಡ್ ಅದು ಸತ್ತೋಗಿದ್ದನ್ನ ಇನ್ನೂ ಅದಕ್ಕೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ರೆ ದಟ್ ಈಗಲೇ ದಿಸ್ ಮ್ಯಾನ್ ದಿಸ್ ಸಿರಿಯಾಕ್ ಈಸ್ ಡೆಡ್ ಅಂತ ಏನೋ ಮೆಮೊ ಹಾಕಿದಾರಲ್ಲ ಒಂದು. ಈ ಸರ್ವೈವ್ಡ್ ಬೈ ಹಿಸ್ ವೈಫ್ ಅಷ್ಟೇ, ಅದೇನು ಅಬೇಟ್ ಅಂತೂ ಆಗೋದಿಲ್ಲ. ಯು ಅಮೆಂಡ್ ದ ಏನೋ ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಹಾಕಿದ್ದಾರೆ, ಅದು ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್. ವಿ ಡು ನಾಟ್ ನೋ whether why have you produced the xerox copy of the death certificate?
ಟ್ರೂ ಕಾಪಿ ಅಂತ ನಾ ಸಿಗ್ನೇಚರ್ ಮಾಡಿರ್ಬೇಕು ಸಮಯದಲ್ಲಿ.
ಅದೆಲ್ಲ ನಾವು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಳ್ಳೋದಿಲ್ಲ. ಇಲ್ಲಿ ಟ್ರೂತ್ ಹುಡ್ಕೋದೇ ಕಷ್ಟ ಆಗಿದೆ, ಇನ್ನು ಟ್ರೂ ಕಾಪಿಗಳನ್ನ ಹೇಗೆ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಳ್ಳೋದು? Respondents. Who is this? Rajshekhar is the owner of the vehicle. Response 1 and 2 filed MEC number 4997 of 2002 before the 14th additional MACT and small causes court Bengaluru, claiming compensation for the death of their son. What is his name? ಮೊದ್ಲಿಂದ ಎಷ್ಟಿದೆ, ಮೊದ್ಲಿನ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೆಸರು ಬಂದಿಲ್ಲ. ಸೆಬಿ ಸಿರಿಯಾಕ್. In that case, the tribunal had awarded compensation of 7,81,500 by award dated 12/11/2003. The review petitioner challenged that order before this court in MFA number 8520 of 2004. Respondents 1 and 2 contested the said appeal before this court. This court, on hearing the parties by both parties by the judgment dated 15/3/2010, partly allowed the appeal of the petitioner and reduced the compensation from 7,81,500 to 5,43,200. In the meantime, the claimants, respond number 1 and 2. Also, claimants had filed MFA number 2497 of 2005, seeking enhancement of the compensation. In both the cases, the insurer was represented by different counsel, but the claimants were represented by the same counsel. MFA number 2497 of 2005 was disposed of on 7/4/2010, enhancing the compensation from 40,000. By 40,000, by rupees 40,000. 7,81,500 earlier. In addition to the 7,81,000.
Enhanced by
7,81,000 is the what additional? Enhancing, awarding additional compensation of rupees 40,000 in addition to 7,81,500. The records show that when MFA number 2497 of 2007 came up for hearing, none of the parties represented brought to the notice of the court about the filing of MFA 8520 of 2004 by the insurer and the disposal of the same on 15/3/2010. To execute the award in MFA number 2497 of 2005, the claimants filed execution case number 884 of 2020 before the tribunal. The petitioner claims that it came to know about award in subsequent order in MFA number 2497 of 2005. MVC number so and so, execution case number so and so. The claimants even sought attachment of movables of the movable properties of the petitioner to recover the award amount in MFA number 2497 of 2005. This review petition was filed in 2022 on the ground that they came to know about the subsequent award only when they received the attachment warrant. And the fact that the claimants have played fraud without disclosing the disposal of MFA number 8520 of 2004. Next bit. Shri Sripad Shastri, Lawyers Council, for response 1 and 2, submits that since there were at that stage, at that time, there was no digitalization. He failed to note that two cases were filed against the same award. He further submits that when MFA number 2497 of 2005 came up for hearing, he had forgotten the disposal of the earlier appeal, that is MFA 8520 of 2004. He seeks to justify the action of the claimants on the ground that even the petitioner is also equally negligent. He submits that in the petitioner's office, they maintain the records. Therefore, they should be aware of the two cases as they had they had appeared and heard in both the cases. Next point. Maybe. Apparently, admittedly, in both the cases, the counsel who represented the petitioner were different. Further, any negligence on the part of the officials in the petitioner's counsel does not give any handle to the claimants to make unlawful gain by abusing the process of the court. They were aware of they were common parties in both the cases and represented through a common advocate. Further, to crown all this, they filed execution petition number 884 of 2020 and proceeded to seek the attachment of the properties of the claimant, the petitioner. By that time, they had already received the compensation awarded by the tribunal and which was reduced by this court in MFA number 8520 of 2004. At the most, if at all there is any dereliction of duty on the part of the officials of the petitioner, at the most that may give cause to the petitioner to initiate disciplinary proceedings against such officials. But that does not mitigate the misconduct of response one claimants, that is respond number 1 and 2. By such of their act, the response not only have abused the process of the court, they have even played fraud on the court. It is material to note that in this case, even statement of objections are not filed. Though the learner counsel for response 1 and 2 claim contended that on learning about such mistake, he filed an application in MFA number 8520 of 2004 to recall that order. Firstly, no material is placed in support of the same. Secondly, if at all any such application was to be filed, that should have been filed in the subsequent case, that is MFA number 2497 of 2005. That also shows that the claimants had an inclination to adopt unethical practices only to make wrongful gains. Order 40. It is no doubt true that Shri Shripa Shastri Learned Counsel conceded for recalling the order, but that will not, that doesn't permit relieving the claimants without any stringent, that doesn't permit the court foregoing of any action against claimant number 1 and 2. In this case, it was reported that claimant number 1 died. The original death certificate is also not produced. Even accepting the same, even if the same is accepted, he is survived by claimant number 2. Therefore, this petition does not abate. Section order 47. Ground. Section order 47 rule 1 provides for reviewing an order if it is found that such order suffers an error apparent on the face of the records or any sufficient reason. The fraud played by the claimants on the court is a sufficient reason to recall that order. Apart from that, the actions of the claimant, such acts of the claimant is nothing but an act of obstructing or tending to obstructing the administration of justice, which is a criminal contempt within the meaning of Section 2C of the Contempt of Courts Act 1971. For the aforesaid reasons, this review petition deserves to be allowed with cause and recommending for necessary action against the claimants in the matter. Hence, the following order: the review petition is allowed. The judgment order dated 7/4/2010 in MFA number 2497 of 2005 into bracket MV is hereby recalled. The appeal in MFA number 2497 of 2005 is dismissed with cost of rupees 1 lakh payable by payable by respond number 1 and 2 to the High Court Legal Services Authority, Karnataka State Legal Services Authority, within 4 weeks from the date of the receipt of a copy of this order. Within 4 weeks from the date of this order, failing which Member Secretary, Karnataka State Legal Services Authority shall recover the same in execution of this order. Further, Registrar Judicial is requested to place the matter before Honorable the Chief Justice for initiation of contempt against respond number 1 and 2.
Pastor matter, the hearing.
Serial number 3, madam.
Serial number 1 is some your junior colleague was telling that you have to produce certain documents. Yes. ಒಂದು ಅದರದ್ದು ಪರ್ಚೇಸ್ ಮಾಡಿರೋ ರಿಸಿಪ್ಟ್ ಕೇಳಿದ್ವಿ, ಇನ್ನೊಂದು whether she has undergone. ಇದ್ಯಾವ ಕೇಸ್ ಅದೇನಾ ಸೇಮ್ 1199. ನೀವು ನಮ್ ಕೈಗೆ ಬೇರೆ ಫೈಲ್ ಕೊಟ್ಟಿದ್ದೀರಿ. ಡೆತ್ ಕೇಸ್ ಕಾಣ್ತಾ ಇದೆ. ಅದೇ ಆಗಿದೆ 3540.
1199 ಕೊಡಿ.
ನೆಕ್ಸ್ಟ್ ಅಲ್ಲ ಕರೆಕ್ಟ್ ಈಗ ನೀವು ರೆಡಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಅಲ್ಲ ಇದು ಓನ್ಲಿ ಎಸ್ಟಿಮೇಟ್ಸ್ ಅಲ್ವಾ? Correct. What we had asked is, you have purchased it pending. ಯಾವಾಗ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದೀರಾ? 2012-2016. Description, unit price, total price. Purchase order. This is purchase order. Next page. Purchase order is not the receipt. Receipt. Delivery schedule. Delivery schedule ಆಯ್ತು. ಅದು wheel and axle plan.
Delivery schedule is just quantity words and then. And it would be 7,41,000 only.
Unit number is 1 ಅಂತ ಇಲ್ಲಿದೆ. ಆಯ್ತು. Correct. This is all about placing orders. ಅಲ್ವಾ? ಎಲ್ಲಿದೆ ಡಿಡಿ? ಡಿಡಿ ನಂಬರ್ ಏನು?
DD number is ಅಂದ್ರೆ delivery schedule details ಮೇಲ್ಗಡೆ. ಅದು ಮೇಲ್ಗಡೆ quantity words ಅಂತ.
ಆಯ್ತು, ಕ್ವಾಂಟಿಟಿ ಆಯ್ತು.
Rupees
7 lakhs ಕಂಜೈನಿ so and so. ಮೆಟ್ರನ್ ಹಾಸ್ಪಿಟಲ್ ರೇಲ್ ವೀಲ್ ಫ್ಯಾಕ್ಟ್ರಿ. ಇದು ಹಾಸ್ಪಿಟಲ್ ಹೆಸರಲ್ಲಿದೆ, ನಿಮ್ಮ ಹೆಸರಲ್ಲಿಲ್ಲ. ಡಿಮ್ಯಾಂಡ್ ನಂಬರ್ so and so, ಇಂಡೆಂಟ್. ಪ್ರಾಡಕ್ಟ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಕಂಜೈನಿ ಅಟ್ ರೇಲ್ ವೀಲ್ ಫ್ಯಾಕ್ಟ್ರಿ. ಡೋರ್ ಡೆಲಿವರಿ. ಇದ್ರಲ್ಲಿ ಏನು ನೀವು ಅವ್ರಿಗೆ ನೀವು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ ಅನ್ನೋದು ಏನಿದ್ರಲ್ಲಿ ಕಂಡು ಬರೋದು?
ಕೆಲಸ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ ಆಯ್ತು, ಫಾದರ್ ಆದ್ರೂ ಕೊಟ್ಟಿದ್ದಾರೆ ಅನ್ನೋದಕ್ಕೆ ಎಲ್ಲಿದೆ? ಡಿಡಿ ಕೊಟ್ಟಿದ್ರು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ನೀವು. ಶಿ ವಾಸ್ ರಿಪ್ರೆಸೆಂಟೆಡ್ ಬೈ ಹರ್ ಫಾದರ್ ಓನ್ಲಿ ಹಿಯರ್. ಅವ್ರ ಹೆಸರು ಬರ್ಬೇಕಿತ್ತಲ್ಲ, ವಿ ನಾರಾಯಣ ಸ್ವಾಮಿ ಅನ್ನೋರು. ಅಲ್ಲ ಅಂದ್ರೆ ಫ್ರೀ. ಕರೆಕ್ಟ್. ಅಲ್ಲ ಇದು ಯಾವ್ದೋ ಮೆಟ್ರನ್ ಹಾಸ್ಪಿಟಲ್ ಪರ್ಚೇಸ್ ಆರ್ಡರ್ ಪ್ಲೇಸ್ ಮಾಡಿದವರು ಮೆಟ್ರನ್ ಹಾಸ್ಪಿಟಲ್ ಅನ್ನೋರು. ನಾಟ್ ಹಾಗಾದ್ರೆ ನಿಮಗೆಲ್ಲ ಬರುತ್ತೆ ದುಡ್ಡು ಕೊಡೋದು? ರೇಲ್ ವೀಲ್ ಫ್ಯಾಕ್ಟ್ರಿ ಅವ್ರು ಕೊಟ್ರೆ ನಿಮ್ಗೆಲ್ಲ ಲಯಬಿಲಿಟಿ ಬರುತ್ತೆ. ಸೊ ಯು ಆರ್ ನಾಟ್ ಎಂಟೈಟಲ್ ಫಾರ್ ದಟ್. ಸೊ ನಾವೇನ್ ಅದ್ರಲ್ಲಿ 3 lakhs ಅಂತ ಏನೋ ಟ್ರಯಲ್ ಕೊಟ್ಟನವ್ರು ಕೊಟ್ಟಿದಾರ? ಎಷ್ಟು? 3 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ರು ಅವರು. ಸೊ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಸ್ಪೆಂಡ್ ಫಾರ್ ದಿಸ್ 3 lakhs. ಸೊ ಅದನ್ನ ರೆಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. They will, ಅಲ್ಲ ನಮ್ಗೆ ಅದೇ ಡೌಟ್ ಬಂದಿತ್ತು. ಇಂಥದ್ದೆಲ್ಲ ಸ್ಪಾನ್ಸರ್ ಮಾಡೋರು ಜಾಸ್ತಿ ಇರ್ತಾರೆ. ಚಾರಿಟೇಬಲ್ ಆರ್ಗನೈಸೇಷನ್ ಅವರು, ಆರ್ಟಿಫಿಷಿಯಲ್ ಲಿಮ್ಸ್ಗೆ ಅದು ಈ ತರ ಅನ್ಟೈಮ್ಲಿ ಈಗೆಲ್ಲ ಆದಾಗ ನೋಟ್ಸ್ ಬರ್ಬೇಕಿದ್ವಲ್ಲ ಇದರಲ್ಲಿ. 459. ಇಲ್ಲಿ ನಾವು ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ ಕೆಪಾಸಿಟಿ ಅದನ್ನ ಮಾಡಿ 6,800 8,500 ಅವಾಗಿನ ರೇಟ್ ಇಟ್ಕೊಂಡು 20%, 80% disability. ಅದಕ್ಕೆ 40% ಇದನ್ನು ಸೇರಿಸ್ಕೊಂಡು it has come to 2,720. 2,720 ಅಲ್ಲ 8,500 80% ಎಷ್ಟಾಯ್ತು? 6,800. 6,800 40% 2,720. 2,720 plus ಇಲ್ಲ ಅಲ್ಲಿ ಮೊದಲೇ 80% ಮಾಡ್ಬಿಟ್ಟಿದ್ವಲ್ಲ, ಆಡ್ ಮಾಡೋ ಕ್ವಶನ್ ಇಲ್ಲ. ಹಾ 6,800 2,720 9,500 ಇದು ಮಾಡಿದೀವಿ, ಕರೆಕ್ಟ್ ಇದು ಮಾಡಿದ್ವಿ. 5,920 12 into 18 ಮಲ್ಟಿಪ್ಲೈರ್ ಮಾಡಿದ್ವಿ. 20,56,320 ಫ್ಯೂಚರ್ ಅರ್ನಿಂಗ್ ಕೆಪಾಸಿಟಿ. What is this 60 lakhs? 6 lakhs or 60 lakhs? Figure just. She was hospitalized how long? 60,000 pain and suffering. How many times she underwent surgery?
49 days per contract.
60,000. What is this 29,600? Medical. 60,000 pain and suffering. ಅದು ಮಾಡಿ ನೋಡೋಣ ಮೊದಲು. 29,600 medical expenses. And this 40,000 Tribunal has also awarded accordingly. ಆಮೇಲೆ 50,000 ಅಮ್ಯುನಿಟಿ ಇದು ಕೊಟ್ಟಿದ್ದು ಬೈ ಟ್ರಿಬ್ಯುನಲ್. ಬಟ್ ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ ಕೆಪಾಸಿಟಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು ಅವರು? So we have modified it to some extent. ಅಂದ್ರೆ ಇಲ್ಲಿ ಬರೀಬೇಕಾಗುತ್ತಲ್ಲ ನಮ್ಗೆ. 20,56,320. ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ, 1 lakh ಮಾಡ್ಬೋದು. 1 lakh. ಆಮೇಲೆ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಇಸ್ ಬೇಸ್ಡ್ ಆನ್ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್. ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಎಷ್ಟು? 29,600. 600 ಅದು. ಆಮೇಲೆ 49 ಫುಡ್ ನರಿಶ್ಮೆಂಟ್ ಟ್ರಾನ್ಸ್ಪೋರ್ಟೇಷನ್ ಎಲ್ಲಾನು ಸೇರಿಸ್ಕೊಂಡೇನದು? ವೇರ್ ಶಿ ವಾಸ್ ಟ್ರೀಟೆಡ್? ಫುಡ್ ಟ್ರಾನ್ಸ್ಪೋರ್ಟೇಷನ್ ಅಟೆಂಡೆನ್ಸ್ ಅಲ್ಲ, ಶಿ ಇಸ್ ರೆಸ್ಟ್ ಎಲ್ಲ ಅವ್ರು ಬೆಂಗಳೂರಲ್ಲೇ ಇರೋದಾ? 49 days. ಆಯ್ತು 40,000 ಆಯ್ತು. Then amenities ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಅಂತೀವಿ? ಮ್ಯಾರೇಜ್ ಅಲ್ಲ, ದಟ್ ಇನ್ಕ್ಲೂಡ್ಸ್ ಮ್ಯಾರೇಜ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಎಲ್ಲ ಅದರಲ್ಲೇ ಬರುತ್ತಲ್ಲ ಹಾಗಿದ್ರೆ. ಅಮ್ಯುನಿಟೀಸ್ ಅಂದ್ರೆ ಅಲ್ಲ, ಇಲ್ಲ ಅಂದ್ರೆ ಇದರಲ್ಲಿ ಅಮ್ಯುನಿಟೀಸ್ 50,000 ಅಂತೇನೋ ಬರ್ಕೊಂಡಿದೆ. ಮ್ಯಾರೇಜ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಬೇರೆ ಕೊಡೋದಾದ್ರೆ ಅಮ್ಯುನಿಟೀಸ್ ಇದು ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ ಅಲ್ವಾ? ದಟ್ ಈಸ್ ಒನ್ ಆಫ್ ದ ಅಮ್ಯುನಿಟಿ ಅಲ್ವಾ? ಅಲ್ಲ, ವಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಅದನ್ನ, ವಿ ಹ್ಯಾವ್ ಆಲ್ ಬಟ್ ಇಸ್ ಫಾರ್ ದಟ್. ಆದ್ರೆ ಅಮ್ಯುನಿಟೀಸ್ ಮತ್ತೆ ನೀವು ಜಾಸ್ತಿ ಮಾಡ್ಬೇಕು ಅಂತ ಇಲ್ಲ. ಅಮ್ಯುನಿಟೀಸ್ ಬಿಕಾಸ್ ಶಿ ವಾಸ್ ನಾಟ್ ಏಬಲ್ ಟು ಡೂ ಹರ್ ರೆಗ್ಯುಲರ್ ವಾಟ್ ಎವರ್ 50,000 ಏನ್ ಮ್ಯಾರೇಜ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಯಾವ್ದೋ ಕೇಸ್ ನೋಡಿ ಅಂತ ಹೇಳಿದ್ವಲ್ಲ ನಾವು. 3 lakhs ಏನೋ ಕೊಟ್ಟಿದಾರಲ್ವಾ ಕಾಜಲ್ ಆಯುಷ್. ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲಿ ಇದು ಮಾಡಿ ಅಲ್ಲಿ ಕಡಿಮೆ ಕೊಡ್ಬೇಕು. ಎಲ್ಲಿ 3 ಲಕ್ಷ ಅಲ್ಲ, ಸಿ ಅಂದ್ರೆ ಇದೇ ಇಟ್ಸ್ ನಾಟ್ ಮೇಕಿಂಗ್ benefit out of this. ಈಗ when this artificial limb was 49 days hospitalization, artificial limb fixation ಆಗಿದ್ದ ಅವಾಗ ಅಂದ್ರೆ ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್ 2014 ಡೇಟ್ ಆಫ್ 2016 ನಲ್ಲಿ ಆರ್ಟಿಫಿಷಿಯಲ್ ಲಿಂಬ್ ಫಿಕ್ಸೇಷನ್ ಆಗಿದೆಯಾ ಅಂದ್ರೆ ಫಾರ್ 2 years. ಅಲ್ಲ ಅಮ್ಯುನಿಟಿ ಅದು ಬರೋದಿಲ್ಲ, ಅದನ್ನ ಕೊಡೋದಿಲ್ಲ. ಅಂದ್ರೆ ಫಾರ್ 2 years ಶಿ ಸಫರ್ಡ್ ದ್ಯಾಟ್ ಅಂತ. ಅದಕ್ಕೆ ಶಿ ವಾಸ್ ಏಜ್ಡ್ ಎಷ್ಟದು 17 years. ಅಂದ್ರೆ ಏನು ಒಂದು ರೆಗ್ಯುಲರ್ ವರ್ಕ್ ಆರ್ ಎನಿ ಗೇಮ್ಸ್ ಸ್ಪೋರ್ಟ್ಸ್ ಏನು ಬರೋದಿಲ್ಲ. 1 lakh ಮಾಡ್ಬೋದು, ಅದನ್ನ 1 lakh ಮಾಡ್ತೀವಿ. ಮ್ಯಾರೇಜ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ 2 lakhs ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ, ಅದು ಅಲ್ಲೇ ಕವರ್ ಆಗುತ್ತೆ. ಸೊ ನೌ ಶಿ ಇಸ್ ನಾಟ್ ಎಂಟೈಟಲ್ ಟು ಎನಿ ರಿಇಂಬರ್ಸ್ಮೆಂಟ್ ಫಾರ್ ದಿಸ್ ಆರ್ಟಿಫಿಷಿಯಲ್ ಲಿಂಬ್. ಇದೆಲ್ಲ ಕೂಡಿಸಿ ಎಷ್ಟಾಗುತ್ತೆ? 20,56,320. 1 lakh ಇಲ್ಲಿದೆ ಕೆಲಸ ಡಿಕ್ಟೇಷನ್ ಕೊಡೋದು. ಯಾವ ಸಾಕೆಟ್?
Change of socket. Future surgery 50,000. ಆಮೇಲೆ change of socket without a right gate 40,000.
ಸಾಕೆಟ್ ಅಂದ್ರೆ ಅದೇನೆ ಪ್ರೊಸೆಸ್ ಚೇಂಜ್ ಮಾಡೋದು ಅಲ್ಲ, ಅದ್ರ ಮೇಲೆ ಸಾಕೆಟ್ ಅದೇನು ಇದು ಮೆಟಲ್ ಅದು ಬರುತ್ತಾ ಅದು ಸಾಕೆಟ್? ಅಲ್ಲ ಅದಕ್ಕೇನೋ ಮೇಲೆ ಫ್ರೇಮ್ ನಂತದ್ದೇನೋ ಹಾಕ್ತಾರೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ, ಅದು ಹೋಲ್ಡ್ ಮಾಡ್ಕೊಳ್ಳೋದು. ಏನ್ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್ 2 set ಕೊಟ್ರಲ್ಲ ನೀವು. There will be a recurring expense of approximately 40,000 annually. Possible requirement of socket change due to unpredicted physiological changes in her body and other maintenance of processes like change of ಕಂಜು. ಅದೇ ಅದಕ್ಕೆ ಹಾಕೊಳ್ಳುವಾಗ ಮತ್ತೆ ಕೆಲವಷ್ಟು ಎಕ್ಸಸರೀಸ್ ಹಾಕ್ತಾರಲ್ಲ ಅದರದ್ದು ಇರ್ಬೇಕಾಗ ಹೋಮ್ ಕಾಸ್ಮೆಸಿಸ್, ಸಸ್ಪೆನ್ಷನ್ ಸ್ಲೀವ್ ಎಟ್ಸೆಟ್ರಾ. ಅಲ್ಲ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಎಲ್ಲ ಅದ್ರಲ್ಲಿ ಚೇಂಜ್ ಆಫ್. ಅಲ್ಲ ಈಗ ದಿಸ್ ವಾಸ್ ಎ ಮ್ಯಾಟರ್ ಆಫ್ 2014 ಸರ್ಜರಿ ಆಗಿದೆ ಅನ್ನೋದಕ್ಕೆ ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಹಾಕಿದ್ದೀರಿ ನೀವು? ಫ್ಯೂಚರ್ ಸರ್ಜರಿ ಕೊಡಿ ನೀವು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ 50,000. ಫ್ಯೂಚರ್ ಸರ್ಜರಿ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀರಿ ಅನ್ನೋದಕ್ಕೆ ಏನಿದೆ ಮೆಟೀರಿಯಲ್? ಮತ್ತೆ ಏನು ಮಾಡಕ್ಕಾಗೋದಿಲ್ಲ. ಇದೇನೋ ಮೇಂಟೆನೆನ್ಸ್ ಇದ್ದು ಅವ್ರು 40,000 ಕೊಟ್ಟಿದ್ದಾರೆ, ವಿಲ್ ಮೇಂಟೈನ್ ದಟ್. ಆಯ್ತು, ಈಗ ಅವ್ರು ಮತ್ತೆ ಅಲವನ್ಸ್ ತಗೊಳಕ್ ಶುರು ಮಾಡ್ತಾರೆ, ಬೇರೆ ಡಿಸಬಿಲಿಟಿ ಅಲವನ್ಸ್. ಅದು ಬರೋದಿಲ್ಲ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಅಷ್ಟೇ. ಇದಕ್ಕೆ ಅಂದ್ರೆ 40,000 ಸೇರಿಸ್ಬೇಕಲ್ಲ. 925 25,65,920 ಆಗುತ್ತೆ. ಟ್ರಿಬ್ಯುನಲ್ ಅವಾರ್ಡ್ ಮಾಡಿದ್ದು ಎಷ್ಟಿದೆ? 22 lakhs ಅಷ್ಟೇ. ಇನ್ನು ಎಷ್ಟಿದೆ ಮ್ಯಾಟರ್ಸ್?
ಇನ್ನೊಂದು ನಂಬರ್ 3 ಪಾಸ್ ಓವರ್ ಇದೆ, ಆಮೇಲೆ ಅಡ್ಮಿಷನ್ ಇದೆ.
ಅಡ್ಮಿಷನ್ ಏನ್ ನಾಳೆ ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ ಟುಮಾರೋ ಫಾರ್ ಡಿಕ್ಟೇಷನ್. ಅದನ್ನ ನೀವು ಅವಾಗ ಪ್ರಾಪರ್ಲಿ ಮಾಡಿಕೊಡಿ. ಇದನ್ನು ಎನಿವೆ ನಾವು ಇದನ್ನ ಮಾಡ್ಕೊಡಿ. ಫರ್ದರ್ ಆಸ್ ರಿಕ್ವೆಸ್ಟೆಡ್. ಅಲ್ಲ ಉಳಿದಿದ್ದಾಗ ಜಾಸ್ತಿನೇ ಮಾಡಿದ್ದೀನಲ್ಲ, 20 lakhs. ಈಗ ಇದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿದ್ರೆ ಟುಮಾರೋ ವಿಲ್ ಡಿಕ್ಟೇಟ್ ದಿಸ್ ಸೇಮ್ ಆರ್ಡರ್. ಟುಮಾರೋ ಮೇಲೆ ಹಾಕ್ಸ್ಬಿಡಿ. ಅಲ್ಲ ಫರ್ದರ್ ನೀವು ನನ್ನ ಮಾಡಿದವರೆಲ್ಲ ಕೊಡ್ತೀನಿ ಅಂದ್ರಲ್ಲ, ಅದಕ್ಕೆ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೋಬೇಕು. ಮೂರು ಬರಲೇ ಇಲ್ಲ.
3 I appear for the respondent.
You were not there in the morning. And the case was heard.
Yes, my lords, I was told Omay sir has argued the matter. I was in the other court, my lords.
He is negligence as well as quantum. Legal manager, Gina Engineering Company.
Yes, my lords.
Whether you will argue now?
I will argue the matter.
Yes. Dictation ಅಂತ ಆಗೋದಿಲ್ಲ ನೀವು ಮಾಡಿದ್ರೆ. Tomorrow we will list it soon after that the other matter.
Yes, my lords.
ಅವರು ಬಂದಿರ್ತಾರೆ ಅಷ್ಟೊತ್ತಿಗೆ. Heard the appellant's counsel as requested by response counsel for further hearing list. ಎರಡಿದಾವಲ್ಲ connected.
Admission. Number 50. N. Siddappa. Madam Paratri.
TCS ಬಂದ್ಬಿಟ್ಟಿದೆ ಅಲ್ಲ. ಏನಿದು? What is the point involved? You have moved it. You are for owner appeal. Siddappa BN Spurti for claimants.
Claimants.
ಎಲ್ಲಿದಾರ?
Appearing.
ಬೆಳಿಗ್ಗೆ ಇರ್ಲಿಲ್ಲ ಅಂತ ಕನ್ಸುತ್ತಲ್ಲ. ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ರು. Case of injury, na? This first appeal is by the owner. Liability is passed. Liability is passed to the insurance on what ground? Sorry, the owner on what ground? ಅಲ್ಲಲ್ಲ, ಓನರ್ ಲಯಬಿಲಿಟಿ ಪಾಸನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಓನರ್ಸ್ ಅಪೀಲ್.
Owner's appeal, my lord.
Compensation amount and deposit received amount. ಅಲ್ಲ ಯಾಕೆ? Why insurer is exonerated?
My lord, there was no insurance for the jeep, my lord.
Insurance. So there was no insurance at all. Then why this insurance branch manager Oriental Insurance Company was implicated?
They are insurance of the car, my lord.
Car. ಇಲ್ಲ, ಅದು ಯಾವುದೋ ಒಂದು ಸಿಂಗಲ್ ಬೆಂಚ್ಗೆ ಹೋಗೋದು. Initially, it was ordered to be placed before the single judge. Then how it came?
My appeal is with respect to my appeal, it is subject matter is 19 lakhs 04,800, my lord. So it was attached to this.
Official list MFA before appropriate means after obtaining the order of so and so ಅಂತ ಆಗಿದೆ.
My appeal subject matter
matters with prostitute consultation admit 2015 is the list for final hearing on 27 sir.
much of this.
Vijay Kumar Paratu.
All right, I am for the respondent number 2. Can it be called tomorrow, my lord? It is compromised, only thing we are. So report ಮಾಡಿದ್ರೆ ತಾವೇ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. 50% ನೆಗ್ಲಿಜೆನ್ಸ್ ಮಾಡಿ ಕಾಂಪನ್ಸೇಷನ್ ಆಸ್ ಇಟ್ ಇಸ್ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡೋದಷ್ಟೇ. ದಟ್ಸ್ ಆಲ್.
ನಿಮಗೆ 70% ಮಾಡಿದಾರಾ?
ಈಗ 50-50 ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡೋದಷ್ಟೇ. ನೋ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್. Whatever the compensation awarded by the tribunal is
have agreed for
just unreasonable.
Correct. Whether I have agreed that you will not seek any enhancement of the compensation? No. Other side counsel was submitting that you have compromised. Only negligence, contributory negligence ratio has to be changed.
ಅಷ್ಟೇ ಬೇರೆ ಇಲ್ಲ.
Enhancement ಮತ್ತೆ ನೀವೇ ಹಾಕ್ಬೋದಿತ್ತಲ್ಲ ಅದನ್ನ ಒಂದು ಮೆಮೊನೆ.
ಅಲ್ಲ, ಸ್ವಲ್ಪ ಅದು ಕಂಪನಿಗಳಿಗೆ ಅಪ್ರೂವಲ್ ತಗೊಳ್ಳೋದು ಸ್ವಲ್ಪ ಇದಾಗುತ್ತೆ. ತಾವು
Hard admit list for final hearing on date. Thank you.
Number 70, Anantramasi.
You connected matter ಅಲ್ಲಿ second set ಹಾಕಿಲ್ವಾ? Officer raised on memo for release of the amount. ಅಷ್ಟೇ ಅದರದ್ದು ಸೆಕೆಂಡ್ ಸೆಟ್ ಹಾಕಿಲ್ಲ. ಅಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ appeal memo along with so and so office objection raised on memo for release of the amount. ಅದರದ್ದು ಸೆಕೆಂಡ್ ಸೆಟ್ ಹಾಕಿಲ್ಲ. That is I think so. ಆಮೇಲೆ 17.2 ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಸೆಟ್ ಆಫ್ ಅಪೀಲ್ ಮೆಮೋ ನಾಟ್ ಫೈಲ್ಡ್ ಅಂತ ಇದೆ. 17.2 ರಾಜಶೇಖರ್.
17.1 and 2 were actually after the objection on memo of release of amount. The acted as well as 16 were. Memo filing period was the RS certificate of 10 and 2 before the circular appoint memo.
ಅಲ್ಲ ರೀ ಇದ್ರಲ್ಲೂ ಸೆಕೆಂಡ್ ಸೆಟ್ ಆಫ್ ಅಪೀಲ್ ಮೆಮೋ 17.1 ಅಲ್ಲಿ ಅವ್ರು ಕೊಡ್ಬೇಕು ಅವೆರಡು ಕೇಸಲ್ಲಿ ದೇ ಹ್ಯಾವ್ ಟು ಸಬ್ಮಿಟ್ ಸೆಕೆಂಡ್ ಸೆಟ್. ನಿಮ್ದು ಅಡ್ಮಿಟ್ ಮಾಡ್ತೀವಿ ಬಿಡಿ. ದಿಸ್ ಇಸ್ ಕೇಸ್ ಆಫ್ ಸೊ ಕ್ಲೇಮೆಂಟ್ಸ್ ಆಫ್ ಚಾಲೆಂಜ್ ಓನ್ಲಿ ಒನ್ ಅವರ್ಡ್. ಅದು ಒಂದು ಚಾಲೆಂಜ್ ಮಾಡಿದಾರ ಇದ್ರಲ್ಲಿ ಫಸ್ಟ್ 17 ಅಲ್ಲಿ 17 ಆಮೇಲೆ 17.3 ಅದರಲ್ಲಿ ಅಡ್ಮಿಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ವಾ? ಬಂದಿದೆ 17 and 17.3 ನಲ್ಲಿ ಅಡ್ಮಿಟ್ ಲಿಸ್ಟ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್. 17.1 and 17.2 ನಲ್ಲಿ at request finally 2 weeks time is granted to the victim failing which the appeal shall stand dismissed. ಅಲ್ಲ ಇದೇನು ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಇದು ಇದೆಯಾ? ವಾಟ್ ಈಸ್ ಫಾರ್ ರಿಲೀಸ್? ಬರೀ ಕ್ವಾಂಟಮ್ ಮೇಲೆ ಅಷ್ಟೇನಾ ರಿಲೀಸ್ ಮಾಡ್ಬೋದಾ ಅಮೌಂಟ್ ಅಲ್ಲಿ? ಅವರು ಅಪೀಲ್ ಮೆಮೊ ನೋಡಿದ್ದೀರಾ ನೀವು? ವಾಟ್ ಇಸ್ ದಟ್ ದೇ ಹ್ಯಾವ್ ಚಾಲೆಂಜ್? ಮತ್ತೆ ಹೇಗೆ ರಿಲೀಸ್ ಮಾಡೋದು? ಆಯ್ತು ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀವಿ ಬೇಕಾದ್ರೆ ಲಿಸ್ಟ್ ಆನ್ ಅಂತ ಡೇಟ್ 30th. ಅದು ಮತ್ತೆ 2 weeks ಆಗೋದಿಲ್ಲ 10 days ಟೈಮ್ ಅಂತ. You submit the second set, otherwise your appeals will be dismissed.
Number 18, B. Chandrachuda.
Case of? You are only on quantum or? You are only on the quantum issue or any, what is that? Quantum, yaar other side appear agada Rashik. Notice hogilwa illa. Yadu Mrs. United India Insurance Company. Yaru Hegde mulkundu matte yaru idare? Iವರು ಶಿವನೇಗೌಡನೇ ಇದ್ದಾರೆ ನಮ್ಮ ಶ್ರೀ BC ಶಿವನೇಗೌಡ ಲಾಯರ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕರೆಸ್ಪಾಂಡೆಂಟ್. ಯಾರು ಲೇಡೀಸ್ ಇಲ್ವೇ ಇಲ್ಲ ಏನ್ರಿ? ಯಾರು ಮಂಜುಳತಿ ಇದ್ರ ಇಲ್ಲೇ ಬರ್ಕೊಳ್ಳಿ ಒಂಚೂರು ವುಮೆನ್ ಎಂಪವರ್ಮೆಂಟ್ ಮಾಡೋಣ. ಶ್ರೀಮತಿ ಮಂಜುಳಾ ತೇಜಸ್ವಿ ಲಾಯರ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ರಿಕ್ವೆಸ್ಟ್ ಟು ಆಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್ ಕರೆಸ್ಪಾಂಡೆಂಟ್ ಮತ್ತು ಇದ್ದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. ವಾಟ್ ಅಬೌಟ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1? ಮೆಮೊ ಫೈಲ್ ಮಾಡಿ. ಹಾಗಾದ್ರೆ ಅದನ್ನ ನಾವೇನು ಹೇಳ್ಬೇಕಾ? ಎಕ್ಸ್ಪರ್ಟ್ ಇದ್ರೆ ಅವರು ಎಕ್ಸ್ಪರ್ಟ್ ಅಂತ ಇದೆಯಲ್ಲ, ಮೆಮೊ ಫೈಲ್ ಮಾಡಿ. ನಾನು ಕೌನ್ಸಿಲ್ ಫಾರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸಬ್ಮಿಟ್ ಮೆಮೊ ಫಾರ್ ಇವತ್ತೇ ಕೊಟ್ಬಿಡಿ. ಈಗ dispensation of notice to respond number 1. Respond number 1 had not contested the matter before the tribunal, therefore notice to respond number 1 is dispensed as paid for. ಇದರಲ್ಲಿ ಏನು ರೆಕಾರ್ಡ್ಸ್ ಏನು ಬೇಕಾಗುತ್ತೆ? Admit, call for TCRs, list after the receipt of TCRs.
Number 19, Harish Bandari. ಇದ್ರಲ್ಲಿ ಕ್ಲೇಮೆಂಟ್ ಗಾರು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಲ್ಲ, ಪೇಮೆಂಟ್ಸ್ ಏನು ಬಂದಾಗ ಹೇಳಿ. ನ್ಯೂ ಇಂಡಿಯಾ ಅಶ್ಯೂರೆನ್ಸ್ ಕಂಪನಿ ಶ್ರೀಮತಿ ಗೀತಾ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಇಸ್ ರಿಕ್ವೆಸ್ಟ್ ಇದಾರ. ಯಾರೋ ಒಬ್ರು ಕೊಟ್ಟು ಯಾಕೋ ಇತ್ತೀಚೆಗೆ ಇಲ್ಲಿ ಬರ್ತಾ ಇಲ್ಲಲ್ಲ ತೇಜಸ್ವಿ. ಆಯ್ತು, ಯಾರು ಮಂಜುಳಾ ತೇಜಸ್ವಿ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ಅಲ್ಲ, ನಮ್ಗೆ ಬರ್ಬೇಕು ಇಲ್ಲಿ. ಅದಕ್ಕೆ ಗೀತಾ ಶ್ರೀಕಾಂತ್ ರೆಗ್ಯುಲರ್ ರಿಕ್ವೆಸ್ಟ್ ಟು ಆಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಅದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. ಆಮೇಲೆ ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ 2 to 8. ಇದರಲ್ಲಿ ಹರೀಶ್ ಭಂಡಾರಿ ಅವ್ರದ್ದು ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅವರೆಲ್ಲ ಇದೆ ಅಲ್ವಾ?
ಲಿಸ್ಟ್ ಅವ್ರು ಬರ್ದೇನೆ ನಾವು ಎಕ್ಸಿಟ್ ಮಾಡೋದು ಹಿಂಗೆ ಲಿಸ್ಟ್ ಆನ್ ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ರಿ.
Number 20, Shivaprasad M. Vintage Kamath, Karatu.
Coordinate bench. Where is that MFA? It is submitted that this matter is connected to MFA number so and so. List both the matters together on date. Number together on 28. ಬರ್ಲಿ ಅದ್ರಲ್ಲಿ ಯಾರು ಹಾಕಿರ್ತಾರೆ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ತಗೊಳಕ್ ಡೈರೆಕ್ಷನ್ ಕೊಡೋಣ. ಅಲ್ಲ ಅದು ಲಿಸ್ಟ್ ಆಗ್ಲಿ ಎರಡೂನು ಯಾರು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಅಡ್ವೊಕೇಟ್ ಇರ್ತಾರೆ ಅವ್ರಿಗೆ ಕೊಟ್ಟು ಆಮೇಲೆ ದೆನ್ ವಿಲ್ ಇಶ್ಯೂ ನೋಟಿಸ್. ವಿ ಆರ್ ಗೋಯಿಂಗ್ ಟು ಯಾವತ್ತು ಹೇಳಿದ್ರಿ ಡೇಟ್ 28/6. ಅದ್ರ ಜೊತೆಗೆ ಅದು ಲಿಸ್ಟ್ ಆಗ್ಲಿ ಅವಾಗ ಯಾವ ಅಡ್ವೊಕೇಟ್ ಅದಕ್ಕೆ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಅವ್ರಿಗೆ ಕೊಡೋದಕ್ಕೆ ಬರುತ್ತೆ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ. ಬರೀ ಅದು ಎರಡಕ್ಕೂ ನೋಟಿಸ್ ಕೊಡೋದಕ್ಕೆ. ಅಂಡ್ ಇಫ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 has not contested, you can seek dispensation of notice to them. Correct ರೀ, ಕಾಂಟೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಲಯಬಿಲಿಟಿ ಯಾರಿಗೆ ಫಾಸನ್ ಮಾಡಿದ್ದಾರೆ? ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಅವರು ಇದ್ದಾರೆ. ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಹ್ಯಾಸ್ ಆಲ್ಸೋ. ಆಯ್ತು ಡೇಟ್ ಲಿಸ್ಟ್ ಮಾಡಿ. ನೀವೇ ಹೇಳಿದ್ರಿ ಈಗ ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಅಪೀಲ್ ಇದೆ, ಅದು ಆಲ್ರೆಡಿ ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಅಂತ. ಅದಕ್ಕೆ ಮುಂದಿನ ವಾರದಲ್ಲಿ ಡೇಟ್ ಹೇಳಿ.
27/6.
27/6.
Number 21, DC Sitaram Rao, Rajshekar K. for R1.
You have filed or they have filed? This is insurance appeal. You have filed appeal. Claimants number kodi. It is sorry, counsel for respondent. Respondent submits that this matter is connected to MFA number so and so. ಇದರಲ್ಲಿ ಯಾರೋ ಡಿವಿಷನಲ್ ಕಂಟ್ರೋಲರ್ KSRTC ಇದಾರಲ್ಲ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಡೋಣ. ಅದ್ರಲ್ಲಿ ಯಾರೋ ತಗೊಂಡಿದ್ರೆ ನೋಡೋಣ ಎರಡು ಒಟ್ಟಿಗೆ. ಲಿಸ್ಟ್ ಆನ್ ಲಿಸ್ಟ್ ಬೋತ್ ಮ್ಯಾಟರ್ಸ್ ಟುಗೆದರ್ ಆನ್ 30th.
Number 22, A. Krishnaswamy.
ಯಾವಾಗ್ಲೂ ಇರೋರಲ್ಲ. Alliance. 3,05,000. Transport vehicle, no endorsement. Difference between unladen weight and gross weight. Breach of policy condition. Admit call for TCS, issue notice to the respondents. List on 27.
Number 23, D. Manjunath.
Hmm. 57, 54 years now, married sisters. So they were dependents. 26,88,000 kotiದ್ದಾರೆ. Whether anything was produced to show that he was living with these people? Aadhaar card alla, ration card antade ಏನದೆ. Aadhaar card of the deceased they have produced. Whether that shows he was ration card ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ sheet one. ಅದರಲ್ಲಿ ಇವ್ರ ಜೊತೆಗೆ ಕರೆಕ್ಟ್ ಇವ್ರ ಜೊತೆಗೆ ವಾಸ ಇದ್ರು ಅಂತ ಇದೆಯಾ ಅದರಲ್ಲಿ ರೇಷನ್? Oh, lady na tirado. She was married. How much is awarded now? So heard it. Heard admit issue notice to the admit call for TCS, issue notice to the respondents, interim stay of the execution of the impugned award. Subject to the appellant depositing, yes, deposit for 50% of the award amount before the tribunal within 4 weeks from the date of the receipt of the copy of this order. I have one of the 23 is disposed of accordingly.
Bill number 24, Vinod Gowda,
And notice on the one date list on
18.
1.
Bill number 24,
minor case injury case. Insurer manager United India Insurance Company. Iವರು ಇದ್ದಂಗಿಲ್ಲ ಇವರು ಇದ್ದಾರೆ ಆದ್ರೆ ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್ ಬೇಡ ಅಂತಾರೆ ವಿಜಯ್ ಕುಮಾರ್ ಈ ತರ ಶ್ರೀಮತಿ ಗೀತಾ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕರೆಸ್ಪಾಂಡ್ ಪ್ಲೀಸ್ ಡೈರೆಕ್ಟ್ ರಿಕ್ವೆಸ್ಟ್ ಟು accept notice for respondent number 3. ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡ್ ಮಾಡೋ ರೆಕಾರ್ಡ್ಸ್ ತರಿಸ್ಕೋಬೇಕಾಗತ್ತೆ admit all parties here issue notice to response 1 and 2 list on
18. Bill number 35, Prakash HD,
ಎರಡು ಅವ್ರಿಗೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಹಾಕಿದ್ದಾರೆ ಡಿವಿಷನಲ್ ಮ್ಯಾನೇಜರ್ ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್ ಇದರಲ್ಲ ಯಾರಿದ್ದಾರೆ ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್
ಜ್ವಾಲಾ ಕುಮಾರ್ ಅಂತಿದ್ದಾರೆ ಕೊಡಿ.
ಶಿವನೇಗೌಡ ರೆಗ್ಯುಲರ್ ಆಗಿ ಬರ್ತಾರಲ್ಲ ಶಿವನೇಗೌಡ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕರೆಸ್ಪಾಂಡ್ ಇಸ್ ರಿಕ್ವೆಸ್ಟ್ ಟು accept notice for respond number 2 ಉಳಿದಿದ್ದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಕಾಂಟೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲಿ ಅಂದ್ರೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಮೆಮೊ ಹಾಕೊಂಡಿದ್ದಾರೆ. File is reduced to 5 times. Under the impugned award, the liability is fastened to records show that under the impugned award, liability is fastened to respondent number to the insurer. Therefore, notice to respond number 1 is dispensed with as paid for. Admit call for TCRC. List down.
78.
7.
Bill number 26, Prakash HD,
Insurance company. ತಹಸೀಲ್ದಾರ್ KGID ಇದ್ರೊಳಗೆ ಇವ್ರಿಗೆ ಕೊಡ್ಬೇಕಾಗತ್ತೆ ನೋಟಿಸ್ XCVP. XCVP is requested to accept notice for response 1 and 2. The appearance council shall serve copies on the ಅವ್ರಿಗೆಲ್ಲ ಸರ್ವ್ ಮಾಡಿದ್ಮೇಲೆ ತಗೊಳ್ಳಲ್ಲ ಇದನ್ನ
SPP ಬರಲ್ಲ AG ಬರುತ್ತೆ.
HCGP. ಹೇಳ್ತಾನೆ ನಾವೇನ್ ಹೇಳೋದು ಇವ್ರೇನಂದ ಕ್ವಾಂಟಮ್ ಇದಾರೆ ಕ್ವಾಂಟಮ್ admit call for TCR. List of the receipt for TCR. ಎರಡರಲ್ಲ ಅದರಲ್ಲಿ ಸೇಮ್ ಅಲ್ಲ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಬರೋದಿಲ್ಲ. SCVP ಇದ್ದಾಗ ಯಾಕೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಮಾಡಬೇಕು? ಏನದು ಮೆಮೊ ಫಾರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಡಿಸ್ಪೆನ್ಸ್ ಆಫ್ ಅಕಾರ್ಡಿಂಗ್ಲಿ ಅಂತ ಬರ್ತಾರೆ SCP. ಇದೇನು ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಇರೋವಾಗ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಯಾಕೆ ಕೊಡ್ತಾರೆ? ಬೇರೆ ಏನಾರ ಇದೆ Yeah. ಬೇರೆ ಅದು